CRP was filed by me. Here afterwards, your lordship converted this. There was some urgency.
GMCPC ಆಗಿದೆ.
How even 60
Friday ಕೊಡಿ. Friday.
One matter filed in March. Several
Next week. Monday.
80-year-old.
Monday. ತೊಂದ್ರೆ ಇಲ್ಲ. Monday.
My lord, in this,
General award ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
my lord, it is truth I'm not, the public action is scheduled to be held tomorrow,
2:30.
2:30.
May I please? Bill number 73.
Adjournment ಇಲ್ಲ.
Yesterday I moved a memo. Today's the date given, but matter is not listed, my lord.
Next week.
2:30 because my
Why?
matter is pending since 1951, my lord.
Urgency ಏನ್ sir?
It is a partition suit, my lord.
ಅದಕ್ಕೆ?
1950, it is pending since
2:30 ಯಾಕೆ?
seeking a direction my to
Disposal. Friday ಬರ್ಲಿ ಕೊಡಿ. ಅದು 2:30 ಏನಿದೆ?
Submission, my lord.
ಇಲ್ಲ ಸುಮ್ಮನೆ urgency
On
project.
submission.
Heavens are going to fall.
in date given.
Then ನೆನ್ನೆ date given. Friday ಹಾಕಿ ಅದು.
On submission, my lord. Yeah, I mean, position last 20-30 years.
Right,
my
sir.
lord.
Lordship, the KIDB matter, I moved the memo, but it's been lost listed. There's an urgency, kindly have this matter.
ಏನ್
2:30.
urgency?
But I'll disperse the amount, compensation amount. Your Lordship.
ಕೊಡಿ ನಾಳೆ ಹಾಕಿ.
My lord,
Okay,
direction to.
My lordship, 2:30, my lordship.
What?
Let up
ಅದೇ advocate ದಾ?
My lordship.
ಎಲ್ಲಿ ಅವಿನ ರೋಡ್ ನಾನು ನಿಮ್ದ್ರಲ್ಲಂತೂ ಏನು ಶೆಡ್ಯೂಲ್ ಇರಲ್ಲ. I will not grant stay at all in that.
Schedule is there.
I am
One
not
portion
going
of
to grant stay. ಕೊಡಿ. ನಾನು ಸ್ಟೇ ಕೊಡೋದೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Kindly see.
No. 10 years ಇಂದ ಆಗಿರೋ ಡಿಗ್ರಿನ ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತೆಲ್ಲ ಹೇಳಿ ಅದ್ರಲ್ಲಿ ಏನ್ ಯಾವ ಪೆಟಿಷನ್ ಶೆಡ್ಯೂಲ್ಗೆ ನಿಮಗೆ ಸಂಬಂಧನೇ ಇಲ್ಲ. No. Don't do all this. Just because we show indulgence. I will not grant stay in that today. List that tomorrow, not 2:30.
My submission, my lord.
Execution matter was stayed, subject to Supreme Court, they're getting stay from Supreme Court.
ಅದೇನಾಯ್ತು?
Yesterday it was listed at 140, it did not reach.
ಎಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲ?
Supreme Court stay was not granted.
ಹಾ.
Yesterday.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಿದ್ರಾ?
Who ಮಾಡಿದ್ರು? Supreme Court did not grant the stay. Yesterday it was listed 140.
ನಾಳೆ ತಗೊಳ್ಳಿ.
On submission, my lord.
15 days.
Fresh matter,
2:30, my lord.
Next week.
On submission.
2:30.
Why sir 2:30?
15 days time ಕೊಟ್ಟಿದ್ದಾರೆ. If not, amount will be, confiscated also.
ಕೊಡಿ ಆಯ್ತು 2:30 ತಗೊಳ್ಳಿ.
On submission, my lord.
ಮೇಡಮ್ ಅವರು 2:30 ತಗೊಳ್ಳಿ.
Submission, my lord.
ಹೇಳಿ.
There is one.
Yes.
I am in position last 30.
Yes. ಮೆಮೋಗಳು ಕೊಟ್ಬಿಡಿ ಸರ್. ಯಾವ್ದು 2:30 ಗಿಲ್ಲ ಕೊಡಿ. Give all the memos. Let it be, sir. Give it. Give it, sir. Monday. Let it be. Give it Monday. ಬೇಡವಾ ಮೆಮೋ? ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಎವಿಡೆನ್ಸ್ ಇದ್ದಾಗ 617 ಹಾಕಿದ್ದೀರಾ? You think I'll interfere? No. Give it, sir. No problem.
No, dependents, my lord, they have not got to the court notice. Those things I have said to the trial court. And my lord, without.
Monday it will come. Give it. If I continue on Monday, it will come. Yes. No, sir.
Lords, it's a fresh matter. We have challenged the
Give it,
acquisition
sir.
proceedings.
Give it.
My lords, the urgency is there is a threat of disposition.
Hard disposition. Acquisition proceedings ಯಾವಾಗಿಂದು?
2024.
ಸುಮ್ಮನೆ ಇವೆಲ್ಲ ಹೇಳ್ಬೇಡಿ. ಕೊಡಿ.
My lords, it may be taken up
Give
on
it.
Thursday.
Thursday. Yes.
Please.
Why?
Great.
Sorry? Why? Correct. No problems. Friday. Yes. ಏನಾಗಲ್ಲ ಕೊಡಿ.
Request for
Third next week, sir. Next week. Third time ನೀವು ಟೈಮ್ ಹೇಳಿದ್ರೆ 3rd 10th ಅಂತಲ್ಲ next week ತಗೊಳ್ಳೋದು ನಾನು.
One submission.
Because I can't help it.
One
I
submission,
can't
my
take 500 matters.
One submission, my lord.
Right? Everybody have urgency.
One submission, my lord.
You will wait, please. Kodi, next week.
No, sir. No, sir.
Give it, sir. Give it. CRP Thursday kodi.
No, sir.
Monday. Only Monday. Yes. ನಿಮ್ದು ಏನು urgency ಇರಲ್ಲ Monday.
ಎಕ್ಸ್ಪರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡು ಇಂಜೆಕ್ಷನ್ ನಾನು ಪ್ರೊಫೆಷನಲ್ ಇದೀನಿ. ಎಕ್ಸ್ಪರ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಟ್ಟು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಟ್ರೈಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದು ಕೂಡ ಹಾರ್ಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು.
39 ಅದನ್ನ ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ ಆರ್ಡರ್ ಮಾಡಕ್. ನಾನೇನು ಕೊಡಲ್ಲ ಇಲ್ಲಿ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇಲ್ಲ.
2:30 ಇಂದ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಆಯ್ತಲ್ವಾ ಕೊಡಿ. ಹಾ.
My lord, CRP, my lord, year 2020.
CRP give it, sir.
My lord, kindly tomorrow, my lord.
No, not tomorrow, sir. CRP.
After.
It will come on CRP day, that is Thursday. Yes, sir. ಹೇಳಿ ಈಗ.
One submission. The trial court is posted for the orders, my lord. I am enjoying.
When?
Monday, 28th, my lord.
Sorry.
Because we have lost the trial, we were 20 years in, we are staying, position in the engine position.
Friday.
Suspend Friday, accommodate me
Friday.
Friday, please.
Seeking for speedy disposal of the appeal. 8-year-old appeal.
ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಎಲ್ಲ ಕೊಡಿ.
Lords, this is a criminal petition before your lordships. The criminal petition before your lordships, the main.
Writ of mandamus, my lord.
Give it, sir.
My lord, writ of,
Give it.
The
My
matter
lord,
has
writ
been
of,
posted for final argument tomorrow, my lord.
Maybe.
My
Just
lord,
on Monday.
my lord,
What were you doing till now?
my lord, writ of mandamus.
Monday ನೇ ಅದು,
ಇದೆ.
not.
Yes.
Oh, yes, yes.
Writ of mandamus ಇದೆ, my lord.
Next week.
my lord, ನಮ್
Next
site ಅಲ್ಲಿ
week, next
ಮನೆ
week.
ಕಟ್ಕೊಂಡು ಕೋರ್ಟ್ ಆರ್ಡರ್
Next
ತಮ್ಮರಿ ನಾವು
week,
ಬಿಡಲ್ಲ.
yes.
Lord, 3 IAS are pending from 2020, my lord. Somewhere around 52.
Friday. To adjournment.
CMCPC, my lord.
Monday.
My lord, one more
No, sir,
memo is-
Monday.
My lord, I have one more memo on the same similar matter, my lord. From 20
Disposal?
Yes,
Give it. Yes.
on earlier.
Fresh matter, GMCPC.
Give it, sir. Give all the memos.
Yeah.
Give all the memos, sir. Give the memo.
Monday.
Give the memo, sir. If you want, give the memo or don't give the memo. I can't request you to give the memo.
My lord, this is 10-year-old matter, my
No
lord.
problem,
Here the
give it.
issue is only about
RP,
who
my
to start the evidence, my lord.
Give it, madam.
Any date, my lord,
No,
because
yes. It's a
even
pending
previ-
matter, no dates, yes.
My lord, we even previously have posted a
madam.
memo. It is
Yes.
coming on seniority,
No,
my lord.
pending matters, no, yes.
Fresh matter, my lord. I filed an application.
Monday, give it. Adu Monday, give it. ಏನ್ ತೊಂದ್ರೆ ಆಗಲ್ಲ ಕೊಡಿ ಮಂಡೇ ಸರ್. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬೇರೆ ಕಡೆ ಸ್ಟೇ ತಗೊಳ್ಳಿ, ಹಾ ಸರ್. ಅಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬಗ್ಗೆ ಮಾತಾಡೋದಿದ್ರೆ ಬೇರೆ ಕಡೆ ಹೋಗಿ, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಮಂಡೇ ಸರ್, ಮಂಡೇ GMCPC ಅಲ್ವಾ? ಮಂಡೇ
One LABDA matter.
ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇರಲ್ಲ ನಿಮ್ದ್ರಲ್ಲಿ, ಗೊತ್ತು ನನಗೆ. ಕೊಡಿ,
One LABDA matter,
ಕೊಡಿ.
pending matter.
My lord, CRP for tomorrow, my lord.
They are Thursday. Pending matter, criminal petition, Friday. Successive petitions Friday. Yes, call the cases. Adjournment ಏನು?
1 week adjournment, serial number
ಆಮೇಲೆ
20.
ರೀಚ್ ಆದಾಗ ಹೇಳಿ.
Please.
ದಿನ ಹೇಳ್ಬೇಕಾ ಅದನ್ನ? ಎಸ್. ಎಸ್, ಸಂತೋಷ್ ನಾಗರಾಳ ಏನಿದೆ?
Yes, lord.
ಲಿಬರ್ಟಿ ಕೇಳ್ತೀವಿ ವಿಡ್ರಾ ಆಗಿದೆ, ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ ಲಾರ್ಡ್ ಸರ್ಟಿಫೈ.
ಲಿಬರ್ಟಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತ?
ವಿಡ್ರಾ ಮಾಡಿದೆ.
ಮೆಮೋ ಎಲ್ಲಿದೆ?
ಮೆಮೋ ಆಲ್ಸೋ ಪ್ಲೇಸ್
ಇನ್ ದಿ ಲೈಟ್ ಆಫ್ ದಿ ಸೆಡ್ ಮೆಮೋ ಹಾಕಿದ್ರಲ್ವಾ?
ಮೆಮೋ
ಮೆಮೋ
ಹಾಕಿದೆ.
ಏನ್ ಕೇಳಿದ್ರಿ?
ವಿಡ್ರಾ ಲಿಬರ್ಟಿ ಕೇಳಿದೆ.
ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋನೇ ಮಾಡಿರೋದು, ಮತ್ತೇನ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್, ನೋ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್.
ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ ಫ್ರೆಶ್.
ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೋ ಅಂದ್ರೆ ಏನರ್ಥ? ಮೆಮೋ ಲಿಬರ್ಟಿ ಕೇಳಿದ್ರಾ?
ಕೇಳಿದೆ.
ಎಸ್, ನೆಕ್ಸ್ಟ್.
Order seal number 2.
311, my lord. For the respondent number 2 in this one. ನಿನ್ನೆ ನಾನು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ರೋಷನ್ MC. Copy has not yet been received.
Learned counsel so and so submits that is entered appearance for the respondent complainant. Registry to print the name of so and so as appearing for the respondent complainant. List the matter on next Friday haki. List the matter on 1st August interim order subsisting.
ಇಲ್ಲ 30ನೇ ತಾರೀಕು ಮ್ಯಾಟರ್ ಇದೆ. ಬಿಫೋರ್ ದಟ್ ಟುಮಾರೋ ಆದ್ರೂ I'll
30ನೇ ತಾರೀಕು ಏನ್ ಮ್ಯಾಟರ್ ಇದೆ?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. The matter has been posted for argument since.
ಏನು ಪೋಕ್ಸೋನಾ?
ಹೋಗ್ಸೋದು
ಸೆಟಲ್ಮೆಂಟ್
ಇಲ್ಲ
ಮತ್ತೆ?
311 application.
311 application.
E11 application will dispose it then.
with a condition that
that
there will be no further.
ಎಷ್ಟನೇ ಸರ್ತಿ ಇದು?
It was
Second
third
time.
Huh?
Second time. First time it
Whom
was
do you
for
want to examine?
myself, my lord.
Yourself.
Myself for to clarify.
yes.
The petitioner is before this court calling in question an order dated 14/3/2025 passed by the concerned court in special case 571 of 2023 whereby you are the victim, huh?
Yes, ma'am.
Whereby the petitioner, how old are you? 21 years. Whereby the application filed by the victim to examine herself has been declined. The facts, her sons. A complaint comes to be registered on 1/12/2022 in crime number 9 of 2020, in crime number 9 of 2023 after it is transferred to Rajajinagar police station for several offences including the offences under the POCSO Act. The police after investigation have filed a charge sheet and the matter is pending before the concerned court as special case number so and so. The issue in the list is not with regard to the merit of the matter. The petitioner victim files an application seeking further examination of herself in under section 311 of the CRPC. The concerned court rejects the petition, rejects the application on the score that the matter requires disposal. ಏನಕ್ಕೆ ಕೊಟ್- ಮಾಡೋದು?
ಈಗ ರಿಪ್ಲೈ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದೆ.
ಅಲ್ಲ. Restraint, where is that? Page victim, sorry, ಇದು.
The application, Milord.
ಅಲ್ಲ, order, impugned order.
Milord, impugned order is at 82, Milord. Page number 82.
On several grounds, including the one that the petitioner victim has already examined herself and there is no question of for permitting further examination. The counsel for the accused and the state would in unison submit that one opportunity be given, but that should not become the ruse to drag the proceedings. On the said date, if a direction is rendered to conclude the examination, they would have no objection for allowing the application. In that light, I deem it appropriate to set aside the order impugned and direct the concerned court to, ಯಾವತ್ತಿದೆ next? Direct the concerned court to permit further examination of the victim with the condition that the victim should conclude her examination on the said day itself. It is made clear no further opportunity of the kind that is now sought would be granted to the victim to examine herself. It is open to the concerned court to regulate its procedure thereafter. For the aforesaid reasons, following order allowed, quashed. The application filed by the petitioner stands allowed. The victim petitioner shall complete her further examination on the 30th of July 2025. It is made clear no further adjournment should be granted on the matter on the score of examination, and this would be the last straw of opportunity to the petitioner. Ordered according.
Great.
Yes.
Number 3,
Memo for withdrawal
4,
in terms of memo.
For the petitioner, madam.
Signature of petitioner as
No,
Deepu.
actually, her name is Deepu alias Dhanlakshmi.
Alias.
She has signed as
Deepu-
Dhanlakshmi anta sign ಮಾಡಿದ್ದೆ.
Deepu alias Dhanlakshmina.
Dhanlakshmi anta sign ಮಾಡಿದ್ದೆ. That office objections has been raised.
So office objections overruled.
It may be
ಏನು
posted
CRP
for,
ನಾ?
ಇಲ್ಲ
CRP na?
CRP, 7 rule 11. Earlier,
Notice. Yes.
another suit was filed.
Notice.
Stay, evidence is going on. madam.
ಹಾಗಾದ್ರೆ ಲಿಸ್ಟ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ಟೈಮ್ ಅಲ್ಲಿ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲ ಮುಂಚೆನೆ ಹಾಕಿದ್ದೆ.
ಲಿಸ್ಟ್ ಆನ್ ಥರ್ಸ್ಡೇ,
Please.
ಥರ್ಸ್ಡೇ ಇಲ್ಲ, ಫ್ರೈಡೇ in admission. Non-compliance of office objections.
5,
Review petition. Why?
ಅದ್ರಲ್ಲಿ-
I am very conscious about what I have written. Only 2 I have allowed and not the rest.
May I just show you something? I normally would never come to your lordship as the review petition. But please see para 13 at page 36.
ಅದೆಲ್ಲ ಅಲೋ ಮಾಡ್ಬೇಕು ಅಂತ ಬರ್ದಿದ್ದೀರಾ?
ಅಲ್ಲ ಅದೊಂದು
ಹಾ.
just before that note, I just want to show one sentence.
ಹಾ.
There seems to be a little confusion there. Other inclusion that is sought is whether there was novation of agreement. Novation of the agreement, the plaintiff's project is defendant one entering into an agreement to sale with the plaintiffs and again entering into a sale deal with D2 and D3. That's not what we have said. There's a supplementary agreement entered into after our agreement to sell, which is the novation. Lord, there was
They serve on the other side. They heard the learned senior counsel, Dhyan Chinappa, appearing for the petitioner. The learned senior counsel projects certain obfuscation with regard to the observations at paragraph 13, which may require a review to that limited extent.
only that.
The counsel shall serve on the counsel who represented the respondent before respondent in the original proceeding. List on Friday ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Yes,
List on 25th.
yes.
That's the only thing we'll do. Ready ಆಗಲ್ವಾ?
till number 6,
Just filing the recall application.
Withdrawn.
Recalling application. That's a cost matter, my lord. Yesterday it was like this.
ಇವತ್ತು ಬಂದ್ರಿ. ಈಗ ಟು ಬಿ ಪೇಡ್ ಬೈ ದ ಕೌನ್ಸಿಲ್ ಅಂತ ಮಾಡ್ತೀನಿ, ಕಾಸ್ಟ್ 10,000 ರೂಪಾಯಿ. Will recall it.
Please.
Is in the wheelchair, 1 lakh.
I understand.
Why you did not tell the court earlier bench?
Petition is pending, writ appeal is
ಅಲ್ಲ ಆಯ್ತು, earlier bench ಗೆ ಯಾಕೆ
So
ಹೇಳಿಲ್ಲ?
they were not appeared. None was represented.
This court, the coordinate bench of this court had, while disposing the petition, imposed a cost of rupees 1 lakh payable by the petitioner to the Karnataka State Legal Service Authority. The cost was not paid, therefore a warrant was issued and the petitioner therein was brought before the court. And looking at the condition of the petitioner who comes in a wheelchair before this court, the non-bailable warrant that was issued stood suspended. Subsequent to the same, an order on 10/6/2025, this court had passed an order on 10/6/2025. It was observed that the petitioner is on a wheelchair and is 92 years old and the sole petitioner challenging the acquisition proceedings. Though the reason rendered in the application, affidavit accompanying the application is far from being satisfactory, the condition of the petitioner, and the state sheets, idella sponsored litigation. Avaru kodtare budi.
Yes.
Yeah, ನೀವೇನ್ ಮಾಡಿರಲ್ಲ ಅದು. Everything is
my
land
lord,
acquisition, ಎಲ್ಲ sponsored litigation.
In that, the Lokaita court also pending is that they give the complaint also.
Sorry. Yes, so and so. In the light of the observation made on 10/6/2025, in the peculiar facts of the case as a one-off situation to a one-off problem, I deem it appropriate to allow the application and recall the order imposing costs of rupees 1 lakh. All the other conditions stipulated shall remain as it is. Yes. Mic on ಮಾಡಿ sir. Switch on your mic.
Sorry, my lord, if they don't deposit 1 lakh cost, 500 would be added every day. That can be also.
The entire order is gone. Cost and the other consequences of non-payment of costs stands recalled.
Please, comply.
ಇದನ್ನ ಹಾಕಕ್ಕೆ ಹೇಳಿ 5 ಸರಿ ಆಯ್ತು ಹಾಕಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
7.
This is a 2014 writ petition, my lord, which was filed by my father.
ಏನಿದೆಲ್ಲ?
ಅದೇ ಅದೇನಾಗಿದೆ 37/2024 it was dismissed for non-prosecution. The writ petition was filed by my father challenging the preliminary notification. Stay of interim order of stay was granted. Thereafter, my lord, my father passes away. My lord, I did not know the lawyer here in Bangalore.
Recalling ಹಾಕಿದ್ದೀರಾ?
Recalling.
For the reasons so and so recalled. Interim order, if subsisting at the time of dismissal of the petition, would stand restored. Yes.
I filed other applications also, my lord, bringing LRs on record. That may be considered.
Respondent ಯಾರಿದ್ದಾರೆ?
Respondent state as.
State will allow. ಎಲ್ಲಾನು allow ಮಾಡಿ. For the reasons indicated in the affidavit.
To file amended.
Petitioner to file amended cost title forthwith. In other dismiss ಮಾಡಿಸ್ಕೋಬೇಡಿ. ಈಗಲೇ ಅದು forthwith ಬೇಡ, on 2 weeks ಕೊಡಿ. In the next 2 weeks.
8.
And for the impleading applicant, it's minutes, I appear to the petitioner's minutes. Property belongs to the.
One minute, Ejake. ಇದರಲ್ಲಿ continuation of delay, ಆಮೇಲೆ other objections. Quay the applications overruled ಅಂತ ಮಾಡಿ.
This matter,
Rectification of office objections.
the impleading application filed by me, the property belongs to Hallagere Village Panchayat. The petitioner
Any
herein.
objection?
I'll file my objections, my lords.
To the impleading application.
Please, my lords.
Learned counsel for the petitioner seeks a week's time to file his objections to IA 1 of 2025, filed for impleading the proposed respondent. Objections, if any, by the next date. List the matter on 5th August.
Much grateful.
Yes, next.
9.
The petitioner. Both these matters, my lord,
What is this, Clifton?
identical questions are there in both questions.
No, they are rectification of amended WP. Why don't you comply with all the, ಎಲ್ಲ ಈ stage ಅಲ್ಲಿ ಬಂದ್ರೆ impossible. You should comply with everything.
I apologize, but I was.
And then file it, forget it, Allah. You should go and see.
That's not the case at all.
Not that, in general, I'm telling, ಯಾರು objections comply ಮಾಡಲ್ಲ.
I'll just check that.
Yes, Pradeep, ಏನಿದೆ?
Lord, connected case, my lord, I am appealing. ಒಂದು ವಾರ ಟೈಮ್
Objection ಹಾಕಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ.
ಒಂದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ ಇನ್ನು.
ಫಸ್ಟ್ ಒನ್ ಹಾಕಿದ್ದಾರೆ.
24 ರಲ್ಲಿ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ.
Same, 5th August, the learned counsel for the petitioner to comply with the office objections by office objections be complied with by the next date. The counsel Shri Pradeep Kumar seeks 10 days time to file a statement of objections in 9.1. Objections, if any, by the next date.
Interim order is
List on 12th August. Interim order subsisting will continue to the next date of hearing. Post in B group.
Please, an apology, my lord.
Generally, I will not to you.
Allah, but of course, I am appearing, my lord, I have to
Yes.
apologize.
10 withdrawal.
10, 11,
Appeal ಹಾಕ್ಬೇಕು.
ಇದರಲ್ಲಿ ಅಡ್ಜುಡಿಕೇಶನ್ ಆಗಿಲ್ಲ.
2197 application.
ಹೌದು, adjudication
2197 ಅಂದ್ರೆ ಅದು it's a order by
ಅಲ್ಲ,
itself.
ಅಡ್ಜುಡಿಕೇಶನ್ ಆಗಿಲ್ಲ.
ಏನಾಗಿದೆ?
ಸುಮ್ನೆ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬಿಟ್ರು ಅಷ್ಟೇ.
ಆರ್ಡರ್ ಅಂದ್ರೆ
ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ವಿತೌಟ್
that's
ಅಡ್ಜುಡಿಕೇಶನ್.
an order, sir.
No decree is drawn because
Sir, 2197 rejection may not result in a decree, but that's an order by itself appealable. ಏನದು?
May be permitted to objections, my lord.
ಯಾವ್ದಕ್ಕೆ?
Objection to petition.
ಏನು maintainable
No
ಅಲ್ಲ?
maintenance, no
No
maintenance.
maintainable.
rule 101, there must, it needs adjudication. Without adjudication.
That is also a subject matter of appeal. You challenge it in appeal.
My
No, sir, why appeal ಆಗಕ್ಕೆ ಏನ್ problem?
ಅಲ್ಲ, decree
96 appeal ಆಗಕ್ಕೆ ಏನ್ problem?
ಡಿಗ್ರಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ you produce a decree ಅಂತಾರೆ. Decree is not drawn. Decree ಇಲ್ಲ ಅಂತಂದ್ರೆ the office will raise an objection. Where is the decree?
2197 is an order by itself.
Moreover, no locus.
Rejection of 2197 in the manner in which Allah, it is rejection. You will have to file an appeal.
Well, transport has not drawn decree. If decree is not produced, the question of materiality of appeal does not arise at all. Again, there will be a problem for me. That is because of the mistake committed by the transport. I have come before this township in filing the writ petition. Otherwise,
Yes, sir.
I would not have filed this writ petition.
My lord, basically they have no locus standi to file this petition, my lord. My lord, they are the vendors of my vendors, my lord. They executed suit for specific performance of contract, my lord. They executed the register sale deed in favor of my vendor in respect of same scheduled property, and now they are filing application before the trial court object.
What decree has to be drawn against you, sir, or in your favor? 2197 rejection is an order which is appealable. You have to appeal. No decree need to be drawn there. Yes. Anything else, sir?
Lord, my objection may be taken on record, my lord.
Learned counsel for the respondent seeks to file a statement of objections. Office objections qua maintainability of the petition stands sustained. It is open to the petitioner to file an appeal if he so desires for statistical purposes. Next.
And today deliver warrant with police ಮಾಡೋದಕ್ಕೆ ಇದು ಮಾಡಿದ್ದಾರೆ ಇವತ್ತು.
ನಾಳೆನೇ ಫೈಲ್ ಮಾಡಿ. Yes.
I am directed to get the stay order.
ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
No entry ಮಾಡು contract. No entry.
Yes, next.
ಇವತ್ತು ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ಇವತ್ತೇ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ವಿತ್ ಪೊಲೀಸ್ ಹೆಲ್ಪ್.
ಅದಕ್ಕೆ ಸಪರೇಟ್ ಹಾಕ್ಬೇಕು ನೀವು. Yes.
Because
Oh, sir.
again the problem there is because definitely the office will raise an objection. Where is the decree? Then where can they go and get
Next
the
we'll
decree?
see. Yes, yes.
12,
In the meantime, some interim order till filing of the appeal.
ಏನ್
Till filing of the appeal.
it you have to file an appeal ಅಂತ ಹೇಳಿ ಅದ್ರಲ್ಲಿ ನಾನು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡಕ್ಕಾಗತ್ತಾ? Yes, why are you precipitating? ಅವ್ರ ಅಪೀಲ್ ಹಾಕೋರ್ಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ?
No, ನನ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಮೇಡಮ್.
ಅದು ಡೆಲಿವರಿ ವಾರಂಟ್ ಏನದಲ್ಲ?
My lord, the execution petition is filed in the year 2020 itself, my lord. My lord, the petitioner is being a full-time practicing advocate and colluding with some other advocates. They filed another specific performance of contract before the CH-27, my lord, and they are protracting the proceedings, my lord. They're not
Yes,
seeking
next.
to get the fruitful of the decree, my lord.
Next.
Much obliged, my lord.
Next, sir. ಇನ್ನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ರಲ್ಲ ಅದ್ರಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ. Yes.
Appearing for petition.
Office objections ಏನಿದೆ?
Parties, some of the parties, why they are not made as arrayed as a party? I think they
Sir,
are not.
office objection, learned senior counsel, learned senior counsel M.R. Rajagopal appearing for the petition, office objections overruled. ಏನಿದು? ಎಲ್ಲೇ?
But it's a question of law is there.
Question of law is there.
Yes, what is
Will
that
issue
mean?
notice.
When I apply for interim order, an extra admission award passed after 30 years.
We'll see. Then list on Thursday.
Yes,
Preliminary hearing.
much obliged.
Thursday preliminary. Yes.
13,
Could it be on next Tuesday? Thursday,
problem.
Friday is cooperative matter. Problem will be.
Oh, sir.
That's the reason.
Will cooperate.
Yes.
Tuesday.
Grateful for the cooperation.
Yes, sir.
For the petitioners, my lords.
Yes. Office objection.
Well, it's office objections ಇದ್ರಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ಟೈಪ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಒಂದು. It's already.
Typed ಕೇಳ್ತಾ ಇದ್ದಾರಾ?
Yes, my lords. The reason is the matter's
All
already
right,
been.
we'll overrule the office objections. We'll list it day after tomorrow.
Again.
Tomorrow.
Again, my lords.
List but tomorrow in preliminary hearing of accepting the submission of the counsel for the petitioner. Office objections overruled. Yes.
Sure.
Next.
14,
For the petition, week's time may be granted, my lord.
Learned counsel seeks a week's time to comply with the office objections.
15 preliminary.
Week's time is granted.
Pray for a short accommodation. This matter.
Not accommodation.
Please.
Why? Last time we ಹೇಳಿದ್ರಿ.
Senior has gone out of station.
B part.
My lords, on the last occasion, my lords, we had pointed out that an award has been framed. This honorable court was pleased to direct us to secure instructions as regards issuance of a 12-2 notice
Yes.
under the Old Land Acquisition Act and also deposit.
Okay.
I am in the process, my lords. I'll file because frankly, my lords, they have not issued a 12-2 notice or made deposit. I don't want to make a oral statement. I'll make them file an affidavit, my lords. Let them file an affidavit, my lords. A short accommodation may kindly be given.
At the request
Because they have framed the award, they've sent it for approval and they've sat over it.
ಅದು ಗೊತ್ತು ಅದೇ ಆಗಿರೋದು ಅಂತ ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಮತ್ತೆ ಯಾಕೆ ಬರ್ದ್ರಿ?
ಅದಕ್ಕೆ ನಾನು I don't want to make that statement. I'll make them file an affidavit, my lords, based on which my lords could give a file.
All right.
Please.
This court on 10/7/2025 had passed the following order. The learned counsel B.B. Patil seeks time to comply with the order. Seeks a week's time to comply with the order. List the matter on next Tuesday agata or Thursday agla.
Please. Any day. my
List the
lords.
matter on 1st August.
Please. Deeply obliged.
Yes.
16,
Is the one which is covered by the judgment.
Covered ಅಂತ ಇಲ್ಲಿ ಹಾಕಿರೋದು. Covered ಅಲ್ಲ ಅಂದ್ರಲ್ಲ
Not
ಆಮೇಲೆ.
covered, my lords. I have filed, my lord, detailed statement of objection.
Ah.
And the writ petition consists of 4 survey numbers, my lord. In respect of one survey number, one of the petitioner has filed another petition without disclosing, my lord, the filing of the other petition. The present petition is filed. My lord, that petition is still pending. And in one of the petition, my lord,
That petition.
my lord, I have produced.
ಇನ್ನೊಂದಿದೆಯಾ?
ಇನ್ನೊಂದು ಹಾಕಿದ್ದಾರೆ for the same relief, but anyway this is covered. Your lordship may.
Anyway, this is covered.
I will
Same
submit.
relief.
In which way this is covered ಹೇಳಿ?
Huh?
In which way? Anyway ಅಂದ್ರೆ many way ಆಗುತ್ತೆ. Which way ಅಂತ ಹೇಳ್ಬಿಡಿ.
Which way is the government has given sanction at the end of 25 days from the day on which
30 days
preliminary
mandatory ಅಂತ.
30 days is
That is
mandatory.
directory ಅಂತ ಹೇಳಿರ್ಬೇಕು ಎಲ್ಲ.
And the same notification has been set aside, quashed by the court.
ಯಾವ್ದು ಕೊಡಿ ಅದು? ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ?
ಕೊಟ್ಟೆ last time ಕೊಟ್ಟಿದ್ದೀನಿ. WP 29/211 of 94. Last time court ಕೊಟ್ಟಿದ್ದೀನಿ.
Detail objections. ಯಾವ ಜಡ್ಮೆಂಟ್ ಇಲ್ಲ.
ನಿಮಗೂ ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಒಂದು ನಿಮಿಷ ಸಾಹೇಬ್ರು ಕೊಡ್ತೀರಾ?
This is the copy which they have furnished to me.
ಇದೇನಾ covered ಅಂತ ಹೇಳಿ?
They say, my lord, it is covered. My lord, those petitioners have approached this honorable court in the year 1998, and the relief was granted to the petitioners therein. But subsequently, there are other orders passed by this honorable court holding that the scheme is substantially implemented. And it is not their case that on account of the shortage of 4 days in, my lord, sanction of layout, any rights of the petitioners are infringed. My lord, they have filed objections, it has been considered and rejected. But these petitioners have come, my lord, before this honorable court in 98. My lord, the present
petitioners?
No, my lord, the petitioners therein. The present petitioners have approached this honorable court in 2018, my lord, after 20 long years.
Oh, this is same notification.
Same notification, my lord. And one of the petitioner has filed a petition seeking, my lord, grant of incentive side. The writ petition has been disposed of. But all these things are not disclosed in the writ petition.
No.
Only after I filing counter, my lord, they say seek to amend the writ petition. But that amendment application is still to be considered. But I will file my additional statement objection.
Then we will have to
This
hear
is
it.
not covered, my lord, is my respect.
ನಾನು covered ಅಂತ preliminary ಹಿಂಗ್ ಹಾಕ್ದೆ.
ಅಲ್ಲ covered.
If he is objecting to it, yes.
ಅಲ್ಲ, your lordship would kindly see he is contending
What were you doing for
R21 to R24.
No, 1 minute. What were you doing for 25 years, sir, after this?
Your lordship would kindly see. I have given.
1998 is the order.
Correct.
We are in 2025. This is filed in 2018. All right. Yes, 20 years.
Your lordship would kindly see, what we have stated is right to fair compensation has come again. Thereafter, that is another ground that we are urging. Only because.
Where are those judgments? Where are those judgments?
Which judgments, madam?
Right to fair compensation and other things.
That is
That
not
is a new
applicable.
ground, that is, that because my.
So your lordship's no, my lord, right to fair compensation act is not applicable to the special enactments under the urban development.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಇಲ್ಲ.
ಇದು ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ.
Development, the act itself says fair compensation act is applicable. The very act says.
Yes. We'll hear it only.
Please.
It's covered ಅಂತ preliminary ಹೆಂಗ್ ಹಾಕಿದ್ದು. If he is objecting to it, it has to be heard post, admit rulish ಆಗಿದೆಯಾ?
ಆಗಿದೆ already.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. It was listed for final hearing only on the last
List the matter for final hearing next Friday. That is, sorry, 1st August.
Please.
ಅವತ್ ಮುಗ್ಸೋಣ. Covered ಅಂತ preliminary hearing ಆಗ್ತದೆ.
ಅಲ್ಲ, cover is same
If
notification has
there is
been
a dispute with regard to matter being covered or not, we'll hear it. Yes.
He is relying on R1 to R24, I will satisfy this one.
Friday.
17.
Lord, 17, I am appearing for the petitions council minutes. Lords,
Amendment direction.
Yes, two.
ಯಾರು objection ಹಾಕ್ಬೇಕು?
ನಾನು ಹಾಕ್ತೇನೆ.
Lords, this is the 6th round of litigation for an acquisition which has taken place in 1996. After 5 successive and successful rounds of litigations for the petitioner, Lords, the authorities pass an award
But
for
court ಗೆ
20,000
ಬಂದಿಲ್ವಾ?
rupees for a land which is acquired for airport.
ರವಿಶಂಕರ್ ಸರ್,
Lordships.
ಕೋರ್ಟ್ಗೆ ಬಂದಿಲ್ಲ ಇವತ್ತು?
ಇಲ್ಲ.
ಧಾರವಾಡದ ಒಂದು ಮ್ಯಾಟರ್ ಗಿತ್ತು ಅದಕ್ಕೆ ಹಂಗಾಗಿ ಅದಕ್ಕೆಲ್ಲ ನಾಡಿದ್ದಿಗೆ ಹಾಕೊಂಡ್ರೆ ನಾನು ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದಿಗೆ.
ಇಲ್ಲ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಅಬ್ಜೆಕ್ಷನ್ ಯಾಕೆ?
There are two applications of file.
Amendment and direction.
Yes, madam, I will ready ಇದೆ ಕಳಿಸ್ಬಿಟ್ಟಿರಿ.
ಅಲ್ಲ, senior counsel is saying it is 6th round.
Correct.
ಪ್ರತಿ ಸರಿ ಇದೇ ಮಾಡಿದ್ದೀರಾ?
Petitions have not meant because the alternative remedy is available.
What alternative remedy?
Once award is passed, they have to go for 18 occurrence.
Compensation.
Lords, for the
And
land
moreover,
acquired
Lord,
for
the
the
seeking
airport
to pay the
after
order,
5
they
rounds
leave
of
act.
litigation.
That is
Pass an award issued to the adjacent landowner.
ಅಲ್ಲ, ಅದನ್ನ delete ಮಾಡಿದ್ದಾರೆ.
ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ಹೆಂಗ್ ಸಾಧ್ಯ?
Lords, I'm just making the statement. Lords, after 5 rounds of litigations, the authorities pass an award that 20,000 rupees per acre will be awarded for a land acquired for the international airport after 30 years. This is the audacity with which the authorities are behaving.
80,000 per acre.
ನಾನು objection.
20,000, 20.
ಹಳೆ acquisitions, not new one ಅಲ್ಲ.
96
Adjacent
acquisitions.
land ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅದು
Adjacent land.
ಇಲ್ಲ ಅದು. ಅದರ ಕಾಪಿ ಹಾಕಿದ್ದಾರೆ.
ಒಂದು ನಿಮಿಷ. Adjacent land ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
93 lakhs
per acre.
this per acre in 2016.
ಇದು ನಿಮ್ದಕ್ಕೆ ಎಷ್ಟು?
20,000 rupees.
What is this, sir?
No, that's what I.
So you like those landlords and not these?
But that's not, it's only, it appears a draft, it's not approved.
Now, after 30 years of litigation, they will not say that they will pay the compensation on that market value. Today, they will have to pay the compensation.
Reference ಆಮೇಲೆ ನೋಡೋಣ. But what is the difference here?
No, that's what I want to place in our record, because so it says it is not even, it's like a draft.
ಒಬ್ಬರಿಗೆ 93 ಲಕ್ಷ
75 of my written papers.
ಅಲ್ಲ, ಅದಕ್ಕೆ 10% ಇಲ್ಲ, 20,000.
That's what I'm getting instruction, because it says it's only is the
The
only.
learned counsel P.V. Chandrasekhar seeks 10 days time to file his objections. Petition ಹಾಕಿದ್ದೀರಾ?
ಅದು ಹಾಗೆ 2000
Objections.
ಆಗಿದೆ.
Petition ಹಾಕಿದ್ದೀರಾ? Objections
To the IAS and
to the application, objections to the application and to the main petition.
2 weeks.
List the matter on 6th August. In the event no objections come about to the applications or to the petition, it shall be construed that there are no objections to be filed by the respondent. List the matter on 6th August.
So great.
Next may be show Siri R, name of the,
ಯಾವುದ್ರಲ್ಲಿ?
in this matter.
17 ಅಲ್ವಾ ಇದು?
Please, my lord.
ಪ್ರಸಾದ್ ಹೆಗ್ಡೆ ಇಲ್ವಾ?
No, my lords.
Registry to delete the name of Prasad Hegde KB as appearing for the petition and print the name of Siri R.
Please, my lords.
Siri R.
Much obliged.
Great.
Yes, next.
Lord, for petition, Lord, the property belongs to joint family, my lord. The award has been given to my lord, respond number 2 to 9 only. Award, my lord, compensation has not been granted to the
Joint
petitioners.
family partition suit pending ಇದೆಯಾ?
Pending, my lord.
Pending ಇರ್ಬೇಕಾದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ unless it is over?
No, my lord. Insofar as, my lord, admitted fact, my lord, kindly see ink page number, my lord, statement of objection itself, and the gift deed which they executed in the year of 1966 has been admitted by them, and they have stated in their written statement, kindly for a moment.
Land ಎಲ್ಲೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಥವಾ GMCPC ನ?
ಅಲ್ಲ, this is, my lord, ಎಲ್ಲೇದಲ್ಲೇ ಬಂದಿರೋದು ಇದು.
Correct.
provided, my lord, in so
Suit
far
del
as
argument
suit
ಮಾಡ್ತಾ
is for declaration, not partition. Kindly for a moment,
Partition and
ink page
declaration
number
ಎರಡು ಇದೆ.
38 may
What
kind-
is the stage of the suit?
Argument, evidence.
amended petition ಹಾಕಿದ್ದಾರೆ. One, for a moment, ink page number 38 ನೋಡಿ sir. Admittedly, they respond para 20, that is the statement of objection filed by them. That they have said, my lord, that 50% that I am entitled, 50%, my lord, can be, my lord, till disposal of the suit, my lord, that since AC case, my lord, clearly hold that I am entitled by referring all the documents.
Yes, sir.
50% ಮಾಡಿ ಅದರಲ್ಲಿ 25% each
ಇಲ್ಲಿ clear ಆಗಿ ಹೇಳಿದ್ದಾರೆ 50% I am entitled.
50%?
50% amount ಅಲ್ಲಿ ನಮಗೆ ಅವ್ರಿಗೆ ಈಕ್ವಲ್ ಮಾಡಿ ಇನ್ನ ರಿಮೈನಿಂಗ್
ಇಲ್ಲ,
ಆಫ್ಟರ್ ಡಿಸೈಡ್ ಆಫ್ ದಿ
38 para 20 ನಾವು ಓದ್ಬಿಡ್ತೀನಿ sir.
Both of you sit and file a
ಪಾರ್ಟಿಷನ್
memo.
ಪಾರ್ಟಿಷನ್
Both of you sit and file a memo. Yes, list on Thursday.
ಎಂಟ್ರಿ ಮಾಡಬೇಕಲ್ಲಿ
Entry order subsisting will,
Since, my lord, that
whatever you want to file a memo, sir. Yes.
no, we will not file because, my lord, there is a, they have admitted that I am entitled 50%, and AC also court.
We'll
ruled-
hear it, list the matter
please,
on
please.
12th August. Interim order subsisting will continue
ಒಂದು
to the next
ಸಬ್ಮಿಷನ್
date.
50% ಅಂತ ಕೇಳಿದ್ರು ಅವರು ಆ 50% ಅಲ್ಲೇ
Entry
ಅರ್ಧ ಮಾಡಿ ಇನ್ನು ರಿಮೈನಿಂಗ್
ಅದಕ್ಕೆ
50% ಆಫ್ಟರ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ದಿ ಸೂಟ್ ಅಂತ
File,
ಮಾಡಬಹುದು
file it, sir. Sit
ಲಾಸ್ಟ್ ಟೈಮ್
across-
ಅವರು ಅದೇ
Sit across and file it, yes.
ಎಂಟ್ರಿ ಮಾಡಬೇಕಲ್ಲ
That will continue.
19.
It's appearing for the petitioner in 19.1 minutes.
My lords, 19, we had moved this saying that there is a road which is blocked.
Correct.
And my lords, I've sought the indulgence of this court to file a map to show which door. I've filed it in the registry, my lords, on the last date of hearing, if my lords could.
Really, ಇಲ್ಲಿದೆ.
My lords, may please have the map.
Place on record, my lords, one document, my lord. I've
I'll-
made a proposal, my lords, to the KIDB, my lords, to forego, my lords, the entire land, subject to, my lords, them allotting, my lords, portion of the entire land, my lords.
Let him allow us to work on the road. This
Lords, the road also I
negotiate-
have shown in the map. If the, let them consider first, my lords, the proposal, because, my lords,
ನಾಳೆನೇ consider ಮಾಡಿ.
ಅಲ್ಲ, we'll consider it. ಅಲ್ಲಿವರೆಗೆ
all
road,
that I am seeking,
road
my lords,
access. ಅಲ್ಲ,
my lords, the entire extent is 6 acres.
Road access ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ,
ಕೆಲ್ಸ
ಅದ್ರಲ್ಲಿ ಹೇಳಿದೀನಿ, your lordships may kindly.
ಅದು ಕೊಟ್ಟಿದ್ದೆ ಅವ್ರಿಗೆ.
My lords, it is already submitted to them, my lords.
What is it? You have not seen?
ನಮಗ್ ಕೊಟ್ಟಿಲ್ಲ,
ಅಲ್ಲ,
ಬೋಡಿ
to
ಕೊಟ್ಟಿದ್ದಾರೆ.
the-
ನನಗ್
to the
ಕಾಪಿ
board.
ಕೊಟ್ಟಿಲ್ಲ,
Council
ಬೋಡಿ
ಕೊಡಿ
ಕೊಟ್ಟಿದ್ದಾರೆ.
sir.
Today, my lords, I am placing.
Council ಕೊಡಿ. And file it along with the memo. What is all this?
My lords, I'll just show this on the map if my lords could have.
No, if he is agreeing to forego everything, finish. Matter
Give him
ends.
alternate. There is a policy of the government,
Matter ends,
10,000.
sir.
Subject
Undertaking
to-
may be taken, my lord.
subject to
Take it on,
allotting.
I'll take it on Friday. You exchange those things and get instructions on that.
My lords, 19.1, which is connected matter. My lords, for hearing serial number 26, where my lords had said I have not filed the 28.3 order. The 28.3 order is here.
26, sir. ಇನ್ನು
Serial number 26, my lords was hearing the other day. My lords asked me to keep the entire records. Actually, 19.1 needs to be connected to that, my lords, by incident.
number ಕೊಡಿ.
Serial number 19.1.
D-link 19.1.
And connect it along with serial number 26 listed today at petition number
10575.
10575 of
Oh,
2020.
that matter. Yes.
Please.
Grapes.
Please, grapes, we have filed the 28.3 order.
Wait.
We have kept it ready.
Yes. ಅದನ್ನ ಇದನ್ನ ಡಿಲಿಂಕ್ ಮಾಡಿ ಅಲ್ಲಿ ಟ್ಯಾಗ್ ಮಾಡೋಣ ಆಮೇಲೆ.
My lords may permit,
This is Friday.
Friday, my lords, by that time we'll give him alternate land.
My lords, I have
ಮಾಡ್ಬಿಡಿ.
the proposal which I have given, my lords, let them consider, because, my lords, in 22
Friday ಗೆ, by then they will consider if they
Please.
want the road. Yes.
Please, please,
List the matter on Friday. Interim order subsisting will continue to the next date.
please, oblige.
Next.
20.
Morning, I made a request, a week's time I come because national authorities have to.
ಅದು 3 weeks ಇಂದ ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ,
ಏನಾಗಿದೆ?
ಅದು ಫೈನಲೈಸ್ ಆಗಿ ಬರ್ಬೇಕಾಗಿತ್ತು. Read
Yes. ಏನಾಯ್ತು?
On behalf of the state highway division, my lord, it is confirmed that there is no plan as such, except these three
ಅದೆಲ್ಲ
options.
ಆಯ್ತು. Now here earlier there was some submission made with regard to the Ministry of Surface Transport saying something.
I
That is
made
for
a
the
submission.
Central government, my lord, she is urging, my lord.
Who
but,
who
which
appears?
is not-
Yes, Ajay Prabhu.
Yes, my lord.
Which is not there.
Union of India ಯಾರು?
I'm appearing for.
Yes, what happened?
Lord, this
Is this correct or not? He is simply stalling the road. That is why it was correct or not?
Lord, regarding stall, encroachment.
ನಿಮಗೆ ಫೈಲ್ ಓದಿಲ್ಲ ಅಂದ್ರೆ ಫೈಲ್ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ. You're asking the petitioner, what's the matter about?
No, my lord.
Then
regarding this, my lord, there is only three options. My lord,
ಆದ್
out of
3
the-
ಆಪ್ಷನ್ ಆದ್ಮೇಲೆ ಏನಾಗಿದೆ ಏನ್ ಇಲ್ವೇ ಇಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
No, my lord, there is no other
There is
proposal.
no other proposal as such except the 3 options.
He is bringing
Then
new
we will
facts, my
dismiss it, Shiv Prakash sir.
My lord, my humble request is now,
With the direction.
ಈ ಆರ್ಡರ್ ನೋಡಿದೀರಾ ಇಲ್ವಾ?
lord. Lord, ನೋಡಿದ್ದೀನಿ.
ಏನ್ ನೋಡಿದೀರಾ?
My lord, to check the feasibility, my lord. My lord,
ಇದು ಕೊಡಿ ಮೇಡಮ್ ಅವ್ರಿಗೆ. ಫೈಲ್ ನೋಡಲ್ಲ, ಆರ್ಡರ್ ನೋಡಲ್ಲ. ಬಿಕಮ್ ವೆರಿ ಬಿಸಿ.
no, my lord, sorry.
This
Other
was,
ಏನು ಅಂತ
this was,
ಕೇಳ್ತಾ
this
ಇರೋದು.
was, this was proposed for us, my lord, that.
My lord, my lord, it is sought with them, my lord. They have produced a report.
What is that?
Yes, my lord. Ministry
If
of
they are
That
Ministry.
submission, on that submission I'm adjourning it. What has happened to that?
My lord,
ನೀವು previous files ನೋಡಲ್ವಾ ಯಾವ್ದಿದೆ?
I'm sorry. I'll seek instruction on this.
I'll take it tomorrow. If instructions are not sought, day after tomorrow. List day after tomorrow.
my lord, my humble request is on 4th or 5th, Monday or Tuesday.
No, sir.
My lord, request is because when we moved the matter with the humble minister, then for redoing and relook the matter entirety, the direction is there so that we can place it material on Tuesday. Please, my lord.
Tuesday. List next Tuesday.
Let it be on the part heard, my lord, at 2:30.
Next Tuesday, yes.
That is 2:30, my lord.
ಏನು ಚೇಂಜ್ ಆಗುತ್ತೆ?
ಇಲ್ಲ, change ಆದ್ರೂ ಸಮೇತನ 4:30
Next
ಬರುತ್ತೆ.
Tuesday, yes.
Lord, let him
ಇಲ್ಲ.
give any documents to my lord that he has
That
represented.
you secure instructions, sir, on that I have passed an order.
My lord, on that information, my lord, that was transmitted to our division, wherein our engineer has gone and
I
tested.
finally
He has given report.
list the matter on next Tuesday, 29th, huh?
29th, my lord.
29th, it is made clear, no further adjournment will be granted in the matter.
Because my lord, this is, my lord, interested to
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ
PW, ಅಲ್ಲ, PW department.
ನೋಡ್ಬಿಟ್ಟು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ಬನ್ನಿ.
51.
Into the last order, my lords. Right, my lords, to settle the matter.
What happened?
Nothing there.
He said, my lord, there is no settlement.
We,
ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಲ್ವಾ?
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಬೆಳಗ್ಗೆ.
ಹಾ, ಸರಿ. ಹೇಳಿ.
please, my lords,
Come on, merits.
please. Lords, impugned order, my lords, at page number 21. The plaintiff, my lord, had filed a suit for rectification of the sale deed of the boundaries. During the pendency of the suit, my
This
lord,
is second rectification.
second rectification. Page number, during the pendency of the suit, my lords, parties, plaintiff and defendant number 1 and 2, my lords, filed a compromise petition. Page 21, my lords, is the order. Para 9.
Page 21.
Page 21. Para 9 is the order. The trial court holds, my lords, that a partial compromise between the parties is not permissible under Order 23, Rule 3 of the CPC.
It is permissible, that's all right.
Please, my lords.
Yes.
Now, this order, my lords, is now challenged before this honorable court, my lords.
Why partial compromise is not permissible?
My lord, partial compromise is permissible. Lord, question is merely because compromise is lawful doesn't mean that it is having a satisfaction to the court. In the present circumstances, my lord, I will point out that my lord, I kindly see the nature of relief sought. Even in the suit, your honor, he doesn't say what kind of rectification needs. A very privileged suit. Even in the compromise petition, my lord, he has not stated what is to be rectified. That is, my lord, the compromise petition is at
Page 36 is a prayer. 36 is a prayer, first prayer, my lords. To direct the defendants, my lords, to execute a registered rectification deed.
But the reason rendered by the court is wrong. Para 9 ali, all the parties should be parties to the compromise is not the law.
I have mentioned what is the rectification I want, I have mentioned, my lords.
but in the given, yes, let him complete, my lord.
I have mentioned what rectification I want, my lords, at page 36. That's a prayer in the plaint, my lords. I have said so what rectification I want, and I mentioned the new schedule also, my lords, along with the plaint.
Yes, sir. Partial compromise is
My lord, that is, I will agree, my lord. But in, my lord, in page 46, the compromise petition. What is the nature of compromise? It has not been stated anything. My lord, ಒಂದು ಮತ್ತು ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳು ವಾದಿಗೆ ದಾವಾಡ್ಸೋಟಿ ಸ್ವತ್ತನ್ನ 98ರ ನೋಂದಣಿ ಕ್ರಯಪತ್ರದ ಮೂಲಕ ಅವರುಗಳ ದರದುಗಳಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಸ್ವಾಧೀನ ವಹಿಸಿಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದು ಒಪ್ಪಿರುತ್ತಾರೆ. ತದನಂತರ ದಿನಾಂಕದ ವಾದಿಯ ಸಂಪೂರ್ಣ ಮಾಲೀಕರಾಗಿರುತ್ತಾರೆ, ಒಪ್ಪಿರುತ್ತಾರೆ. ವಾದಿಗೆ ನೋಂದಣಿ ಪತ್ರವನ್ನು ಚೆಕ್ ಬಂದು ನಮೂದಿಸಿ ಬರೆದು ಕೊಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ. ವಾಟ್ ಚೆಕ್ ಬಂದಿ ವಾಟ್ ಇಸ್
So we'll direct the court to, you file an appropriate application, we'll direct the court to reconsider it, but not on this ground, this I will set aside.
Milords, page 46 is a compromise, Milords. I have mentioned everything. I have mentioned the nature of the compromise also. Your Lordship will see page 46.
ಎಲ್ಲಿದೆ?
Please, Milords, para number, unnumbered para number 3, Milords.
ಒಂದನೇ ಮತ್ತು ಎರಡನೇ ಪ್ರತಿವಾದಿಗಳು ಅವರ ಮಕ್ಕಳು ವಾದಿಗೆ ನೋಂದಣಿ ತಿದ್ದುಪಡಿ
ದಾವಾ ಶೆಡ್ಯೂಲ್ ಚೆಕ್ ಬಂದಿ ನಮೂದಿಸಿ
ಚೆಕ್ ಬಂದಿ
ಕೊಡಲು ಒಪ್ಪಿರುತ್ತಾರೆ ಹಾಗೂ ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿಗೆ ವಾದಿಯೇ ಪ್ರತಿವೇಕವಾಗಿ ಖಾತೆ ಮತ್ತು
ಸ್ವಲ್ಪ ಡೀಟೇಲ್ ಆಗಿ ಬರೆದ್ಬಿಟ್ರೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ?
The suit only is only for the correction of boundary, my lords.
My lord, even suit also there is the ambiguous. There is no clarity.
The reason of the court is.
Reason I will agree, my lord, and order 23 rule 3, my lord, mandates. My lord, I am very conscious, my lord, 227, my lord, very privileged suit, privileged compromise. My lord, even it is not mentioned.
The compromise is only with regard to the boundaries now.
No, not mentioned. Which boundary is to be corrected?
As for the suit schedule property, my lord, I mentioned.
Even suit schedule, even, my lord, 98 there was a sale deed. My lord, 2004 there was a rectification deed. After lapse of so many years, 10 years, suit is filed. But what is to be, which boundary to be rectified? In what connection? In the compromise also it is not stated.
Suit schedule property, what connection is there?
Sorry, my lord, but in the compromise also, they cannot say very vaguely. That is omnibus.
Only with regard to boundaries.
Oh, which boundary? He has not stated.
I have said so.
ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ boundary ಚೆಕ್ ಬಂದಿಗೆ ನಮೂದಿಸಿ
ನಿಮ್ ಪ್ರಕಾರ ಇರೋ ಬೌಂಡ್ರಿ ಅಲ್ಲ, ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇರೋ ಬೌಂಡ್ರಿ
ಅಲ್ಲ ಸ್ವಾಮಿ. ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಹಾಗಾದ್ರೆ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಕ್ರಯಪತ್ರದ ಬೌಂಡ್ರಿ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಗ್ಬೇಕು. ಯಾವ ಬೌಂಡ್ರಿ ಐದರ್ ನಾರ್ದರ್ನ್ ವೆಸ್ಟರ್ನ್ ವಿಚ್
ಬಟ್ ದಿ ರೀಸನ್ ಇಸ್ ರಾಂಗ್, ವಿಲ್ ಸೆಟ್ aside.
Yes, my lord, reason is wrong. My lord, so far as nature of suit is concerned, my lord, the court have a satisfaction. Though it is lawful, my lord, partial partition is permissible, subject to satisfaction. Compromise is permissible.
With regard to who's Badri, ನೀವು ಯಾರಿಗೆ?
1 and 2.
You are sailing with him.
I am sailing with him.
ಅವರಿಗೆ ಸೈಟ್ ಒಂದೊಂದು ಕೊಟ್ಟು ಈಗ ಅವರು ಹೇಗೆ ಹೇಳ್ತಾರೆ ಅದು ಸೈನ್ ಹಾಕಿದ್ದಾರೆ.
Whatever
ಈಗ
he
ನಾವು
wants, he'll go file.
ಈಗ ನೀವು ಸೈಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಇದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಎರಡು ಬೇಕಂತ.
ಅಲ್ಲ ಅಲ್ಲ ಸ್ವಾಮಿ, ವಯಾ ಮೀಡಿಯಾ ಹೇಳಿದೀವಿ ಸ್ವಾಮಿ, ನಾವು ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಅದೇ ಹೇಳಿದೀವಿ.
There is nothing.
ಅವರು
This order cannot be sustained. Yes.
But it will not having a satisfaction, Lord.
Your satisfaction is not the concern of the court, sir.
Allah, that is our order 23 rule 3 demands, my lord. Allah, but the nature of litigation.
If I am satisfied, I will pass the orders.
Allah,
I am, I guess.
No, my lord, I am not saying that, my lord. Since the nature of relief demands, there must be a clarity. But in the compromise,
boundary change ಮಾಡಕ್ಕೆ clarity.
ಯಾವ boundary ಸ್ವಾಮಿ, ಯಾವ boundary change?
ಇನ್ಯಾವುದರ boundary ಪಕ್ಕದ ಮನೆದು ಮಾಡ್ತಾರಾ?
ಅಲ್ಲ ಇಲ್ಲಿ ಬೌಂಡ್ರಿ ಯಾವ ಬೌಂಡ್ರಿ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ ಅಂತ ಬರಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದಾರಲ್ವಾ, ವಿಲ್ ಕಾಸ್ ದಿ ಕೋರ್ಟ್ ಟು ರೀಕನ್ಸಿಡರ್ ಇಟ್. ದಿಸ್ ರೀಸನ್ ಇಸ್ ರಾಂಗ್. ದಿ ಪೆಟಿಷನರ್ is before this court, petitioner plaintiff is before this court calling in question.
We have also filed objection, my lord, before trial court.
Whatever.
Yes.
Calling in question.
Reconsider.
An order of the concerned court dated 25/11/2024 by which the court rejects an application and order 23 rule 3 in OS 617 of 2010. Heard so and so. Facts in brief germane are as follows. The facts in brief, bada. The facts that leads the petitioner to this court for the present lies in a narrow compass. The concerned court, a compromise was entered into between the parties way back in the year 2019. A rectification is sought with regard to the terms of the compromise or the suit schedule property as the case would be. The said rectification was accepted to or acceded by the parties. A second rectification is now sought before the concerned court by filing an application under order 23 rule 3 by the plaintiff. That is the said suit filed for rectification under order 23 rule 3 comes to be compromised between the plaintiff and other defendants.
D1 and D2.
D1 and D2. The
D3 opposed.
The third defendant has put up his vehement opposition, and therefore the concerned court accepting the opposition of the third defendant rejects the application seeking compromise on the ground that in a compromise petition, all the parties should be present. There cannot be a partial compromise. The finding of the concerned, a compromise. The concerned court has observed as follows.
21.
Page 21 and 22, para 8 and 21 to 20 to 22. The reason rendered by the concerned court to reject the application in order 23 rule 3 is on the face of it erroneous, as it is settled principle of law that there can be a partial compromise between few of the plaintiffs and few of the defendants in a suit. Therefore, the order would require reconsideration at the hands of at its hands. With the law being clear, the order runs foul of the settled principle of law. For the aforesaid reasons, the following order. The order date so and so stands quashed. The matter is remitted back to the hands of the concerned court to reconsider the application, reconsider the petition for compromise on its merit and pass necessary orders in accordance with law within an outer limit of 6 weeks from the date of receipt of the copy of the order. While so doing, the concerned court shall hear the parties, consider the objections, if any, and then pass necessary orders. Ordered accordingly.
Good.
22.
So may kindly pass home for accommodate me by 10 minutes.
22.
But the sale deeds have been made. Survey number 93. There have been certain sale deeds given to the other landowners. But the allegation is, my lord, that it is a government land. After the allegation has come up, no sale deeds have been made. I'll have to file an affidavit, my lord. May pass over.
Pass over.
No, Your Lordship kindly.
Pass over.
Sufficiently, Your Lordship has accommodated.
Sufficiently pass over. Pass over. Yes. Yes, next.
23.
For respondent BDA, this matter involves identification of landlords, and BDA has directed for a survey with revenue officials. We need some time to file report notes.
Learned counsel for the respondent BDA Poonam Patil seeks 2 weeks time. Objections?
Yes, Ms.
2
Along
weeks
with
time to
survey.
file statement of objections. There is no representation by of the petitioner. List after 2 weeks. Objections, if any, by the next date. Next.
Great.
64.
Yes, Vinayak, hakudra?
Yes, my lords, I have filed it. Copy may not have been there, my lords. I have additional copy. I am
Avaru
ready.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ, but ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. I am ready. Additional copy ಇದೆ.
What's the matter about?
He's questioning the demand notice. We have charged interest for delay in making payment, my lords.
Payment for what?
E-auction ali he gets a site. It is confirmed. 2020 ali we cancel it. 2018 is the confirmation. 2020 ali we cancel it for non-payment. And then he files a writ petition. First round, cancellation order is set aside. That order is challenged by the BDA in writ appeal. Order is confirmed again. Now we have issued demand notice seeking interest for the belated payment.
When did he pay?
My lords, now after the demand notice, he has paid the entire amount. Now he is seeking refund also. So that is the case, my lords. Now,
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
We paid full amount.
ಎಷ್ಟು? How much is that full amount?
1 crore 54.
1 crore 54.
No, you want refund of it, is it?
A refund.
71 is ಜಾಸ್ತಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು.
He has prolonged the matter by delay tactics.
2018 is the allotment, is it?
Confirmation is 12/3/2018, my lords.
12/3/2018.
Yes, my lords.
What was the time limit for payment?
Because of the
45 days, my lords. I must also tell, 45 days was the.
Any notice issued to him?
My lords, I'll come to that. ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ ಕನ್ಫರ್ಮೇಶನ್ ಲೆಟರ್ ಅಲ್ಲೇನೆ ಡೈಮೆನ್ಷನ್ ಅನ್ನ ಕನ್ಫರ್ಮ್ ಮಾಡಿ ಆಮೇಲೆ ಹೇಳ್ತೀವಿ ರಿಪೋರ್ಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಒಂದು ಹೇಳಿದ್ವಿ ನಾವು. ಬಟ್ ಹೌವರ್ ದಟ್ ರಿಪೋರ್ಟ್ ಕೇಮ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ ಸೆಪ್ಟೆಂಬರ್ 6 months ಡಿಲೇ ಇತ್ತು ಅವಾಗ ಇನಿಷಿಯಲಿ. ಅದಾದ್ಮೇಲೂ until 2020 he does not pay. Then we pass an order for cancelling the site.
That is set aside.
That is set aside.
That is set aside. It's confirmed by division bench
Yes,
also.
at set aside. Adaga there is an observation made by the learned single coordinate bench of this court. The
Page?
next F ali, my lords, at page number 50.
50.
Yes, my lords. Third line from the top. Therefore, I am of the view that in the event if the petitioner herein deposits the entire amount with relevant interest. within 30 days from the date of receipt of certified copy of this order, then respondent BDA shall consider the same and execute the registered sale deed in respect
So
of
division
such.
bench allo confirm ಆಯ್ತು.
This has been confirmed, my lords. I agree, my lords. This order was challenged.
After this ಏನ್ ಮಾಡಿದ್ರಿ?
Now demand notice ಕೊಟ್ಟಿದ್ದು ಆಮೇಲೆ.
Where is demand notice?
Annexure A, my lords, page number 20. I must admit, we have calculated the interest as on the date of demand notice, my lords. Writ appeal period ಅನ್ನು ಸೇರಿಸಿ.
Okay.
That I need to be fair.
Interest only for the delay of his first payment.
My lords,
2020 ವರೆಗೂ he did not pay.
No, even as on 2020, he did not pay. He has paid the remaining 75% only after I've issued the demand notice.
This is 12/2/2025.
Yes, my lords.
But proceedings before the court, you can't.
My lords, that period where writ appeal period may be, my lords, but then writ
Not even the petition period. It was before the court. Cancellation interim order ಇತ್ತಾ?
No, my lords. ಇರ್ಲಿಲ್ಲ.
Interim order ಇದ್ದೇ ಇರುತ್ತೆ. ಇರ್ಲಿಲ್ವಾ?
My lords, I'll verify that once again in that case.
Even then he is before the court. ಅದಕ್ಕೆ interesting charge.
My lords,
Ultimately he has succeeded. See, if it had been dismissed is a different thing.
but
He has
then,
succeeded.
but then one aspect that I
It
would,
dates back to the date of the cancellation order.
one aspect I would like to bring it to my lord's notice. 2000,
In the three
18,
occasion, my lord, by
2000.
delay tactics only,
Tactics.
delay tactics
All right,
only,
we'll see.
prolonged the issue.
ಆಯ್ತು ನೋಡ್.
One aspect that I would like to bring it to my lord's notice. 2018 is the confirmation order. 2018 ನಲ್ಲೇನೆ dimension confirmation ಅಂತ ಹೇಳಿದ್ವಿ. There was no change. ಅದೇ dimension ಇತ್ತು.
ಆಯ್ತು ಇದೆಲ್ಲ ಆಗಿದೆ ಅಂತ. Cancellation is set aside.
2020 ಅಲ್ಲಿ we cancel, my lords. Until then also he has not made any payment. The title value in that period would have gone
ಆಯ್ತು,
up.
you can't include the period of litigation also and charge interest for it. That's all.
I
The
leave it
writ
to my
petition period and writ appeal period exclude ಮಾಡಿ, you are ready to buy?
Ready to buy.
He has already paid the
Paid
amount.
the
that he
amount,
is
full
seeking
amount,
refund.
paid the amount.
I leave it to my lords.
That's bad. You can't charge interest for the pending litigation.
My lords, I must also tell
If it had been dismissed, definitely different. ಅದಕ್ಕೆ you exclude this period and charge him interest whatever. ಅದಕ್ಕೆ ರೆಡಿನಾ?
Ready, ready.
4 ವರ್ಷ ಕಮ್ಮಿ ಆಗುತ್ತೆ.
Ready, my lord.
Ready. We'll close it. The petitioner is before this court calling in question a demand notice dated 12/2/2025 insofar as it imposes interest upon the delayed payment and also seeks a mandamus directing the respondent BDA to refund the excess amount of interest collected to the tune of 71,17,876. Heard the learned counsel for the petitioner and the counsel for the BDA Vinayak Pandit. The facts enumerated are as follows. The BDA issues a notification on 30th January 2018 concerning site number 16 4th block MV layout for e-auction. The auction was conducted between 6/2/2018 to 20/2/2018. The result of the auction is the emergence of the petitioner as the successful bidder. The sum was declared to be 1,52,98,000 and called upon the petitioner to pay the balance amount within 45 days. It transpires that the petitioner did not pay any amount till the year 2020. On 4.
My lord, it is paid on 28/11/18, 53,021.
Or made a part payment only on 28/11/2018 and not the complete payment as was required in law.
To the
The
extent of
representation
60%.
of the petitioner then represents to the authority seeking extension of time or waiver of interest as the case would be. The representation comes to be rejected on 4/2/2020, which follows a cancellation order on 30th May 2020. The petitioner calls the said order of cancellation in question before this court in writ petition 2663 of 2021. The learned single judge, the coordinate bench of this court, in terms of its order dated 22/8/2022, sets aside the order of cancellation and directs the respondent BDA to consider the matter in the light of the observations made in the course of the order. The observations in the course of the order was that to collect the outstanding amount along with interest,
Relevant.
along with the applicable interest and pass necessary orders in accordance with law.
Within 30 days.
Within 30 days from the date of receipt of the copy of the order. The BDA does not comply with the order, but chooses to challenge it before the division bench in writ appeal 1081 of 2022. The writ appeal also comes to be dismissed on 9/12/2024, affirming the findings of the learned single judge. Therefore, the learned single judge, the next para. The BDA then sought to comply with the order but issues a demand notice demanding interest from 2018 till 2025, the date on which the demand notice was issued. The petitioner then makes the payment of interest even and challenges the same before this court. The learned counsel appearing for the petitioner would submit that the interest calculated for the pendency of the petitions both before the learned single judge and the division bench is calculated as interest to the interest and imposed upon the petitioner. The learned counsel submits for the folly of the petitioner for not paying the amount for 2 long years from 2018 to 20, he is ready to pay interest, but not for the subsequent period as it was as the allotment had been cancelled and the cancellation is set aside by this court. The learned counsel appearing for the BDA Vinayak Pandit submits that no fault can be found with the imposition of interest for the period throughout. At best, the petitioner may get relief at the period when the writ appeal was pending, as the BDA had chosen to file a writ appeal. He would submit that the petition be dismissed with the aforesaid observation, only with the aforesaid observation and not beyond, and is not entitled to any relief beyond what is submitted. I have given my so and so. The four narrated facts are not in dispute. The issue, as observed, lies in a narrow compass. The petitioner is an auction purchaser. The auction is conducted by the BDA on 30th January 2028. The
18.
28 2018 and the 2018. The petitioner was called upon to pay 1,52,98,800 within 45 days from 12/3/2018. The petitioner did not pay, but had represented to the respondent BDA to waiver of interest. The petitioner even then neither paid the interest nor the amount that was to be except payment of 53,000. This led the BDA to cancel the representation, reject the representation and pass an order of cancellation of allotment. The cancellation of allotment was challenged before this court in writ petition 2663 of 2021. A coordinate bench, in terms of its order dated 22nd August 2022, allowed the petition by the following observations, para 6 at page 48 to 50. The BDA was directed to consider execution of a sale deed in respect of the allotment to the petitioner in accordance with the rules, with applicable interest within 30 days from the date of receipt of the copy of the order. Therefore, the order of cancellation stood set aside, and which dates back to the order of cancellation, i.e. 30/5/2020. The BDA, next para, the BDA would choose to toss the order of the learned single judge before the division bench in writ appeal 1081 of 2022, which comes to be dismissed on 9th December 2024. Therefore, the date on which the petitioner prefers the writ petition, i.e. 11/12/2020, and the date on which the division bench dismisses the appeal, i.e. 9th December 2024, in the considered view of this court, cannot form the part of interest that is imposed for delayed payment on the petitioner. Next para. It would have been altogether a different circumstance if the petitioner had not succeeded before the learned single judge. Petitioner does succeed before the learned single judge. It is the BDA which challenges it before the division bench, And after 2 years of its challenge, the division bench rejects. Therefore, the pendency of the proceedings before this court from 11/12/2020 till 9/12/2024 cannot be a part of the interest that is levied, as it would it would run counter to the concept of the act of court shall prejudice no man. The act of court, I mean, the pendency of the petition from 11/12/2020 till its disposal before the learned single judge, and the pendency of the petition before the division bench. In that light, the order impugned, i.e. the demand notice, requires certain tweaking to be done, which shall be in the following manner. The petitioner is held liable to pay interest from the date on which he had to make the payment till 11/12/2020, and not any period beyond it till the date of making the payment. The learned counsel for the petitioner submits that he would have no objection to pay interest up to 11/12/2020. In that light, and for the aforesaid reasons, I pass the following order. The writ petition is allowed in part. The demand notice dated 12/2/2025 is set aside insofar as it includes the period between 11/12/2020 and 9/12/2024. The petitioner is held liable for payment of interest on delayed payment only for the period between the last date of payment that is demanded till 11/12/2020. The demand notice is modified accordingly. The BDA is directed to comply with the orders passed by the learned single judge in accordance with the aforesaid modification, with an outer limit of
8 weeks.
8 weeks from the date of receipt of the copy of the order.
25.
That's all.
Fresh matter, my lord. My lord, in 93, my lord, 1 acre 3 guntas of land has been acquired by the Muda belonging to petitioner, my lord. Due to lapse on the payment of compensation, my lord, father of the petitioner approached the Honorable Court for denotification of the land. The Honorable Court allowed the writ petition, my lord, declared that the land does not come in the acquisition notification, and directed the Muda to hand over the 1 acre 3 guntas of land to the petitioners.
That is in 2001.
2001, they issued endorsement by contending that as per the
endorsement when
endorsement page number 23, my lord. By contending that as per the order of the Honorable Court, the land in question 1 acre 3 guntas.
ಯಾವತ್ತು ಕೊಟ್ರೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್
ಅಲ್ಲ 2002 ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಫಾದರ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಅಪ್ರೋಚ್ ದಿಸ್
ಪರವಾಗಿಲ್ಲ, 25 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರು?
ನೋ ಮೋರ್. ಅವರ ಸನ್ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಇಬ್ಬರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಅಂಡ್ ದೇ ಯುಟಿಲೈಸ್ 12 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್, 31 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದಾರೆ. 12 ಗುಂಟಾಸ್ ನ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ರಿಟರ್ನ್ಡ್. ಇಸ್ ಆಲ್ಸೋ ಶೋನ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 24.
1 HCGP, 2 and 3 TP Vivekanand. Petitioner to serve set of copy the HCGP. Petitioner to serve set of papers upon the councilship TP Vivekanand for respondents 2 and 3. List the matter after 2 weeks. Please.
26.
Grapes 28/3 order.
Which was 19.1, which was dealing.
19.1, Jevai. Tag this petition along with serial number 19.1. I'll dealing ಮಾಡಿದೆ ಬೆಳಗ್ಗೆ ಇದಕ್ಕೆ ಅಟ್ಯಾಕ್ ಮಾಡಿ.
My lords, may please permit me. My lords, this is
the 28 ಅಷ್ಟೊಂದು ಮಾಡಿದ್ದೀರಾ?
All 900 acres are there in one order. And my lords, I'll clarify. I've noted, my lords, that annexion R13 is an order of the coordinate bench as regards his brother's petition. These are we had submitted the same copy before the learned single judge there as well, along with the original file where the preliminary and final notifications and all are there. My lords may note, in as much as 19.
He has participated.
I'll read out. He has participated. I'll pass it on after reading it. Lords, there is 3 columns, survey number and the objections. ದಿನಾಂಕ 24/1/22 ರಂದು ಪ್ರಕರಣವನ್ನು ಕೂಗಲಾಯಿತು. ಖಾತೆದಾರರು ಪಿ ಜಯರಾಮ್ ಪುಟ್ಟಸ್ವಾಮಿಗೌಡ ಎಂಬುವರು ಹಾಜರಾಗಿ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್, ದಿನಾಂಕ 28/1/2019 ವಿಚಾರಣೆಯಲ್ಲಿ there was another 19 ವಿಚಾರಣೆ. ಖಾತೆದಾರರು ಹಾಜರಾಗಿ ದ್ರಾಕ್ಷಿ ಬೆಳೆ ಬೆಳೆಯುತ್ತಿರುವುದರಿಂದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಒಪ್ಪಿಗೆ ಇಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. Now the consideration for that is, ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ, ಆಕ್ಷೇಪಣೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಈ ಜಮೀನು ಉದ್ದೇಶಿಸಿದ ಕೈಗಾರಿಕಾ ಪ್ರದೇಶ ಯೋಜನೆಗೆ ಅತ್ಯವಶ್ಯಕತೆಯಾಗಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಇರುವ ಆಕ್ಷೇಪಣೆಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಭೂಸ್ವಾಧೀನಪಡಿಸಲು ಆದೇಶಿಸಿದೆ. ನೆಕ್ಸ್ಟ್, ಪ್ರಸ್ತುತ ಸಾಲಿನ RTC ದಾಖಲೆಯೊಂದಿಗೆ ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಹೆಸರನ್ನು ನಮೂದಿಸಿ ಆದೇಶಿಸಿದೆ. Now my lords, I'll read out from the order of the coordinate bench. Why I'm reading out, I'll come to that as well. My lords, may I have
1.2 kilometers away ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದಕ್ಕೆ.
My lords, R13 of the
extent ಎಷ್ಟು acquisition?
40 meters.
I'll show.
ಅಲ್ಲ, extent ಎಷ್ಟು acquisition?
Total extent of 28(3) order made is 900 acres. Around, I'll read out.
So
719 acres.
719 acres.
719 acres. All of them are here only.
Whether it is 40 meters away or 1 kilometer away does not make.
More importantly, my lords, I'll read out why I'm same acquisition, his own brother's land, which must be abutting, my lords, 23 guntas. There is no dispute as regards that. The finding given there, my lords, it's a finding of the coordinate bench. Page number 86 of my
Has
statement.
become final?
Yes, my lords. No one has filed an appeal. Page number 86 of my statement of objection.
Yes.
Para 9, after all the arguments are noted. Running page number 86, my lords may have. Internal page number 25. The fulcrum of argument on para 9 I am reading, my lords, on
Yes,
the
sir.
right hand side at the bottom. The fulcrum of the argument on behalf of the petitioner landlord is that the special land acquisition officer has not considered the objections raised by the landowner subjectively, which is the mandatory requirement of section 2 and 3 of the 28 of the act, and having regard to the circulars issued by the state government. However, as rightly pointed out by the learned advocate general, this court in Srimati C.N. Sharda has considered the effect of 2 circulars issued by the state government. Circular, the lords, that 100 meter from the Grand Thana is a part of the circular. Circular dated 3/3/2007 and 18/3/2013, and held that in the second circular dated so and so, a brief background is given stating that in the matter of issuance of final notification under section 28(4) of the act, vast difference was found between the extent of the lands notified in the preliminary notification when compared to the final notification. Lands were being brought from the acquisition proceedings only on the ground that they are fertile agriculture or garden lands. In order to rectify the lacuna, circular dated so and so was issued. While clarifying that alone, some of the lands in the notification which were classified as temple, burial ground, school, playground, industries, sick industries, garden lands, fertile lands are notified. Nevertheless, they shall not be dropped from the acquisition proceedings if they are found to form an integral part of the layout and are necessary to maintain contiguity of the industrial area. I'll show the map, my lords, where the lands presently form. They are right in the center. My lords, I may be permitted to produce a map. The same map with the road I am showing, my lords. Next, I'll continue to read, my lord. Accepting the position, this court held that if the special land acquisition officer has rejected the objection with such observation, they cannot be faulted on the ground that SLAO has passed cyclostyled order without application of mind. For immediate reference, para 6 of the said order, which reads as follows.
Yes.
Now, my lords, the most important part. Para 10. Having regard to the said legal position, the learned advocate general has rightly pointed out to the factual aspects of this case, and in the sketch furnished by the respondent state and the KIDB, it is clear that 3 pieces of property 56/3, 60, 73 form an integral part of the layout now handed over to Messrs. Foxconn, and it would be impermissible to leave out the 3 pieces of land from acquisition. On the contrary, if the land in question are left out of acquisition, they would form a small island within the layout without access surrounded by the industrial area. Same is the case here. Similar is the facts and circumstances insofar as the other petitioners and their lands. They formed an integral part of the industrial area and cannot be left out from the acquisition. My respectful submission, my lords, is that his objection has been considered, his presence is noted, and then the SLAO says that it forms an integral part of the layout, and that is why it cannot be left out. Based on that, my lord, similar observation, the coordinate bench also. And here is a case, my lords, where I've already made an allotment. The allottee is now threatening to leave. I have filed the possession certificate at annexures also.
Yes, sir.
She can see at which my learned friend read the annexure R13.
Mic on ಮಾಡಿ ಇಲ್ಲ ನಿಮ್ ಜಾಸ್ತಿ ಮಾಡಿ.
Annexure R13. Now, in that case, it's not applicable to the case of the petitioner here. The lands involved in this said case not entirely different.
In this case,
entirely R16, different land survey numbers.
Right.
That the point involved in that case, that there were the 3 survey numbers, which were situated in the middle of the acquisition portion area.
Correct, sir.
That is the reason that survey 3 survey numbers.
I only wanted whether you have participated in the proceedings or not. You have participated.
Not, I have not participated. No, not participated.
Anything else, sir?
But in this case, this along with my rejoinder, I filed the photographs. First, the annexure H document, annexure H I produced. That this notice is
So,
issued.
mic hatra ಹೇಳ್- mic hatra.
Notice came to be issued on 4/6/2025. That asking the petitioner here to hand over the possession.
Correct.
Possession. Prior to that, Lordship may kindly see that the KDB contention is they have produced annexure R4. R4.
Yes.
Possession certificate, R5, possession certificate, issued in the year 2024, without obtaining the possession from the petitioner here. Procedure not followed. Without obtaining possession, they have issued possession certificate in the year 2024. Notice came to be issued in the year 2025 to the petitioner here to hand over the possession. That the notice annexure H clearly shows that as on 25. June, petitioner is in possession of this his property. The KDB has not obtained possession. That this is the document or annexure R5 is contrary to created.
ಆ ಪಕ್ಕದ ಕೊಟ್ಟಿದೆ ಇದ್ರದ್ದು ಆ ಕಡೆ ಪಕ್ಕಕ್ಕಿದೆ. Now this is
for Foxconn establishment.
ಅಲ್ಲ,
certain
ಆ survey
portion is
numbers
given.
ಬೇರೆ. 56, 60 ಆ ಸರ್ವೆ ನಂಬರ್ ಇಟ್ ಇಸ್ ಅಟ್ ಡಿಸ್ಟೆನ್ಸ್.
My lords, this is being given to
Clarification ಮತ್ತೆ argument.
1 kilometer distance ಅಲ್ಲಿದೆ ಅದೆಲ್ಲ.
1 kilometer.
1 kilometer distance ಅಲ್ಲಿದೆ ಆ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ. That lands are different, entirely different. The Lordship may kindly see that J1 photographs along with my rejoinder I produced my land situated near to the within 40 meters of the village. Next to my land there is the village AK colony. This land was granted by the deputy commissioner long back to the AK colony formation.
No problem, sir. Acquisition will not stop for all that.
That this is
Anything else? ಅದು ಕೊಡಿ. 28(3) ಕೊಡಿ.
28(3) order, my lords. My lords, one subtle last. ಅವ್ರದ್ದು ಹೇಳ್ತೀನಿ. One last feature of it. This is the file where the appearance, everything is noted. My lords, the petitioner himself files a request for compensation. My lords, compensation ಗೆ request ಕೊಟ್ಟಿದ್ದಾರೆ. Now he is, and all other documents, our Aadhaar card, property papers ಎಲ್ಲ ಕೂಡಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅವರು he is reciling and saying it is not his signature.
ಕೊಡಿ.
This is the petitioner or our brotherದು ಎಲ್ಲ ಇದರಲ್ಲೇ ಇದೆ ಹಿಯರ್ ಮಾಡಿರೋದು.
ಬ್ರದರ್ ಆಯ್ತು, ಇವ್ರು ಶುರು ಮಾಡಿದಾರೆ ಈಗ.
ಅವ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳಿರೋದು, ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಅವ್ರ ಆಧಾರ್ ಕಾರ್ಡು, ಆಮೇಲೆ ಅವ್ರದ್ದು ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಪೇಪರ್ಸು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂಡ್ ಇಟ್ ಇಸ್ ಗಿವನ್ ಇನ್ ದ ಟಪಾಲ್.
ನಿಮ್ ಬ್ರದರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ ನಿಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ವಾ?
ಅಲ್ಲ, brother has not challenged the acquisition proceedings. With respect to some other land he has challenged. That 63 and 64 survey numbers, not with respect to 67. That the last time I produced certificate.
67 extent ನಿಮ್ಮ ಮೂರು ಬ್ರದರ್ಗೆ ಏನೇನ್ ಬಂತು?
Some 23 guntas. 24 guntas.
In which survey number?
67.
23, 23, 23, 67.
ಹೌದು, 24 ಇನ್ನೊಂದು extent.
All right. ಇನ್ನೊಂದು extent 24.
ಹೌದು, ಟೋಟಲ್ 2 acres 16 guntas, 13 guntas.
ಇವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು ಯಾವುದು?
let's say 64,
ಎಲ್ಲಿದೆ ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲಿದೆ?
survey number, I produced Google map. along with
ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಲ್ಲ, ಚಾಲೆಂಜ್ ಯಾವ್ದು ಪಾಟೀಲ್?
ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಅದು ಸರ್ವೆ ನಂಬರ್ಸ್ ಏನು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. They are not stated.
Whether it is 63 or 64, ಎಲ್ಲ adjacent, forms a part of 700 acres.
ಅಲ್ಲ, ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ದೂರ ಇದೆ.
No, sir.
Last time I kindly seen that
Nothing doing.
Google
Yes.
map.
Yes, the petitioner, ಅವ್ರದ್ದು ಇನ್ನೊಂದೇನು? That's also part of the acquisition?
My lords may note that we have considered his objection also. In survey number 52/1 ಇದೆ ಅವ್ರದ್ದು ಅದರಲ್ಲಿ.
Not considered.
Last time I produced certain judgments. Last time now I
With the coordinate bench decision, no judgment is required.
Not coordinate bench, last time,
problem, sir.
last time I kindly seen that the annexure.
I am going to follow the coordinate bench judgment. That's all.
Last time his own my learned friend appeared in the annexure along with my rejoinder I produced. Division bench. Last time I kindly see
Which division bench?
Annexure M. Last time I kindly see along with my rejoinder. Circular issued by the state government was
A
appealed.
circular is considered by the coordinate bench. Anything else, sir?
This is the subject matter involved in the coordinate bench case entirely different from this case.
No, sir, I will
Last time I kindly see at page number.
No, Murali Babu.
That annexure M. Last time I kindly see at page number 33. Annexure M.
Yes.
Annexure M.
Page 33.
33 of annexure M. That 5.6. Para. Sri Venkateshappa, this court held that these said circulars contain the command for the authorities not to subject the lands categorized therein and the classified lands to be excluded from the acquisition. In this said case, the land was converted for non-agricultural purpose and garden land, and yet they were brought under acquisition. Learned single judge dealing with the said case set aside the acquisition which was confirmed by the division bench. Learned single judge in his judgment and order observed that the petitioners had not only obtained no objection certificate for change of land use and the conversion was permitted. The endorsement was suggested by that.
Judgment is that?
Let the division bench judgment. Let the
Name, party name ಹೇಳಿ.
The KDB only filed. This Venkateshappa.
Other consider ಮಾಡಿಲ್ವಾ ಅದರಲ್ಲಿ?
ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ. He himself filed this writ appeal. Even Supreme Court also confirmed the circular. Last time in annexure N, produced annexure N.
Of circular there was.
Division bench judgment confirmed Supreme Court.
Lords, there it did not affect the contiguity. The petitioner here is misleading the court. I would say, my lords, a map was shown, and here the 10 acres was abutting to the main highway. That is why the learned single judge there, my lords, had held that it doesn't affect the contiguity. You have to leave his land as per the circular. Here, a coordinate bench of this honorable court, considering similarly placed lands, has shown that this affects the contiguity, forms an island. I've read out the paragraph, my lords. Also, I'll produce a map and point out his land presently involved, which again forms an island. So can there be parity?
Main road, this is
Can there be parity between his land and the lands therein?
Not the issue. We'll follow the coordinate bench. Yes,
I find para number 6.1 last division bench order, division bench is one the KDB had filed writ appeal. In that it would be noticing law laid on in writ appeal number 461 of 2016 as above.
Coordinate bench decision has become final.
Please. There no appeal is filed.
It would appear that main ground of challenge against acquisition procedure initiated by the response is on the ground of non-application and prior to issue of notification under section 1(3) and section 3(1) of KAD Act. Due to failure to comply with the circulars dated 3/3/2007 and 18/3/2013 in WP number 17836 of 2013, this court has held that duty was cast on SLAO to submit report after spot inspection as contemplated under the circulars dated 3/3/2007 and the 18/3/2013. In writ appeal number 461 of 2016, a division bench of this court rejected contention of the respondent that circular would not have statutory flavor.
Which is a subsequent circular 18/3.
18/3 was a subsequent annexure. They have produced annexure R 14 along with their statement of objections. My land falls under the guidelines of 4 and 5. ಆಯಕಟ್ಟಿಗೆ ಧಕ್ಕೆ ಉಂಟಾಗದಂತೆ ತೋಟಗಳು,
ಆಯಕಟ್ಟಿಗೆ ಧಕ್ಕೆ
ಫಲವತ್ತಾದ
ಉಂಟಾಗದಂತೆ.
ಜಮೀನು ಹಾಗೂ ವರ್ಷಕ್ಕೆ 2 ಬೆಳೆ ಬೆಳೆಯುವ ಜಮೀನುಗಳು, ತರಿ ಜಮೀನುಗಳನ್ನು ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಹೊರತುಪಡಿಸುವುದು.
ಆಯಕಟ್ಟಿಗೆ ಧಕ್ಕೆ ಆಗುತ್ತೆ.
ಗ್ರಾಮಠಾಣದ
That is the logic.
ಸರಿಹದ್ದಿನಿಂದ ಗ್ರಾಮದ ಸುತ್ತಲೂ ವಿಸ್ತರಣೆಗಾಗಿ 100 ಮೀಟರ್ ವ್ಯಾಪ್ತಿಯ ಜಮೀನುಗಳನ್ನು ಹೊರತುಪಡಿಸುವುದು. But in this case, my land situates within the land 40 meters from the Gram Thana limit.
R14 ಅಲ್ಲ ಅದು?
I produce that
R14.
R14.
And this
Produced by the
division,
KDB.
my lords, and this division bench order 28-4 had not happened, only 28-1 had happened.
28-4 only.
ಇದರಲ್ಲಿ 28-4 ಆಗಿರ್ಲಿಲ್ಲ. ಅವ್ರು ಏನ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಸೈಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ 28-4 ಆಗಿರ್ಲಿಲ್ಲ.
Which is the division bench?
My lords, they have produced an annexure M.
Annexure M, rejoinder ga?
Rejoinder annexure M.
ಅದರಲ್ಲಿ ಅವರು ಚೇಂಜ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಯೂಸ್ ತಗೊಂಡಿದ್ರು. They had taken change of land use. Final notification was not done and the entire patch was abutting to the main highway. Considering this, they said that you will have to delete it, not on the ground that SLAO has not followed the circular,
My land also.
but
same
on the
situation.
ground
My
that
land also abutting to the main road.
Wait. Oh, 28-1 ಮಾತ್ರ.
28-1 matra and para 3 may be seen, my lords. They had taken the change of development, they had entered into a joint development agreement with someone and 4 agirlilla. And only ground on which it was quashed was to the effect, my lords, that we had to do a survey first and then find out whether these are suitable for acquisition or no.
Supreme Court ಗೆ ಹೋಗಿದ್ರಾ?
Supreme Court ಗೆ ಹೋಗಿದ್ರು.
Annexure N I have produced that circular confirmed upheld by the Supreme Court, not interfered.
Even now my argument is circular are binding on us, my lords, but in this case it affects the contiguity is my respectful submission. And circular, as my learned friend only read out, it clearly says ayukattike dhakke agadante, and that is what the coordinate bench also observes, saying that if we delete this they'll form islands right in the center of the acquisition.
Yes, sir.
That I produced along with memo citations, the division bench of this honorable court in WP number 36638 of 99. Lordship, I kindly. In that case also my learned friend only appeared before the division bench and Supreme Court also. That at page number 9 of the judgment, along with memo today I produced.
Yes, sir.
What is it? Division bench judgment, my lord. That is the 7th judgment.
In the records,
Lords, the 28-3 order is right there, my lords. And this is the file maintained as regards the petitioner.
ಕೇಳಿರೋದಲ್ಲಿ
ಅದು side flag ಹಾಕಿದ್ದಾರೆ. That is the one. And he has given his Aadhaar card and all the other documents regards the land. And it is given in the invert tapal, my lords, not that we have generated it. And we have judgments to say that he cannot approbate and reprobate, my lords.
Sorry. Let it be with me.
Please. And the 28-3 orders also, my lords, may.
28-3 order ಯಾವುದು?
ಇಲ್ಲಿ ಮುಂದೆ ಇದೆ ಇಲ್ಲಿ. There is a full compilation. All joint orders.
ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಕೊಡಿ.
ಅದರಲ್ಲಿ there is the side flap, my lords. Side one is 52/1 is second one, and this is 67/1.
Lords, with respect to 52.
I'll get back to you. Wait, please.
Survey number 67/1.
67/1.
My lords, only 67. Sorry. The name of the petitioner figures, my lords, there.
P. Jairam.
P. Jairam.
First preliminary notification it was there. Final notification my name was left out.
That I have filed.
Final notification ಯಾಕೆ
ಇಲ್ಲ ಅದು ಒಂದು ಇಂಟರ್ನಲ್ ಆರ್ಡರ್ ಕರೆಕ್ಟ್ ಮಾಡಿ ಅವರಿಗೆ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದೆ.
Why you gave up?
My lords, it got deleted and then we sent a corrigendum notification. Government said you don't have to do a corrigendum notification. There is a circular by us which says that when you are considering him for compensation, you can consider any interested party. I've filed it all in terms of my statement.
Which
of objection.
circular is that?
My lords, I'll show. My lords, annexure R10 of my statement of objection.
This, the coordinate benches, that also was given up in the final notification.
Which one, my lords?
For just Devdas sir ಮುಂದೆ ಇದ್ದಿದ್ರಲ್ಲಿ.
It was not deleted, my lords.
It was there, it was not deleted.
No, my lords.
ಇವ್ರದ್ದು ಲ್ಯಾಂಡ್ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಇರ್ಲಿಲ್ಲ. ಅಲ್ಲೂ ಅದೇ ಸಿಚುವೇಶನ್ ಅಂತ ಕೇಳಿದೆ.
ಅದರಲ್ಲಿ ಇತ್ತು, my lords. No, I'm not able to understand what my lords are
Now
saying.
he says his land was given up in the final notification.
No, his land was not given up. His name was not there is what he's saying.
Name was not.
No, name was not
The
there.
land also not acquired, my lord. 1 acre 11 guntas was acquired. 2 acres 13 guntas, entire the land was not
ಅದಕ್ಕೆ circular
acquired.
ನೋಡ್ಬೇಕು. Circular ಅಲ್ಲಿ we have said
Both
that
the notification. Last time,
his name should be included ಅಂತ ಹೇಳಿದ್ದೇವೆ.
Lord, very same bench. I produced the lord, very same bench, lord. Lord, in the year 2020, lord, 34033, last judgment of my, along with my say memo, I produced at para 10. In similar circumstances, my lord, very same bench. Following the circular, my lord, 18/3/2013, notification came to my lord, quashed. Memo with judgments, my lord, produced.
Yes, sir.
Today memo, last judgments.
ಅಷ್ಟೇನಾ?
ಅಲ್ಲ ಇವತ್ತಿನ ಮೆಮೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ ತಾವು ಲಾಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಲಾಸ್ಟ್ is a very same bench, lordship, in WP number 34033 of 2019, right at para number last 10, following the very same circular. At this juncture, learned counsel for the respondents has brought to the notice of this court that there was an earlier circular dated 3/3/2007, which was an earlier, which was almost of the same content as found in the circular dated 18/3/2013 with minor changes. However, even if it is accepted, the circular dated 18/3/2013 was issued subsequent to the preliminary notification issued in the case on hand. It cannot be ignored that there was a circular dated 3/3/2007 which was holding the field. Even otherwise, as on the date when the order under section 23 was passed by SLAO, the instructions issued by the state government should have been considered by the SLAO, since the petitioner may not have been aware of the circular, but it was definitely within the knowledge of the SLAO. 11, para number 11. Having regard to the above said aspect, this court is of the opinion that the order passed by SLAO under section 28(3) is not in a consonance with the circular issued by the state government, which
Yes,
should,
Mulliba,
which,
reserved, yes.
Deeply obliged.
ನಿಮ್ದೇನ್ ಹೇಳಿ?
one more judgment, last kindly,
Yes, yes.
division bench judgment, Supreme Court judgment, last kindly,
Annexure M.
ಅಲ್ಲಲ್ಲ separate ನಾನು ಮೆಮೋಸ್ ಕೊಟ್ಟಿ ಮೆಮೋ ಜೊತೆ
Kenchappa's
ಕೊಟ್ಟಿದ್ದೀನಿ.
judgment
Last
says you have to take
last-
environmental clearance.
last-
ಒಂದು ನಿಮಿಷ ಕೊಡಿ.
We have taken environmental clearance for this
Last
entire
week.
thing. I can put it on record.
Today's memo.
Today's memo, today's
Division bench judgment,
page number.
page number, the citation number 7, my lord, 3.
Page number.
There is no page
Page
number,
number.
lords. There is in the serial number, it is on the 7th.
Reported judgment.
C. Kenchappa.
Kenchappa case.
Division bench. already.
Division bench at page number, last may kindly, 9, page number 9. On the basis of the allegations, counter allegations made in the pleadings, the first point that arises for consideration is what is the importance of.
The whole problem is coordinate bench, Murli Babu.
ಅಲ್ಲ coordinate bench ಅಲ್ಲಿ ಅಲ್ಲ ನಮ್ಮ land is not involved in the subject matter of that the writ petition. ಅಲ್ಲ ಅದರಲ್ಲಿ
Lords, the reading of the circulars also.
ಅಲ್ಲ.
Reading of the circulars.
ಇವ್ರದ್ದೇನ್ 52 ಬಾರ್.
ಅವ್ರದ್ದು ನಾವು objection consider ಮಾಡಿದ್ದೇವೆ.
What's your ground, sir?
52/1 ಅವ್ರದ್ದು.
They have not
Objections not considered, ಅಷ್ಟೇನಾ?
peruse the interior modern millets.
Interior model ಕೊಡಿ.
Your Lordship has got it.
Yes.
My lords, second paragraph. I may be permitted to read, my lords.
Counsel for the petitioner drawn attention to this court raising.
Learned counsel for the petitioner
Has been cultivated and is a fertile land, moreover. Arkavati River.
It is situated near the
Ethinamale
catchment area.
project and near vicinity of one of the reason main industrial cannot be established in question. No, nothing.
However, nothing is said in respect of these objections.
Have you filed your objections here?
I have filed, my lords, and also his survey number consideration also in the 28-3 order, I flagged it.
No, but what is the observation of the
Lords,
coordinate bench?
My lords, may I place the coordinate bench decision?
Dispose ಆಗಿದೆಯಾ?
ಅದು dispose ಆಗಿದೆ.
All of that WP 19613 ಏನದು?
Please, my lords. Your Lordship may kindly come to page 10 of the page 11, my lords. I'm sorry, my lords. Para 9, my lords.
Page 11.
Thus, Your Lordship has got page 11, para 9, my lords. Let's say, thus, in the light of the aforesaid directions, it is clear that process of consideration of objections does not mean mechanical perusal of the record.
That's all right. Don't worry about that. Yes.
My lords, Your Lordship may kindly come to the order, my lords.
Page
25 of the writ petition.
I filed the full order, my lord.
1 minute. 25. Yes, 25 line.
ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದೆ. ವಿಚಾರಣೆ ಖಾತೆದಾರರು ಗೈರು ಹಾಜರಾಗಿರುವುದರಿಂದ
ಯಾವ್ದಿದು? 52/1.
52/2.
In each objections, yes.
It forms a part of the main
ಇವರು
group we have filed.
ಏನು ಇಲ್ಲವೆಂದು ಪರಿಗಣಿಸಿ ಈ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನ
Objection ಹಾಕಿಲ್ವಾ ನೀವು?
ಹಾಕಿದ್ವಿ.
ಎಲ್ಲಿದೆ?
Lordship may kindly come to page 37 and 38. We have filed twice, my lords, because the notice was issued twice.
Object ಮಾಡಿದಿರಲ್ಲ?
Page 37 and 38, my lords. They have not considered the.
1 minute. Come to page 25.
Please.
52/1. ಗೈರು ಹಾಜರು ಆಗಿದ್ದಾರೆ ಒಂದು. ಇವರ ಆಕ್ಷೇಪಣೆ ಏನು ಇಲ್ಲವೆಂದು ಪರಿಗಣಿಸಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಲು ಆಕ್ಷೇಪಣೆ ಹಾಕಿಲ್ವ ಇವರು?
Lords, they claim that they have filed, but they have filed at an earlier point in time. The hearings happened in 22. Fresh notice, my lords, this
19 sir ಇದು.
They have filed it at an earlier point in time. That is why, my lords.
Well, that doesn't mean that we should consider it.
We should consider it, my lords. But still they have said that ಕೈಗಾರಿಕಾ ಪ್ರದೇಶಕ್ಕೆ ಬೇಕಾಗಿದೆ, even this forms an.
ಹಂಗಂತ you don't have to consider any objection so filed. Not for nothing they would want their properties to be protected. Original file ಎಲ್ಲಿದೆ ಈ ತರ?
ಅದರದ್ದು
28-3
order ಅಷ್ಟೇ ಇದೆ. 28-3 order.
ಇವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ?
My lords, it's at page.
My lords,
Picture D, my lords.
ಅಲ್ಲ date
one more subtle issue. In the connected matter, they have only challenged 28-4.
That's all right. We will write separate orders.
No, separate order ಇದ್ರೆ ಅವ್ರು ರಿಮಾಂಡ್ ಮಾಡಿದ್ರೆ ನಾನು ಫ್ರೆಶ್ ಆಗಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀನಿ. ಅವ್ರು 28-1 ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
Page 35, page number 35. This is the first notice. 12/7/2010.
35. First notice, this is 12/7/2010.
Yeah.
Please, this issue also is considered by the coordinate bench. This issue also is considered by the coordinate bench. There is a
second notice is 15/12/2008. 18. So to both you have filed your objections?
Please, my lords. The first objection was filed on.
ಅಲ್ಲೂ ಹೇಳಿದ್ರು 9/6/2010 and yes. That's the only ground.
Please, my lords.
No, only subtle issue I want to point out is he has not challenged the preliminary notification.
That doesn't.
So the whole acquisition cannot be dismantled.
That doesn't mean that you have to consider. You should not consider.
No, I'm not saying that, my lords. At worst, my lords, his only final notification could be quashed, asking us to reconsider us. We'll consider it, my lords.
My cases are the same.
Both. Yes.
My cases also, my lord, 28-3 not, my lord, considered, my lord. I have challenged it.
Deeply obliged.
Nimdu, your problem is your brother.
Allah, fully, my lord, the judgments produced today, my lord, is covered by the case of the petitioner's herein. We'll see. My lord, they
Obliged,
have
my
not
lord.
considered, my lord, the.
Reserved, next.
Deeply obliged.
Deeply obliged.
27.
Please.
Jimmy.
ಅದೆಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ನಮ್ಮ. Please, this application they had sought minutes for consideration under section 38D now. Lords had asked me to take instructions.
Yes, sir.
But they have not submitted applications under
Yeah,
38D.
Sadashivanagara.
Please.
Bhupasandram.
If they
We
submit
are,
their
in fact, my lord, I
applications.
said last time that we are good with, my lord, the BDA taking an inspection to find out the exact occupation, my lord.
Yes, sir.
The BDA come for an inspection.
They have to file necessary application under section 38D. If they file it, my lords, if they are eligible, it will consider it in accordance with law. My lords may fix a time frame to that effect.
38D.
38D. They have to submit proper
ಆಯ್ತು
application.
ನೀವು application ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀವಿ 17/8/2016.
ಎಲ್ಲಿದೆ?
Last time index of
That's
documents.
rule is of the year 2020.
Application.
ಇನ್ನೊಂದು ಕೊಡ್ತೀವಿ.
38D ಹೆಂಗ್ ಕೊಟ್ರಿ 2016 ಅಲ್ಲಿ?
ರೀಅಲಾಟ್ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ. ನಮ್ಗೆ ಕೊಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ. That's the reason, my lord.
Heard the learned senior counsel. The petitioner is before this court seeking the following prayer. Heard the learned senior counsel M. S. Shamsundar appearing for the petitioner and counsel Shri Ajay Kumar. The learned counsel will say that you are restricting your prayer to 38D.
38D.
The learned senior counsel, after arguing the matter at length, would restrict his prayer for the BDA to consider the case of the petitioner, qua the land, in terms of section 38D of the act. Learned counsel Ajay Kumar submits that the earlier representation submitted was in the year 2016 seeking reallotment, and the rule and 38D comes into force only in the year 2020. And therefore, if the petitioners are wanting their land, wanting the case to be considered under section 38D, a fresh representation must be submitted.
Application.
A fresh application in the prescribed format should be submitted. The learned senior counsel would accept the same and seek 4 weeks' time.
4 weeks time.
4 weeks' time to submit the application seeking benefit under section 38D. In the event the said application is preferred within 4 weeks from today, the BDA shall take a decision thereon within 12 weeks.
Please, we'll consider.
Within 12 weeks thereafter.
I'm told there is a direction, there's a coordinate bench has passed a direction, not that it's 1 year, it's what has been prescribed.
1 year, all right. Within an outer limit of 12 months from the date of submission of the application.
Please.
The decision so taken shall be communicated to the petitioner. Any other document that is necessary from the hands of the petitioner, the BDA is at liberty to seek any other document from the hands of the petitioner if needed.
Please. Till then, my lord, the protection may kindly.
What protection?
Till
Till then, don't take JCB. Yes.
My lords may kindly say that. Otherwise, my lord, entire effort will be rendered, my lord.
Let them submit their application.
We will do that,
automatically
my
it will
lord.
come
We'll next 4 weeks, we'll, my
Let them
lord.
submit their application.
The respondent BDA shall not precipitate the matter till the consideration of the application.
Greatly obliged.
Yes.
Greatly.
58.
Not appear for petition in this case. The petitioner has purchased the BDA site number 278 measuring 2030 in the year 2018. But the site was originally allotted.
Learned counsel Ajay Kumar is directed to accept notice for respondent 1 and 2, the petitioner to serve set of papers upon the aforesaid counsel, lest the matter on 12th August. Instructions be sought by then. Yes,
Please.
next.
29.
Petitioner in this case, my lords. Lords, I have filed the writ petition for rectification of the name in the sale deed, my lords. We have in the name of Mrs. Secular Education Society. It is in the name of secretary. Secretary dies. So we have
Learned counsel Poonam Patil is directed to accept notice for the respondent's petitioner to serve set of papers upon the aforesaid counsel forthwith. Less the matter, same 12th August.
Much.
Next.
30,
On the last occasion, your lordships had directed the petitioner to implead the other LRs.
I have impleted, my lord.
ಎಲ್ಲಿದೆ?
I have written and also I am filing amended writ petition.
Learned counsel for the petitioner submits that he has filed an application seeking impleadment of the other legal representatives and also filed an amended petition. In that light, yes, now.
Lordships may kindly grant me a week's time. I shall verify from the allotment file.
List the matter on 5th August.
Obliged.
Verify what?
Next.
34, 31,
Last time they have inspected the site and they have said that it is in question.
We'll take it on 5th August, yes. ಬೇರೆ ಇನ್ನೇನು ತೊಂದರೆ ಕೊಡ್ಬೇಡಿ. Site inspection ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ. Please, you wanted them to come on record ಅಷ್ಟೇ. Yes, Vachan. They are already on records. Amended petition ಆಗ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ 5th August. List on 5th August. ಏನದು? Counsel for the petitioner files an amended petition, the same is taken on record. ವಕಾಲತ್ ಕೊಟ್ಟಾಗಿದೆ, ಇನ್ನೇನು ವೆರಿಫೈ ಮಾಡಿ. 5th August, yes.
31,
My lord, I am appearing for the petition in this matter, my lord. My lord, writ of mandamus for change of land is concerned.
The change of land use.
Change of land.
The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is said to have acquired the land bearing survey number 23/4 and 30 to the extent of 36.5 guntas as averred in the petition. The petitioner then submits an application to the third respondent seeking change of land use and the said on 13/3/2025. The said application is pending consideration at the hands of the concerned at the hands of the respondent, third respondent. The non-consideration of the said representation is what has driven the petitioner to this court in the subject petition. The learned counsel Murugesh Charati, appearing for the respondents, would submit that if reasonable time is granted, the application of the petitioner would meet its consideration in accordance with law and appropriate orders would be passed thereon. In the light of the said submission, without going into the merit of the matter, I deem it appropriate to dispose the petition, directing the respondent, third respondent in particular, to pass necessary orders on the application so submitted by the petitioner on 13/3/2025 within an outer limit of 12 weeks, 8 weeks.
12.
I mean, the outer limit of 12 weeks and communicate the decision so taken to the petitioner, ordered accordingly.
Obliged.
32,
My lord, in this matter, 2 survey number was involved in this case, my lord. My lord, my lord, 2 survey numbers was there. In the
Whatever, prayer ಏನಿದೆ ಅದು sir.
Obliged.
32. Then electricity ಇಲ್ಲ ಏನು ಕಟ್ ಮಾಡಿದಿರಂತಲ್ಲ.
My lords, we have not formed the layout. Builder has formed the layout.
Correct.
Now kindly
The
see.
BDA has to pay everything ಅಂತ ಇದ್ದಾರೆ.
ಇಲ್ಲ. My lords, kindly see 28A of BDA Act.
28A ಅದನ್ನೇ
Yes.
ಹೇಳಿದೆ.
My lords, 28A comes into picture only insofar as when the BD has formed the layout. Tax is concerned is an independent provision, which
Correct.
is not circumscribed by the section 28A of the Act.
Hmm.
Tax is concerned 28B. The starting word is
So ಇದು
notwithstanding anything.
28A ಪ್ರಕಾರ you have to pay ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
No. My lord, 28A prakara, what they are saying is that we should maintain the streets. As per section 28A comes into
Maintenance
picture.
of streets, electricity, water, everything you have to pay.
No. The reason is this, my lords. Now kindly see, my lords, the writ petition annexures, that is relinquishment deed. The condition imposed is that my lords would find it at page number.
ಆಯ್ತು, ಅವರೆಲ್ಲ ಬಿಡಿ, ಅವ್ರು ಇಲ್ಲದೆ ಇದ್ದಾಗ ಕೇಳೋದು ಬೇಡ. Yes. No representation by of the petitioner, list on Friday. Yes, next.
33,
CH mode.
The 3 property Malad has been acquired. In survey number 12/2, 3 acre 35 guntas. And in survey number 56/4,
Compensation
5 guntas.
not to release.
Malad not to release because Malad the suit is for partition and for separate portion.
When
is
was the
pending.
suit instituted?
Malad suit has been issued 2022 Malad.
Acquisition?
Malad acquisition is of Malad 2010 Malad.
ಮತ್ತೆ ಈಗ suit
Now
institute.
Malad, no Malad.
Yes, sir.
Now my lord, as per the order of this court, my lord, in the earlier writ petition, my lord, the respondent number 4 has filed the writ petition, my lord, seeking for setting aside of the general award. The court holds that, my lord, while passing order, my lord, annexure, my lord, L, ink page number 78, 77.
ಕ್ಲೇಮ್ ಎಷ್ಟು ಅದರಲ್ಲಿ ಎಲ್ಲ ಯಾರಿಗೂ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಬಾರದು ಅಂದ್ರೆ will it not be
My lord, now, my lord, the courts, my lord, while allowing the writ petition.
partition suit ಪ್ರಕಾರ
Allena earlier, my lord, when he filed a writ petition before this court seeking for setting aside of, my lord, the general award, the court holds that, my lord, as per section, my lord, ink page number 78, but it needless to state that in the event the petitioner failing to provide necessary document to establish his ownership over the lands in concern, or if there is any rival claim, the general award stands to restored. Or earlier. Now, my lord, by way of, my lord, the consent order,
For the board, my
award,
lord.
they are going to, my lord, release the entire amount. Though, my lord, the suit is pending. Instead of, my lord, the making all these family members, he only, my lord, he challenged before this court.
ಈಗ ನಿಮ್ದು ಎಷ್ಟು ಶೇರ್ ಸರ್ ಅಲ್ಟಿಮೇಟ್
My lord, share as per, my lord, the suit, my lord, 1/10, my lord. 1/6.
ಅಷ್ಟು ಬಿಟ್ಟು ಕಾಂಪನ್ಸೇಷನ್ ಎಲ್ಲ ಕೊಡ್ಲಿ ಬಿಡಿ ಎಲ್ಲಾರ ಕಾಂಪನ್ಸೇಷನ್ ಯಾಕೆ ನಿಲ್ಬೇಕು
But now, my lord, earlier, he is also party to the, my lord, the suit. He did not brought before, my lord, while passing an award.
Yes, sir.
Though,
the
while pass.
1 minute.
I have to seek instructions, my lords, in this matter.
Who are you representing?
For the board, my lords, 1 and 3.
Learned counsel so and so accepts notice for respondents 1 and 3. ನೀವು ಯಾರಿಗೆ ಗವರ್ಮೆಂಟ್ R1 R2 R2 HCGP 1 and 3. What's your name?
Sharan Sabrad, my lords.
Counsel Sharan Sabrad accepts notice for R1 and 3. 4 yaru? 4 yaru?
But he is, my lord, he is the party, my lord, he has sought for, my lord,
The petitioner shall serve the 4th respondent by way of hand summons and file an acknowledgement of such service by the 25th.
Or respondent number 5 is made as a bank manager as a party.
List the matter on 1st August. On preliminary hearing.
Still such.
In the
period, my
event
lord, as
the
per-
petitioner would not make efforts to serve the 4th respondent by way of hand summons, the interim order now granted would stand automatically vacated. Till the next date, the respondent shall not disperse compensation.
My lord, on the other hand, I may permitted to take out through court also.
No, no. Hand
But
summons-
since, my lord, if he is not, my lord, he is refused,
Affidavit,
then.
affidavit
Please,
ಹಾಕಿ
please,
ತಗೊಳ್ಳಿಲ್ಲ.
please.
Yes, next. ಹಂಗಂತ ಕೊಡ್ದೇನೆ affidavit
No, no, no,
ಹಾಕಿದ್ರೆ-
man, no, man.
Next.
34.
Here for the petitioner. There's a fully developed project. There, my lord, they want to acquire for the purposes of a toll plaza, cutting into all our buildings. Please see page 221.
Toll plaza ಮಾಡ್ಬೇಕಂತ.
Toll plaza, my lord, both sides there's land which is free. But this, the place where they want to acquire, please see page 221. The map, the sketch, my lord.
Who's the acquiring authority?
BDA, my lord. And for last 3 years, they've not done it.
1 minute.
221.
We will serve on Ajay Kumar. I'll
Yes.
take it day after tomorrow.
Wait.
Heard the learned senior counsel, Dhyan Chinnappa, appearing for the petitioner. The learned senior counsel submits that the BDA wants to acquire the lands of the petitioner while leaving away the vacant lands for the establishment of toll plaza. The learned counsel, the advocate on record shall serve requisite set of papers upon the counsel Ajay Kumar. List the matter day after tomorrow on Thursday. Yes. Or let be on Friday.
35.
List on Friday.
Seeking mandamus to consider my representation as per annexure A. I am the notified
First time
Tahsildar.
I'll come. Petition, learned counsel Pachal Pradeep Kumar is directed to accept notice for the second respondent or HCGP 1 petitioner to serve set of Kotidara.
Kottila, sir.
Petitioner to serve set of papers upon the aforesaid on the counsel Pradeep Kumar forthwith. List the matter on 1st August. Yes.
Great.
ಅವತ್ತು ನೋಡಿ ಡಿಸ್ಪೋಸ್
ನೋಡ್ ಮಾಡಿ.
You want 5th August ಹಾಕ್ಲಾ?
ಇರ್ಲಿ ಫಸ್ಟ್.
ಆಯ್ತು, first August, yes.
Today only I will serve the copy.
Yes, next.
Next is general award.
General award, ಕೊಡಿ. Order.
ಇದರಲ್ಲಿ they want lord the developed land lord also. It is already there. Your lordship order. Same with it.
Same order.
Same.
Madam, general award, same order. Disposed.
37.
Lord, appear for petition in this case. This only a mandamus to consider my representation for execution of absolute sale deed in respect
PDA,
of
no?
the site allotted.
Learned Counsel B. Vachan is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid council forthwith. List on 5th August. Yes, next.
58.
Bit of mandamus, my lord.
Mandamus.
Mandamus.
This is
Krishna?
suppressing the writ petition, in the facts they filed the writ petition, my lord. They are-
Objection ಹಾಕಿ ಹಾಗಾದ್ರೆ.
ಅಲ್ಲ, this is covered by your lordship, the judgment in the division.
ಈ
bench.
order ಆ? ಹೌದು. ಕೊಡಿ.
My lord, he is the subsequent construction made in the land in question, my lord. And
ಶಿವರಾಮ್ ಕಾರಂತ ಇದು.
Pardon?
ಶಿವರಾಮ್
Yes,
ಕಾರಂತ.
yes.
We are not parties to this.
ಪರವಾಗಿಲ್ಲ.
ಇದರಲ್ಲಿ
ಯಾಕಂದ್ರೆ
his building
ಅಲ್ಲ
is
ಸ್ವಾಮಿ,
also
ಇದರಲ್ಲಿ
con-
ಮನೆ ಎಲ್ಲ ಕಟ್ಟಿದೀವಿ, ಎಲ್ಲ ಮಾಡಿದೀವಿ. ಇವಾಗ
ಯಾವಾಗ ಅಂತ
2018 ಸ್ವಾಮಿ.
ಇಲ್ಲ ಇಲ್ಲ, subsequent
18.
2000
ಹೌದು ಸ್ವಾಮಿ. We have produced a document before this electric.
2021.
May kindly peruse at annexure C1, my lord.
ಗೂಗಲ್ ಮ್ಯಾಪ್ಸ್ ಅಲ್ಲಿ ಈ ಮನೆ ಎಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ. ಗೂಗಲ್ ಮ್ಯಾಪ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಗೂಗಲ್ ಮ್ಯಾಪ್ಸ್ ಆಫ್ ದಿ ಟೈಮ್ ಸ್ಟಾಂಪ್,
Yes,
time and date stamp.
yes.
The learned counsel K. Krishna is directed to place on record the Google Maps images of date and time stamp of the construction in the lands belonging to the petitioner, as it would steer clear the controversy. He would further place reliance upon the judgment rendered by the division bench in so and so. List the matter on 5th August.
Interim order maybe.
ಇದೆಯಾ? List the matter on 1st August. ಆಗುತ್ತೆ ಅಷ್ಟರಲ್ಲಿ?
ಆಗುತ್ತೆ.
Yes.
My lord,
Interim order subsisting will continue.
my lord, name of Vasant is.
ವಸಂತ್ ಹೇಳ್ಬೇಕಾ? ವಸಂತ್
Vasant
ಇದಾರಾ?
Authorized. Yes, I am appearing on this.
ವಸಂತೇ ಇರೋದು?
ಹೌದು.
ಹಾ.
ತಾವು
ಓ, ಇಲ್ಲಿ ವಸಂತ್, ಆಲ್ ರೈಟ್. ಅಲ್ಲಿ ವಸಂತ್ ಅಂತ ಮಾಡಿ, ಕೌನ್ಸಿಲ್ ವಸಂತ್.
ಆಯ್ತು.
ಕೃಷ್ಣ ಬದ್ಲು. ಎಸ್.
39.
Last patient, government advocate was directed to take notice.
ಏನ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ? ಹಾ
Developments have taken place.
ಹಾ
The SHA government has taken the status of the ADB, whose benefit the land was acquired.
ಹಾ
They have put in portion land back.
ಹಾ
They are supposed to pay the.
ಅಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್ ಯಾರು ಕೊಡ್ಬೇಕಲ್ಲ, ಇವು ಹಂಗೆ ಯುಟಿಲೈಸ್ ಮಾಡಿ.
ಕೊಡ್ಬೇಕು. There is no dispute, I am not on that.
ಎಕ್ಸಾಕ್ಟ್ಲಿ.
Just say with seek inspection, take submission. 2 weeks.
ಆಯ್ತು.
The KADB approached this honorable court long back and please.
Once file his objections,
Okay,
exactly.
That you are entitled to receive, sir.
But what
Okay.
else? Yes.
We are here to help you. Just say.
Thank you very much.
Learned Additional Advocate General Shri Devdas would seek 2 weeks' time to file necessary, to file objections as after the order dated, order of the board, as after the communication dated 8/11/2022, there are several subsequent developments. While the learned Additional Advocate General would accept that the compensation has to be paid, in what manner is what he would file his objections. In that light, list the matter on 6th, 5th August, Saka 12th August Akla. List the matter on 12th August at 3:30 PM. for the
Oh, please.
Yes.
40.
Hearing for the petitioner, my lords, mandamus.
ಯಾವುದು ಮೇಡಮ್ ಇದು?
My lords, seeking for disposal of the trial court matter.
CMCPC na?
ಹೌದು, my lords.
Yes.
My lords, ನಾನು ಫೈಲ್ ಮಾಡಿದಾಗ ಪೆಟಿಷನ್, ಇಟ್ ವಾಸ್ ಆನ್ ಸೇಮ್ ಕೋರ್ಟ್ ಫೀಸ್ ಅವ್ರ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಹಾಕಿದ್ರು ಡಿಫೆಂಡೆನ್ಸ್. ಇಟ್ ವಾಸ್ ಆನ್ ಸೇಮ್ ಸ್ಟೇಜ್ ಫಾರ್ 8 months. And this is not the first suit. There are other suits which have been disposed.
Pending on the file within a time bound frame. But suit is of the year 2022, madam.
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ದೇರ್ ಇಸ್ ಅ ಹಿಸ್ಟ್ರಿ ಬಿಹೈಂಡ್ ದಿಸ್. ಇದು ಫಸ್ಟ್ ಸೂಟ್ ಅಲ್ಲ, 2012 ಇಂದಾನೆ ಹಾಕೊಂಡ್ ಬರ್ತಾ ಇರೋ ಸೂಟು.
Which is that suit?
ಮಹಾರಾಜ್, ಆ ಸೂಟ್ ಬಂದ್ಬಿಟ್ಟು
The petitioner, you are the
plaintiff.
plaintiff, huh?
ಹೌದು ಮಹಾರಾಜ್, ಫಸ್ಟ್.
The petitioner is the plaintiff. He is at the doors of this court seeking a direction for expeditious conclusion of the proceedings in OS 26330 of 2022. A suit filed for?
Suit filed for declaration, my lords, and
Suit
injunction.
for declaration and possession, huh?
Howdo, my lords.
Declaration and possession. The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that the subject suit is not the first in line, but it is instituted in the year 2012 itself, and at every point in time the court would not pass orders, pass necessary orders in any of these proceedings. As an illustration, the learned counsel would submit that the matter was pending for issuance of notice even for 8 months when the suit was instituted. In that light, and the suit being of the year 2022, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 9 months, if not earlier, ordered accordingly.
Again, thank you.
Yes.
Much obliged.
41.
Not seeking writ of mandamus, consider application under 38D.
The petitioner is before this court seeking the following prayer. The learned counsel, seeking the following prayer. The petitioner is said to have purchased the property, subject property, from the hands of one Kasturi C. Shetty in terms of a registered sale deed dated 18/8/7/2002. In terms of the said sale, all the 2002 ಹೇಳದ್ನಲ್ಲ, 2002. In terms of the said sale, all the entries stand in the name of the petitioner. The petitioner, the BDA, the petitioner submits an application before the second respondent BDA under section 38D seeking regularization of the house site and the buildings through reconveyance. The said application has not met its consideration, and therefore the petitioner is before this court in the subject petition. ಇನ್ನು 10/6 ಕೊಟ್ಟಿದ್ದೀರಾ ಆಗ್ಲೇ?
ಸೂಟ್ ಹಾಕಿದೆ
ಜಲ್ದಿ ಮಾಡ್ತಾರ ಅವರು? In the light of the application submitted only on 10/6/2025, I deem it appropriate to dispose the petition with a direction to the BDA to consider the application submitted on 10/6/2025 under section 38D and pass necessary orders in accordance with law within 4 months from the date of receipt of the copy of this order. Ordered accordingly.
Till then not to precipitate otherwise.
1 year ಇದೆಯಲ್ಲ ಅಲ್ಲಿ, ಅದು ಇನ್ನೊಂದು ಜಡ್ಮೆಂಟ್ ಅಲ್ಲ, ಮೊನ್ನೆ 1 year, within 1 year from the date of receipt of the copy of the order as is observed. Which judgment is that? ಕೊಡಿ 1 year ಅದು. ಮುರುಗೇಶ್, ನಿಮ್ಮ ಕೊಲಿಗೆ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಅವಾಗಲೇ, ಅದೇ ಗೊತ್ತು, ಅದು ಎಲ್ಲಿದೆ? You give that judgment, yes. So and so till such time the respondent BDA shall not precipitate the matter qua the possession of the petitioner.
42.
The petitioner, JP Nagar 9th phase scheme lapse.
I don't stay there. JP Nagar 9th phase ನನಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ.
The matter is covered minutes by.
ಅದು ಹೇಳಿ, yes.
It's the order
yes, notice ಮಾಡಬೇಕಲ್ಲ.
Please.
Counsel B. Vachan is directed to accept notice for BB Patil. ನೀವು ಇದ್ದೀರಾ BDAಗೆ? BDA. Counsel B. Vachan is directed to accept notice for the respondents, respondent 2 and 3, HCGP 1, the petitioner to serve set of papers upon the aforesaid Counsel B. Vachan forthwith. The respondent shall not precipitate the matter till the next date of here. Precipitate the matter qua the possession of the petitioner if the petitioner is in possession as on today till the next date of hearing. List on 5th August.
Please. Please.
43.
I filed power for R2 to R4 already.
KDB,
28(1) is challenged, but even though I've sought for interim prayer, I'm not pressing for it. Notice be issued. Yes.
Power hakidin ನಾನು already filed. I'll file my counter.
Learned Counsel BB Patil is directed to accept notice for 234. Registry to print the name of so-and-so is appearing for 234, 1 HCGP. 6th, 5th August, 12th August, yes.
I'll file a counter.
Objections if any by then.
Please,
Next.
deeply obliged.
44.
That's Abhishek.
Request of the petition
Ketan
for-
Kumar.
Yes,
You Ketan Abhisheka.
I'm Ketan Kumar. My colleague is Abhishek. Request of the petition for denotification of his acquired land is rejected by annexure A, my lord. That has been challenged, and the consideration of his request at annexure G and E, my lord.
Denotification reject agada.
My lords, due to the subsequent realignment of the,
Counsel Shri Ajay Prabhu is directed to accept notice for the first respondent. Shobit Shetty, second respondent is 2, 3, 4 and 5.
4 is state.
HCGP. 5.
5
HCGP na NHA.
NHA.
ಹಾಗಾದ್ರೆ madam.
2, 3 and
5 Shobit Shetty, 1 Ajay Prabhu, 4 HCGP. Petitioner to serve set of papers upon all the aforesaid council placed on 12th August.
Obliged.
55.
Matter pertains to a site measuring 30-40, your lordships. I've challenged the acquisition on the ground that converted land, I had purchased converted land and they cannot be acquired. My adjacent site has already been
washed,
your lordships.
Kodi. Vasant. Learned Counsel Vasant is directed to accept notice for respondent 2341 HCGP. The Learned Counsel for the petitioner places reliance upon the judgment rendered by the coordinate bench, which is said to have quashed the proceedings of an adjacent land. The Learned Counsel Vasant to secure instructions and make his submissions on the next date, based on 12th August.
Please.
Next.
46.
Well, for application for change of land use has been,
Pending.
endorsement has been given.
Rejected
Endorsement, in future they may require the land ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure M, my lord, page 23, covered by this honorable court's judgment.
Correct, notice ಕೊಡ್ಬೇಕಲ್ಲ.
Yes, my lord.
ಇಲ್ಲೇ close ಮಾಡೋಣ.
Yes, my lord.
The Learned Counsel for the petitioner submits that the issue in the list stands answered by the judgment rendered by the coordinate bench, as the BDA cannot hold on to the lands of the citizens on the score that the land would be required at any future date. Therefore, the Learned Counsel, Ajay Kumar is directed to accept notice for respondent 1 and 2, HCGP 3, petitioner to serve set of papers upon the council list on 5th August.
Much.
Yes, next.
7.
Lords, 47, I am appearing for the petitions council, my lords.
47, madam.
Please.
47.
Lords, your lordships had by an order dated 7/7/2025. Lords, protected the possession of. Yes.
Correct.
Lords, now they have subjected this very property to e-auction, which is subject matter of an interim order.
But this was the learned single judge of this honorable court has directed to use the police force and remove them from.
Where is that?
Lord, may kindly take Lord page 659. Lord, this is the order of the learned single judge. Lord, so
59.
59. Lord, page 74 is an operative portion. Lord, the possession is taken over. The property is held to be developed. Section 27 rejected. And Lord, only the factor, Lord, page 72, Lord, relevant. Lord, page 72, G, Lord. There's a lot of force in the passionate submission.
What, this has become final?
This has become final. This has been, Lord, this was challenged in the writ appeal.
ಮತ್ತೆ final
order. Please, writ appeal order. Writ appeal order starts from page, Lord, 180, 18, Lord. And Lord, the operative portion in the writ appeal, he is at Lord page 100. Lord. But may I read Lord page 98, Lord? Para 19. Para 19 onwards. In view of the aforesaid factual and legal situation of the matter, more particularly the fact of the earlier challenge of the predecessor in title of the appellants to the notification acquiring survey number so having been negated and the same having attained finality, the appellants opting to pursue the creating the documents in another survey number, namely so and so, placing heavy reliance on the same to sustain their untenable claim that they being in possession of land in survey number 286/2. The court is of the considered view that the learned single judge has come to a just conclusion by dismissing the writ petition, primarily on the ground of appellants not approaching the court with clean hands and clean heart and
Clean hand, heart.
clean head and clean heart.
Head, heart.
Please.
Yes.
The other contention with regard to respondent BDA not taking possession of the land by drawing a measure in the manner known to the law, reliance placed by the learned senior counsel for the appellants on the judgments referred herein above are of no avail in view of the fact situation the present matter has narrated herein above. As rightly taken note by the learned single judge, a full bench of this court in case of ITI employees and so, with regard to modes of taking possession of the acquired land and also the judgment of the apex court in the indoor development versus Manoharlal reported in so and so wherein it has been held.
Confirm ಮಾಡಿದ್ರಲ್ವಾ?
Confirm ಮಾಡಿ.
SLP
Then-
ಹಾಕ್ಲಿಲ್ವಾ?
Yes, there, my lord, they invoke section 38D, my lord, before the division bench, honorable division bench, which was
Para
rejected.
22, my lord,
That
is
was
where the
that
cause
was
of action
taken note of.
arises.
That was
Para
taken
22
note
of the division bench's order is where
Yes.
the cause of action arises.
Yes.
Can I just
22.
read, my lord?
22.
Para
Before
22 at
parting,
page number 100.
Yes. Yes, Ravi
Lords,
Shankar sir.
Before parting, it may be necessary to mention that after conclusion of the arguments, learned senior counsel appearing for the appellants has submitted that notwithstanding the contentions raised in the appeal, appellants be permitted to make an attempt to seek allotment of an area over which the buildings have been constructed from respondent BDA. So-and-so counsel for the BDA has fairly submitted. If it is permissible under law, the same would be considered. It was made clear that such an option granted in favor of the appellant shall not be considered as treated as creating a right or acceptance of the contentions. Accordingly, the matter was adjourned on so-and-so enabling parties to identify the actual area covered by the construction. This is what transpired, my lords, in the earlier round of litigation where the area was identified. It appears after identifying such area, the appellant had made a representation seeking regularization of certain portion of the land over which the buildings are existing. Respondent BDA has issued endorsement on 31/8/23, declined to consider the representation on the premise there is no provision under the Act for regularization. Necessary in this regard to note the appellants who have claimed to put up construction of building or accommodate the school have contended that they have not received any compensation and they would forego their claim for compensation if the respondent BDA considers.
What has happened now?
Lords, now kindly have a look at, my lords, the orders passed by the Supreme Court at page number 109.
Page
109. Lords, paragraph
110.
number 3.
As
Sorry,
regards
Lords,
construction raised by
As
the
regards
petitioner.
construction rights, the acquired land, the High Court has already permitted them to approach the competent authority. The petitioners thus are at liberty to pursue their claim before the prescribed authority in accordance with law. Now, my lords, the matter is at large before your lordships. Now, kindly have a look at the order passed by your lordships because they are referring to an earlier order. Lordships order dated 7/7/2025.
No, if not to evict nor demolish the building.
Lords, now this is the protection which has been granted. Now it is subjected to e-auction to create third-party rights when the matter is subject matter of the list. No, they should have sought for the permission, my lords, of this honorable court in any manner which is having an adverse impact on the orders of your lordships of 7/7/25.
My lord, this is the application where we challenge the notification.
Lords, e-auction insofar as serial number 5 is concerned. Possession is protected.
When did you notify this?
Lord, this appears to have been notified on 19/7/2025, bottom of the page.
7/7 had already passed an order not to demolish nor to evict.
Not to demolish, not to evict, which was done on 2nd. Lords may kindly see, Lord, the representation which they filed, Lord, there, Lord, the photographs which they have filed, Lord, wherein it is shown that it's already demolition has already taken place.
If not already demolished.
Yes,
that's all.
We have not demolished after 7th. Lord, may I make one thing. Lord. 7th, they take an interim order. Lord, on 17th, they come and serve me interim copy of the writ petition, that too even without informing that the interim order has been granted by this court. 17th is the date.
Counsel on record? You are the counsel on record?
Lords, I filed
When did
NOC
you serve?
this. Lords, this morning I had filed NOC.
No, when did you serve?
Lords, I don't have instruction. on-
You should take all the instructions and file wakalat. When did you serve? Why you took 10 days? Why you took 10 days to serve? Page. Why did you take 10 days? You don't know where is Murugesh Sharati, he will be here only. Then why did deliberately you take 10 days?
Always available.
They appeared in previous round of litigation.
Oh, no, this conduct is not correct.
And what has been sought is, they want section 20 to be invoked, so that what has been confirmed by this honorable court, the BDA should negate it, saying that it should be deleted from the purview of final notification, only the
Lords,
betterment
that's on
tax
the-
has to be
Lords,
levied.
that's on the merits
That
of
is
the
the
matter.
representation which has been given, not which is.
Lords, the question is
Proceed
this.
with the auction, don't
Now-
finalize the auction.
Lords,
But
the
the
question is this, Lords, can I
honorable
just say
court-
this, Lords, if your Lords were to permit? Lords, the fact of the matter is that the interim order has been communicated to the BDA immediately after the interim order has been
Where
secured.
there is no,
Lords,
where is
if
the
your Lords may
acknowledgement?
kindly
Where
pass
is,
it over.
you show me one document that you have communicated the interim order date 7/7.
Lords may kindly pass it
One
over. Lords, I
document.
shall get it filed. Yes, Lords may
If you have
kindly pass it over,
communicated
I'll
after
file it.
10 days, this conduct is not correct. I am the advocate
I-
on record.
17th I have received, I have endorsed on their file saying that
The
it
If
question
you
is.
have
is whether
taken
we
10
have
days, I will not continue the interim order even. Pass over, yes.
Yes, my Lords.
48. Fresh matter, my lords, mandamus. BDA. To consider my representation to allot an incentive site, my lords.
Learned Counsel B.S. Sachin is directed to accept notice for respondents 2 and 3. 1, HCGP petitioner to serve set of papers upon the aforesaid counsel less than 12th August. Yes, next.
49.
Not appear for petition in this case. 3 acres of land belonged to petitioner was acquired by BDA for formation of Banashankari 60 layout. For that matter, the 3 incentive site was allotted in favor of the petitioner in the year 2004 itself, and he has deposited entire siteal value. Thereafter, the said site was re-allotted to some other persons. Then,
When was the reallotment?
in the year 2004 itself. Then, subsequently.
Counsel Ajay Kumar is directed to accept notice for respondents 1 and 2. Even reserve sites.
Subsequently,
we'll
site
see.
was identified, my lord. That site may be in 2020
Where is
itself.
the identification?
My lord, Annexure
By
F,
whom?
Annexure F, page 32. Deputy
Page?
Secretary, 32. And then a CD report was received, then Annexure G.
Learned Counsel Ajay Kumar is directed to accept notice for respondents 1 and 2. The respondent BDA. ಎಷ್ಟು ಸೈಟ್ ಇದೆ ಇಲ್ಲಿ?
ಇಲ್ಲಿ 4 ಸೈಟ್ ಇದೆ.
4 ಬೇಕಾ ನಿಮ್ಗೆ?
4 ಅಂದ್ರೆ 2 60-60, 30-32. ಒಟ್ಟು 3
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. The petitioner to serve set of papers upon counsel Ajay Kumar appearing for the petitioner. List on 29th.
In time that site may be.
ಅವತ್ತು ಕೊಡುವ. Yes. ಇವತ್ತೇ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ.
50.
Petitioner, my lords. Petitioner is challenging the award passed by the KADB in favor of respond number 3, my lords. My lords, land in question is a PTCL land, and there is a pending
PTCL land.
PTCL land, my lords. Land was granted in favor of the petitioner's grandfather way back in the year 1948, along with 21 others. And the lands has granted there were for the benefit of the depressed classes in the society.
ಅದು PTCL ಕೊಡೋದೇ ಅದಕ್ಕೆ. ಅದು ಕೊಡೋದೇ ಅದಕ್ಕೆ, ಅದನ್ನೇ ಹೇಳ್ಬೇಕು.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿದೆ. So now what has happened, my lords, the KDB has initiated acquisition proceedings, and I came to know about the said proceedings in the fag end of the proceedings, and I filed objections before the respondent number 2, my
Yes,
lords.
sir.
My lord, there is a sale deed was executed in the year 2009. There was a first sale that has happened in 2009. Subsequently, in 2015, there was second sale. and the present allottee, who is the present beneficiary, that is respondent number 3, he purchased in 2021. When the notification proceeding started, whoever was the khatedar, they have been informed. In
You have
fact,
sold it, leave it.
My one submission was,
Page
there's a
50.
judgment wherein it is clearly held, if the land is subject to PTCL, they cannot be waiting. And what happens, it becomes fait accompli. This is what the
Why
judgment
did you
is.
sell it thrice over?
I have not sold.
Then who has sold?
Subsequent purchases.
Whoever, first sale ಯಾರು ಮಾಡಿದ್ದು?
First sale ನಮ್ದು.
ಯಾಕೆ ಮಾಡಿದ್ರಿ?
We were not aware of this, my lords. My lords, there is a judgment with regard to,
Page 15
my
we
petition
kindly
is also pending, my lords, taking note of this judgment, taking note of PTCL proceedings as state the disposal of the award amount. State the disposal. May I, my lords?
Yes, sir.
page 50 may kindly be turned, my lord, the annexure A. So in that unnumbered paragraph from bottom, the objections has been considered and thereafter the award has been passed.
They have considered
That is
that the land doesn't come under.
Sale ಮಾಡಿದ್ಮೇಲೆ ಮರ್ತು ಬಿಡ್ಬೇಕು.
But as a PTCL protects
Protects
rights of
ಅಲ್ಲಿ
the
ಎಷ್ಟು-
grantee.
non-alienation clause ಎಷ್ಟು
ಯಾವಾಗ್ಲೂ
ವರ್ಷಕ್ಕೆ?
ಯಾವಾಗ್ಲೂ ಮಾರ್ಬಾರ್ದು
Forever
ಅಂತಾನೆ ಇದು.
ಅದು-
ಯಾವಾಗ್ಲೂ 1948-49
ಯಾವಾಗ
award.
ಇದು?
1948 award.
Those are
Grant.
permanently non-alienable.
Permanent non-alienation.
Permanent non-alienation.
Between 38 to 1953.
Yes.
They were permanently
Permanent
Permanent
non-alienable.
non-alienation. So in that objections was considered, and in fact there was an
ಅಲ್ಲ, objection
communication.
they come to the
communication
conclusion
with
no
the-
PTCL ಅಂತಾನೆ.
Communication
Respond
with
number
the-
2 comes to
Correct,
the
ನೀವು ಮಾರಾದ್ಮೇಲೆ ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದೆ ಹ್ಯಾಂಡ್ಸ್ PTCL ಎಲ್ಲಿ ಬರುತ್ತೆ?
Please see
May I
the
just forward
Compensation ಅಂತ you want.
award? Yes, my lords, I am seeking to
No, this
protect.
has to be, we'll have to
Hello,
steer
sir.
this clear. There is
Sir.
not, ಕೊಡಿ ಅದು
Sir.
ಮಾಡಿ, ಕೊಡಿ ಇಲ್ಲಿ.
I'll directly, this
10 sale
judgment is
deeds,
with regard to,
10 hands change ಆಗಿ ಆಮೇಲೆ we go back to the first hand.
kindly peruse page 1805.
Yes, sir.
The finding, the issue framed was when the land is in PTCL and can KIDB award be disbursed.
We'll see. Consider it.
Clause
Yes.
6, my lords. Clause 6 at page
Consider.
1805.
No problem. Learned counsel so and so. And enters appearance for
respond number 2.
respondent number 2, the board.
Please, madam.
Respondent number 2, board. 1 HCGP. Who is this third respondent?
Private respondent. Is the present khatadar.
The third respondent be served by way of hand summons. List the matter on
Lots.
1st August.
ಇಲ್ಲ disburse ಆಗೋಗುತ್ತೆ in the meanwhile.
ಏನಾಗಲ್ಲ. Yes, 1st August. ನೀವು ಕಳ್ಕೊಂಡು ಲ್ಯಾಂಡ್ ಆಗ್ಲೇ ಬಹಳ ದಿನ ಫಸ್ಟ್ ಸೇಲ್ ಯಾವಾಗ?
2009.
2009. ಮತ್ತೆ ಈಗ ಸಡನ್ ಆಗಿ ವೇಕನ್ ಅಪ್ ಬಿಕಾಸ್ ಆಫ್
Proceedings.
ಕಾಂಪನ್ಸೇಷನ್. Yes, sir. Based on
First month.
1st August, yes.
51. Your Lordship, in this matter, the acquisition was only for about 7 acres. 6+ acres, Your Lordship, the coordinate bench of this honorable court has already quashed the entire proceedings. This is only with respect to the small little balance portion that is left.
Small little ಅಂದ್ರೆ ಎಷ್ಟು?
It's less than an acre, Your Lordship. And 95% of it has been set aside by this honorable court, not yet challenged.
Page.
Page 127, Your Lordship.
The larger extent is set aside.
Entire, more than 6 acres out of 7 acres has been set aside, Your Lordship. Page
The larger
127.
extent, yes. Page?
127, Your Lordship.
What is 131?
131 would be the operative portion. At page
ಅಲ್ಲ, page
130, the
131 is
extent.
a judgment, annexure V.
Page is different. Pagination, sorry, Your Lordship.
ನೀವ್ ಹೇಳ್ತಾರ
At
judgment.
para 2, Your Lordship, may kindly see.
Justice Kamal ಅವ್ರದಾ?
Please, please.
That is 131.
Sorry, my set is 127. Your Lordship, paragraph 2, internal page 4. Your Lordship, may
Setting
kindly see.
aside the aforesaid.
The extent, entire extent put together, 38 guntas, 31 guntas, 13 guntas, 8 guntas, 15 guntas, all of them put together, Your Lordship. The entire extent has been set
This
aside.
has become final?
Nobody's challenged this, Your Lordship, and it's based on lapse is what we had anyway challenged.
Heard the learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner. The learned senior counsel submits out of the 7 acres that was subject matter of acquisition, 6 acres and odd have been set aside by acquisition. 6 acres and odd have been quashed by the coordinate bench in page 131. In the, what remains is the lands that belongs to the petitioner. If the reason so rendered to quash the notification acquisition proceedings, qua 6 acres is noticed, it undoubtedly inures to the benefit of the petitioner as well. Therefore, notice ilde madakagalla. I'll stay it now.
Please.
Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. The learned, the advocate on record shall serve on one, state road transport corporation.
It was supposed to be acquired for them, which did not happen.
The learned HCGP is directed to accept notice for 1, 2, 3, R4 and 5 serve on anybody.
Please.
The petitioner is at liberty to serve on the panel council representing R4 and R5.
Obliged.
List on 12th August.
52.
Lot cell number 52, betterment tax imposed by BDM lot on 9 guntas of land by virtue of annexure B notification.
Sir, your car is nice, but voice is not.
I'm sorry, Lord. Now am I audible?
You are in the car.
Yes, Lord. Outside, I tried outside, Lord. It's not.
Right outside.
I tried outside.
Mobile office madidira.
Signal. Signal ಬರ್ಲಿಲ್ಲ, Lord. Section.
ಅಲ್ಲ ಇದು
covered by decision of Krishna Kumar.
Law on the wheels anta. Yes, sir.
Yes, Lord. The betterment tax imposed by the BDA, this earlier betterment tax imposed has been quashed with respect to adjacent land.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. Counsel Ajay Kumar is directed to accept notice for respondent 1 and 2. The petitioner shall serve a requisite set of papers upon the aforesaid counsel. The learned counsel for the learned senior counsel submits that the earlier imposition of betterment tax has been quashed by which order?
By 6th January 2023 order in WP 13,000 of 2020. With respect to adjacent land, same notification.
In terms of the order dated 1/3 so and so ilide, with this in respect of the adjacent lands, list the matter on 5th August. Interim order. There shall be an interim order spread for till the next date. Next.
53.
For petitioner in this matter, my lords. My lords, petitioner is a welfare association, my lords. First block, JP Nagar 8th phase, wherein the reserved site, CA site is being used as a for club purpose, and there is no park or.
Let us see. Council BDN idu.
Yes, my lords.
Council B. Vachan is directed to accept notice for the respondent BDA, respondent 2 and 3, HCGP 1, petitioner to serve set of papers upon the aforesaid council forthwith, 12th August.
Much.
Next.
54.
Please, Your Lordship. My Lord, land in question, my Lord, are acquired by the Special Land Acquisition Officer, my Lord, Yatinwale project, my Lord. My Lord, then, my Lord, in the award proceedings, my Lord, petitioners here are filed their objections, my Lord. Kindly, Your Lordship may kindly see the page number 57, my Lord. In the order, my Lord, what they observed that the special
HCGP is directed to accept notice for the first respondent. 2, 3, 4, 2 and 3 are.
2 is the private respondent, my Lord.
LAC order challenge ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
I am challenging the LAC order, my Lord. What has happened, my Lord? Though I have filed the, my Lord, suit, my Lord, during the pendency of the suit, my Lord, without
LAC order ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ challenge ಮಾಡ್ತೀರಾ?
Yes, my Lord, kindly see for a moment page number 61.
Anyway, copy ಕೊಟ್ಟಿಲ್ವಾ?
60, my Lord.
1 minute, sir. Learned HCGP is directed to accept notice for the first respondent. No notice for the no notice need be issued to respondents 2, 3 for the present. List the matter on Friday. Look into it and get back.
My Lord, because respondent number
Fridays.
Please.
First till maintainable ಅನ್ನೋಣ. Please. Look into it and copy ಕೊಡಿ ಅವ್ರಿಗೆ.
Appear for the petitioner, my lord. The third respondent issued the preliminary notification for the formation of Shantavari Gopala Gowda second stage Mysore, my lord, in the year 2006. Even
2006.
Yes, my lord. Even after lapse of 19 years, they are not implemented, my lord. This matter is covered by the decision, my lord.
ಕೊಡಿ notice ಮಾಡಿ.
Annexure K.
Learned Counsel TP Vivekanand is directed to accept notice for the respondents 2 and 3, 1 HCGP. List the matter on 12th August. Till such interim order kelidira?
Yes, my lord.
Till such time there shall be an interim order as prayed for to the next date of hearing.
Much obliged.
I'm for the petitioner. Blood writ of mandamus is sought for blood. Blood the total extent of land in survey number 91 of Tenisanda is blood 39 acres blood. Out of which blood 31 acres is granted to police department.
Counsel Sri Ajit Achappa is directed to accept notice for respondent 2 and 3 BDA, 1 HCGP.
2 to 4 blood.
2 to 4 BDA, 1 and 5 HCGP. List the interim order.
ಇಲ್ಲ ಇಲ್ಲ ಏನು ಕೇಳಿಲ್ಲ.
List the matter on 12th August. Our dispose ಮಾಡಿ. Next.
57.
For petitioner, my lords, this is a general award matter.
Yeah. Please. ಹೋಗ್ಲೇ general award ಒಂದು ಕೊಟ್ಟಿದ್ದೀವಿ. Covered.
2 and 3, my lord.
Yes, next. 57 general order, 58.
58, my lord, 1 acre of land belongs to petition was acquired by BDA for the purpose of formation of Banashankari 6 days. In the said land, my lord, or a 60, my lord, he put up a construction and residing there. A 38D application was pending consideration. Even the surveyor also, the executive engineer submitted a report recommending for allotment of the said land. Now, my lord, there is third of disposition.
38D na?
38D, Annex G, the 38D application.
Counsel Gautam Dev Ullal is directed to accept notice for respondents to 1 and 2 petitioner to serve set of papers upon the aforesaid counsel. The respondent shall not precipitate the matter qua the possession of the petitioner if the petitioner is in possession as on today. List the matter on 12th August.
Please.
Next.
59.
I appeal for respondent, my lord.
Petitioner, my lord, the DD
They
has been
have-
drawn,
they
my
have
lord,
not-
the same will be deposited.
They have not deposited, simple suit.
My lord, the DD has been drawn. my lord,
40,000 for recovery of on bill. They have issued
DD.
checks.
40,000, my lord.
ತಗೊಳ್ಳಿ.
The DD
ಎಲ್ಲಿ?
My lord, it's
ಎಲ್ಲಿ
been
ಅಂದ್ರೆ ಅಲ್ಲಿ
drawn.
ರೈಟ್ ಸೈಡ್ ತಿರುಗಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
My lord, the order was to deposit before this.
The registrar,
They will deposit. ನಿಮ್ಗಲ್ಲ ಕೊಡಕ್ ಡೆಪಾಸಿಟ್ ಕೇಳಿದ್ದು.
simple suit, my lord.
ಸಿಂಪಲ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿಸಿರೋಣ.
ಏನದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ದೇ ಡಿಂಟ್ ಫೈಲ್ ಫಾರ್ 10 months. ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿ ಎಲ್ಲ ನಾವು ಏನ್ ಮಾಡೋದು?
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಕ್ರಿಮಿನಲ್ ಸ್ಮಾಲ್ ಕಾಸಸ್ ಕೊಟ್ಟು ಈಸಿ ರಿಕವರಿ ಆಗ್ತದೆ.
ಅಲ್ಲಲ್ಲ, ಅಲ್ಲೇ ರಿಕವರಿ ಆಗುತ್ತೆ. ಎಸ್. The learned counsel for the petitioner, this court on 17/7/2025 had passed the following order. In furtherance of the said order, the counsel for the petitioner holds a demand draft of rupees 40,000 in her hand and would submit that it would deposit it before the registry in the course of the day. List the matter on Tuesday. Deposit be made by then. Yes, next.
Let them give the copy.
DD photo ಕೊಟ್ಬಿಡಿ.
ಅವರು ಸೆಟಲೇ ಮಾಡ್ಬೋದು ಸಾಹೇಬ್ರೆ. ನಾವು ಮೈನ್ ಮ್ಯಾಟರ್ಗಿಂತ
ಇದೇ ಜಾಸ್ತಿ ಆಯ್ತು.
ಹೌದು.
ಆಯ್ತು, anyway, Tuesday will close it.
Idea.
29th.
They want to pay the cash check pay order ಆವಾಗಲೇ ಕ್ಲೋಸ್ ಮಾಡಿ.
ಅದು ನೋಡೋಣ.
Idea.
ಇದೆಯಾ ತಗೊಳ್ಳಿ.
List number 2, preliminary hearing, still number 1.
Lords, the impugned order is passed, Lords. Lords, kindly see Annexure B, page 11, Lords. Lords, without hearing, Lords, the petitioner, Lord, they have passed an order for demolition, Lords.
Yes, Ajay Kumar.
My lords, it's really that, sir, my lords, from what I have been informed, my lords, notice was served on 1/2/2025. And he has submitted his reply also on 10/2/2025. After taking note of all the same, my lords, it is the property possession has been, encroachment was removed and possession was taken back.
Lords, yeah, notice,
kindly
I have
note,
no,
the
Lords, no
petitioner-
knowledge of the Lords proceedings, Lords. Lords, kindly see in the impugned order.
Lords, I'll produce, memo hakim madhyana 2:30 told. I'll produce
Lords,
it with.
Password.
Lords, from the impugned order, Lords.
Passwords.
Yes,
Please.
public. Lords, let them serve a copy of the petition.
I'll serve, I just got it, my lords.
Public.
ಕೊಡ್ತಾರೆ.
Public.
List 1, B group matter, still number 60.
Here for response, my lords.
ನೋಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಇರಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ. The counsel for the petitioner has remained continuously absent. Awaiting his appearance, this court has from time to time adjourned the matter. Even today, there is no representation on behalf of the petitioner. In the light of the continuous absence, the petition is dismissed for its non-prosecution. Next. Both.
61,
The response is to. Open.
Yes, Pradeep. Yeah, about,
On the last date, my lord, your lordship, my lord, directed us to, my lord, produce inquiry report, my lord, held under 5A. Are ready this one?
intermodal, the no representation on behalf of the petitioner, list the matter on 5th August. Next,
62,
same order.
63,
Appear for the petitioner, my lords, in this matter, my learned friend, my lords, Mr. Charity had to file a report.
1 minute.
Yet to file a report. I'm yet to file a report.
Learned Counsel Murgesh Charati seeks time, yet again to file a report as was directed earlier. Finally, list this matter on 5th August. In the event of non-compliance, adverse inference would be drawn. Yes, next.
Grateful, my lords.
Next.
64,
Kempegoda layout.
For the petitioner in this case, your
Covered.
lordship, kindly pass over the matter.
Covered, madam. Pass over.
Please.
Yes.
Obliged, your lordship.
5,
List on 12th August.
66,
Enter ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
66 is ಕೆಂಪೇಗೌಡ layout.
ಅದು ಕವರ್ಡ್ ಪಾಸ್ ಓವರ್.
Number pad different types.
SB ಹಳ್ಳಿ.
My lord, this is a case where
67. ಇದು ಕೆಂಪೇಗೌಡ.
but the matter at slum clearance board, where the compensation is based on 300 times the assessment. This question, my lord, was considered by your lordship, my lord, in companion petition, but that is how the matters got adjourned.
Companion petition ಯಾವ್ದು ಸರ್?
ಇಲ್ಲ, ಅದು ಚಿದಾನಂದ ಕೇಸಲ್ಲಿ ತಾವು your lordships have
ಡಿಲೇ ಮೇಲೆ acquisition
ಹೌದು
ಕಾಸ್ಟ್ ಮಾಡಿದೆ.
So far as the second question is concerned, your lordships did not answer it.
Correct.
So therefore, in this case, whether a compensation based on 300 times assessment under section 20 is a sufficient compliance of the passing of an award.
Board ಯಾರು appear ಆಗ್ತಾರೆ?
Lord, I appeal for the board.
Board.
We have communicated to the government to take a decision as to, because this honorable court has held that they should frame a separate rules. So far as consent to the judgment, we have requested the government to take a decision. Let's put.
ಈಗ ಇದು 2015
The matters have been remitted by Supreme Court.
ಅಲ್ಲ 2035 ತಗೊಳ್ಳ ಡಿಸಿಷನ್ ತಗೊಂಡಿರ್ತೀರ
The Muralidhar's case, my lord, what it has been remanded back honorable apex court has remanded back to consider.
That is what I considered.
Please, my lord.
ಮತ್ತೆ
Section 20 was.
ಅದರಲ್ಲಿ the section 20 ಬಗ್ಗೆ I did not go into
Please,
because
Lord.
acquisition could be cost otherwise.
What I would request, my lords, kindly grant 2 weeks time, lord. Within that time, we'll come back with some decision from.
Come back with some what?
Some decision from the government, my lord.
But
We have
whatever
written
the statute which they acquire, whatever may be the purpose, City Improvement Trust Board, the Nagpur 73 Supreme Court could apply. That has been considered even in Girnar's case, 5 judges.
My lord, because we have
Following
also returned to
98, my lord, UP.
Advocate General also,
Yuva's
letter
case.
is sent to the Advocate General also seeking his
ಆಯ್ತು
opinion.
ಒಂದು ವಾರ 10 days time ಕೊಡ್ತೀನಿ. ಅಷ್ಟರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ I will hear the senior counsel and pass out. The heard the learned senior counsel V. Lakshmi Narayan appearing for the petitioner. The learned counsel appearing for the board. ತಮ್ಮ ಹೆಸರು ಮಾಡ್ತಾರೆ.
BN Suresh.
BN Suresh Babu seeks 10 days time to file his objections. The matter is of the year.
Objection is filed, my lord.
Then what do you want?
No, my lord, objection filed.
Seeks 2 weeks time on the score that the government would take a decision on the issue and that decision would be placed before the court. List the matter on 5th August In the, 5th August, 5th August. In the event no decision is placed before the court, the matter would be considered on its merit on hearing the counsel for the parties. Intermodern idea? Yenilla.
No entry matter.
List the matter on August the 5th, 2025.
Since your lordships have decided the earlier petition, let it be treated as a parted or otherwise.
On 5th it will come.
Please.
Yes.
68.
CK weeks time.
ಇದು covered, sir, against you.
ಇಲ್ಲ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ನಮ್ಮದನ್ನ ಅವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ.
Pass over.
Coming up.
Come to the court, pass over.
Please, sir, definitely.
Yes.
69.
Milords, this is
ಇದು ನಾಡಪ್ರಭುದ?
Swami?
ಇದು ನಾಡಪ್ರಭುದ?
ಇಲ್ಲ, ಇದು Banchankari 6 stage, my lords.
Sir. Oh, that covered matter.
Yes, my lord. There are several matters, my lords, in which the decision has been passed.
Against you?
In my favor, my lords.
Yes, madam. Yaar Unnikrishnan Bidi. Learned counsel of the petitioner submits that the issue in the list stands answered in favor of the petitioner in plethora of cases. Therefore, list this matter on preliminary hearing on 5th August.
Obliged.
Next.
70.
Yes, I'm passing on the list of dates and events because this matter had a checkered history.
You are ready? Then we'll take it at 2:30. Make it correct. It pass over matter 2:30 ತಗೊಂತೀನಿ because checkered history ಅಂದ ತಕ್ಷಣ ತುಂಬಾ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ.
71.
71. Yes, Vachan, ಏನಿದೆ?
Subsequent purchaser, my lords, challenging the acquisition.
Land acquisition. Covered. ನಾನೇ ಮೊನ್ನೆ ಬರ್ದಿದ್ದೇನೆ.
Bardi.
Take that one.
Supreme Court judgment.
ಇದೆ. National Highway ದಲ್ಲಿ ಮೊನ್ನೆ ಗಿರಿಧರ್ ಕೇಸಲ್ಲಿ I've written. Don't have that?
91 Act, my lords, where the transfer is prohibited. Matter, my lords, the other day, my lords.
Learned counsel for the petitioner submits that the petitioner is the subsequent purchaser subsequent to the final preliminary no final
Preliminary notification.
Preliminary notification and has no right in law to challenge the acquisition. He would submit that the issue in the list is covered by plethora of judgments rendered by the apex court on the issue. List the matter on 29th in preliminary hearing. There is no representation behalf the petition. Next.
72.
Yes, Krishna, what is this?
Yes, Kempegowda layout. Kempegowda layout matter covered by.
List on.
Hello, it is passed over my Kempegowda layout.
Pass over, sorry. Yes.
73.
Your Lordship, counsel for the petitioner, as per the order of this Honorable High Court on 21st February 2025, it was for the state to make submissions with regard to whether they had permission to execute a sale deed or not.
Appear for the Astrophysics Institute, my lord. Respondent number 4 and respondent. State has to make submission with regard to acquisition.
What inquire? This court on 21/2/2025 has passed the following order. The state would yet again seek time to seek instructions and make submissions. Therefore, if the instructions, acquisition for the purpose of KSRP.
My lord, it was for the purpose of Indian Institute of Astrophysics, IIA.
List the matter, finally list the matter on 7th August. In the event no submissions are made by the state, appropriate orders would be passed. Yes, next.
Please.
Much obliged.
74.
It is covered by the writ of judgment method.
Yes. Yes.
1783 up.
So, madam, Nadaprabhu Kempegowda layout ಸುಮಾರು ಮಾಡಿ. Yes, next. Same order.
75.
This is also covered under.
ಇದು ಅದೇನಾ?
Cover ಆಗಿದೆ.
Same order. Same benefit, whatever division benches given.
The series of benefits which I am entitled in.
Yes, sir, whatever.
76.
Then Murugesh.
pertaining to other layout, Codial subsequent purchaser
Acquisition,
acquisition.
subsequent purchases to the acquisition. The learned, there is no representation on behalf of the petitioner. Counsel for the respondent submits the challenges by a subsequent purchaser pursuant to a preliminary notification, the acquisition and matter stands covered by plethora of judgments list on 29th in preliminary hearing. No representation, brother. Yes.
57.
For the petitioner, my lords,
Hmm.
my lords have challenged the preliminary notification dated 8/1/1964 and the final notification dated 28/10/1971. My lords, despite of these notifications having been issued more than about 45 years ago,
Objections hakidara.
No, my lords.
Finally, the respondent BDA is granted 2 weeks' time to file statement of objections. In the event no objections would come about, it would be construed that there are no objections to the petition and appropriate orders would be passed. List on 5th August. Yes.
Grateful, my lords.
Next. ಯಾರು ಮೂವ್ ಮಾಡಿರೋದು? Just Chandrasekhar.
They're seeking compensation. It's a government land. Earlier, they filed a writ petition. This court held that you have to file a suit for declaration.
Suit ಹಾಕಿದಾರಾ?
These lands are acquired for the.
Suit ಹಾಕಿದಾರಾ? Suit ಹಾಕಿದಾರಾ?
Suit ಹಾಕಿದ್ದಾರೆ. ನಮ್ಮನ್ನು ಬಿಟ್ರು, ಅಲಾಟಿಸ್ ಬಿಟ್ರು. ಬರೀ ಸ್ಟೇಟ್ ಎಕ್ಸ್ಪರ್ಟ್ ಡಿಗ್ರಿ ತಗೊಂಡಿದ್ದಾರೆ. That's the reason why this court has asked so many questions. That's why it was adjourned from time to time.
I will also do the same thing in the afternoon. Yes. Next.
79.
For the petitioner, my lords, 1 week time may be granted.
Several times it is been adjourned.
Several time is granted. This time we will not grant.
Senior is not feeling well.
23 rule 1 application was filed, rejected.
Maybe
Since
passed
GMC
over.
Oh, the GMC.
Yes, sir.
It may be passed over, my lords.
Pass over.
80.
Without acquisition, my lord, roads are found in my property.
Correct.
Statement of objection is filed. We are not using any part of the petitioner's land. It's only national highway property which has been utilized where for
Objection ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ. No.
Copy ಕೊಡಿ ಮತ್ತೆ.
I have not received the copy. They have not filed. They have taken.
They have
several
filed,
times.
sir, it's here. Objections ಹಾಕಿದೆ. Council, the learned HCGP
Mail, my lord.
to serve.
It is sent through mail. I will give a hard
Learned HCGP to serve the objections so filed before this court to the petitioner forthwith. List the matter on 5th preliminary hearing. Yes, next.
81.
For the petitioner in this matter also, which time may be granted to.
Yes, Chandrasekhar.
Subsequent purchase.
Subsequent purchaser.
Subsequent purchase. ಅಲ್ಲ ಇದರಲ್ಲಿ
List the matter on 29th in preliminary hearing.
ಇಂಟ್ರಿ ಮಾಡರ್ ಮೇ ಬೇಕು.
ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the respondent KIDB submits that the petitioner is the subsequent purchaser after the preliminary notification and the issue stands answered against the petitioner by plethora of judgments of the apex court. List the matter on 29th in preliminary hearing.
2019 SSA 229.
ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ನಾನು.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
For yesterday.
Preliminary acquisition in 2003. Final notification 2022 after the lapse of 20 years.
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ಯಾ?
2006 ಇವರು.
ಏನ್ ಮಾಡೋದು? Can't help. Yes.
Entry ಮಾಡರ್ ಮೇ kindly.
Next Tuesday ವರೆಗೂ ಇರುತ್ತೆ. Entry ಮಾಡರ್ till the next day. Yes.
82.
Appears for petitioner. Now in this, the petitioner is according to her, she is the wife of.
According to you, she is the wife.
No. She is the wife of defendant number 3. Now, the defendant number 3 is the purchaser of properties in question. In the 1982 and 88.
Where is the respondent?
No, only short question involved, my lord.
Two wives,
No, only first, she is the only wife. Thing is, you lordship can say, the third defendant has mortgaged the property
purchased property along with his wife because
ಆಯ್ತು ಬನ್ನಿ.
her property also
2:30.
included.
Madam, well, madam.
Yesterday, there was a matter that my lords had posted on 25th, and the other side had taken an adjournment saying this personal bereavement. This was the appointment of commissioner, my lord.
Correct, all right.
Unfortunately, today we've received a notice saying that the inspection is on the 25th. Could this matter be taken up tomorrow, my lord?
Number. You inform the council.
I will, my lord.
Yes.
I will. Deeply obliged.
My lord,
It's a writ petition filed on 10/6/25 only. It is not yet listed. On maintainability, the objection is raised.
Monday,
Finally,
Monday.
Monday. Afternoon.
ಮಂಡೇ ಇವತ್ತಾ? ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ ಏನು?
Maintainability ಮೇಲೆ.
ಅದೇ ಅದು ಅರ್ಜೆನ್ಸಿ ಏನು?
ಅಲ್ಲ, ಮತ್ತೆ ಅದು ಕನ್ವರ್ಷನ್ ಮಾಡಿ ಸಿವಿಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಹಾಕೊಳ್ಳಿ.
my lord,
ಅದು ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಇಟ್ ಮೇಂಟೈನಬಿಲಿಟಿ.
serial number 72, my lord. I was in Hotel 15. I could not able to make it. It has been passed over. My senior is not keeping.
ನೋಡ ಸರ್, that is not a Prabhu Kempegowda. All covered against.
Please, my lord, but he has been hospitalized, my lord. He's,
Last time ಇದೇ ಹೇಳಿದ್ರಿ.
my lord,
I
on two
adjourned it.
occasions the
All
matter
right?
was not reached, my lord.
No, no. Yes, we'll see later.
Please.
Madam. Good up, sir.
Court officer?
List 2 first matter. Huh. Learned counsel appearing for the petitioner files a memo. Kodi. Counsel Ajay Kumar. Name Torsil Ajay Kumar. Registry to print the name of Ajay Kumar is appearing for the BDA. The learned counsel Ajay Kumar M files memo along with the documents. The documents would be the consideration of the case of the petitioner and an order being passed against her. The memo is taken on record. The learned counsel for the petitioner now files a memo seeking to withdraw the petition on reserving liberty to challenge the order dated 17/3/2025. Liberty so sought as granted, petition is disposed as withdrawn. ಅದೆಲ್ಲ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಲೇಔಟ್ದು ಮತ್ ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಡ ಅಷ್ಟೇ. ವೆರಿ ಗುಡ್. 66 ಮೇಡಮ್ 63 ಯಾರು 63 ಅಲ್ಲ ಯಾರಿಗಾಗಿದೆ 63 ನಾಡಪ್ರಭು ಮಿಕ್ಕಿದ್ದು ಯಾವ್ದಾಗಿದ್ದು 75 ಮೇಡಮ್ 75 68 ಆಗಿದೆಯಲ್ಲ. ಒನ್ ಮಿನಿಟ್ 75 ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಮೇಡಮ್. ಅದು 75 ಯಾರಿಗಾಗಿದೆ ಅವ್ರಿಗೆ 66 ಕೊಟ್ಬಿಡಿ. 66 ಸೇಮ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟು 1 2 3 4 ಸೇಮ್ 64 ಸೇಮ್ ಆರ್ಡರ್. ಎನ್ವಿಜಿ ಆಗಿರ್ಬೇಕು ಮೇಡಮ್. ಎನ್ವಿಜಿಗೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. 64, 66 plus 75 ಆಗಿದೆ already. 72 na? 72 also same. Sidmalappa ಅವರು ಇದ್ದಾರೆ. Not there. Yes. ಏನಾದ್ರು ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಲಿ ಬಿಡಿ. Disposed. 74 ಯಾರು? ಚೌಡ್ ರೆಡ್ಡಿ. ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅದು. ಏನ್ ಬೇಕು? 1 minute. 230 ಲಿಸ್ಟ್ ಯಾವುದು? 105 ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ವಾ? At the request of the council appearing for the petitioner, illa dismissal adu. Appearing for the petitioner, list the matter on next Friday haki. That is. Alla hanga 25th haki. List on 25th. In the event no settlement would be arrived at, petition would be dismissed. Illa appropriate orders would be passed. I have already indicated that they will be dismissed. ಏನಿದು 88 ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀರಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಅದು CH ಮೂಡ್ ಅಂತ ಬೇರೆ ಇದೆ. ವೇಟ್.
ಧಾರವಾಡ ಬೆಂಚ್ finance members.
4 o'clock.
Please. Great.
With your lordship's leave, Kalburgi bench.
ಅದು 4 o'clock. Yes.
Let's continue.
With your
82. 82. 82.
Yes, sir. Mike, on ಮಾಡಿ.
Plaintiffs filed the application to implead the petitioner as a party to this suit. Because now your lordship can say she is not at all a necessary party.
That is allowed, is it?
Yes, ma'am.
Allowed.
Yes.
So what? Where is the order?
No. Order, my lord. Annexure 51.
Partition suit, huh?
Now plaintiffs filed this.
What is the suit for?
Suit for partition, my lord. Against father, mother, and the third defendant is the purchaser. During the pendency of the suit, third defendant.
Now who is impleaded, sir?
Impleaded she is a stranger to the property in question. She has nothing to do with the suit property.
You are for the respondent or petitioner?
I am for the here.
Who are you representing?
I am a petitioner, my lord, appearing for petition.
You are for the proposed defendant?
Proposed defendant. I am not a necessary party because my properties have not been mortgaged. The suicidal properties mortgaged by the third defendant who got purchased under
in whose favor?
Pardon me?
Mortgaged in whose favors?
Mortgaged in favor of the Canara Bank, my lord.
That is proposed defendant 4 and 5.
4 and 5.
Why are you brought into the picture?
No, without any reason, because I am no way concerned to the suit.
What's your name? Malati.
Yes, my lord.
Where is the order?
51, page number 51, my lord.
51.
Last para. That the present suit is one for the reliefs of declaration, partition, and separate possession in the separate possession. It is the contention of the plaintiff that the suicidal property is the ancestral and the joint family property of the plaintiff and the defendants 1 and 2. That the defendants 1 and 2 have alienated the suicidal property in favor of the third defendant. Third defendant has mortgaged the suicidal property in favor of defendant number 5. defendant number.
Heard the learned counsel appearing for the petitioner. There is no representation on behalf of the respondent. Interim order idea?
Illa.
We have the respondent. The petitioner, the proposed defendant number 4 is at the doors of this court, calling in question an order dated 9/12/2024, by which the concerned court allows the application filed under Order 1 Rule 10, seeking to implead Canara Bank and the present petitioner as party respondents. The reason rendered to allow the application is as follows, page 51. Not a word of reason is rendered by the concerned court as to why the present defendant number 4, proposed defendant number 4, should be a party to the proceedings. The narration is that the third defendant has mortgaged the property to the defendant number 5, the Canara Bank. Therefore, from where the petitioner springs is not answered by the concerned court. In that light, the order dated 9/12/2024 and the subsequent amendment of order dated 9/12/2024 and all further proceedings taken thereto, qua the proposed defendant number 4 shall remain stayed. Yes.
83.
Then Kumar,
The last date of also, my lord, they have taken time for 2 weeks for.
the learned counsel for the respondent Sachin, you are Sachin VR. Sachin VR seeks 2 weeks time finally, 2 weeks time to yet again to file statement of objections. Finally, 2 weeks time is granted to file objections, if any, list on 12th August in preliminary, the same stage.
What is the interim order?
Interim order subsisting will continue to the next date.
84.
Petitioner, my lord, matter pertains to nice quadra.
Lord, I filed my wakalat today, my lord, I'm yet to get.
Learned counsel submits Nitin Prasad, Allah. Learned counsel Nitin Prasad submits that he has filed his wakalat today and seeks 2 weeks time to file statement of objections. New.
I filed a memo of appearance today for this date.
Your name? So and so, a special counsel, yes. So and so submits that he has filed his wakalat for the first respondent. For the first respondent today, list the matter on 19th August, objections, if any, by any, by then.
Matter is covered, my lord. The short date may be.
Covered,
Please,
Lord, if
28
final
one.
notification is issued, it will stand covered, but I'll have to ascertain the facts.
Agadar, let it come on 5th August. You ascertain the facts. If it's covered, we'll close it.
Yes.
Please.
List on 5th August. Next.
Grateful, my lord.
85.
For petitioner, my lord. Lord, this is a case where the short point for consideration is that the preliminary notification issued to the converted property, my lord. This is covered by the judgment, my lord.
Lord, mere conversion, my lord, does not.
Kodi.
This is the latest.
What do you mean?
Month of January 2025.
Lord, circular dated 3/3/2007, my lord.
Also-
Lord, 18/3/2013, my lord. Oh, say that, my lord, converted land, my lord, but my lord, that is
I may
subject to, my lord,
submit it
not
to,
affecting the
relevant
contiguity and
courts.
compactness.
The learned counsel, objections, Haki. The learned counsel appearing for the petitioner submits that the issue in the list stands completely answered by the order of the coordinate bench in writ petition 6195 of 2023, which comes to be affirmed by the division bench.
No, that is challenge.
And the order in writ appeal 1476 of 2023. The learned counsel Pradeep Kumar seeks time to file his statement of objections. List the matter on 5th August.
My lord, there is an interim order.
Interim orders, idea?
They are in the process of alienating this.
2024, my lord.
This is all right. There shall be an interim order as prayed for till the next date of hearing.
2024.
Covered, sir.
Adರಲ್ಲಿ some
There are so many judgments, my lord.
619 from lord.
Whenever you want to file objection.
No.
There shall be an interim order of stay till the filing of the statement of objections. Yes.
Date may be.
Lord,
5th August.
in the referred judgment, my lord, there was a sanction plan. Lord, yes, the case, my lord, where, my lord, 2015, my lord, conversion order. Lord, conversion order says that, my lord, only within, my lord, 2 years, they have to implement the project. There is no, my lord, sanction plan. There's nothing, my lord. There's no relinquishment
You
deed
file
executed.
your objections, yes.
Great.
Yes, ಇದು ಒಂದು ವಾರ ಅಷ್ಟೇ 5th August ವರೆಗೆ ಹಾಕಿ, yes.
86.
ಅಲ್ಲಿ 85 ಅಲ್ಲಿ ಮೇಡಮ್ ರಿಜಿಸ್ಟ್ರಿ ಟು ಡಿಲೀಟ್ ದಿ ನೇಮ್ 85 ಅಲ್ಲೇ Registry, delete the name of PV Chandrasekhar as appearing for respondent 2 and 3. Then 86.
I represent for the petitioner in this case.
Yes, sir.
In this case, we had filed the original suit for partition, Your Honor. Under the
Suit,
social property, the amount has been dispersed.
86 ಯಾವ್ದಿದು?
Oh, yes, property has been acquired, compensation is for
Awarded,
disbursement.
they are dispersing the amounts. We have filed application for not to disperse the amount in the civil court, Your Honor, as per Annexure C, Your Honor. But the amount is.
ಏನ್ partition suit pending ಇದೆಯಾ?
Partition suit pending ಇದೆ.
ಯಾವಾಗ ಹಾಕಿದ್ suit?
Suit ಹಾಕಿರೋದು 19.
Compensation determine ಮಾಡಿದ್ ಯಾವಾಗ?
ಈಗ last year. That is as per G and G1, Your Honor.
Order was passed.
For
Order.
dispersing the amount, Your Honor.
Yes,
ನೀವು
SLAO
ಯಾರಿಗೆ?
has rejected
ರಾಜೇಂದ್ರ,
the.
ನೀವು ಯಾರಿಗೆ?
Plus, I am for the private respondents. Plus, this property, so the original survey number 43, which is the entire extent of 7 acres, was belonging to the one Nanjundappa. It was granted, it was an Inam land which was granted to him. I produced annexure R1, which is a grant registered. Subsequently, in 2002, there was a family partition where the father of the petitioner, he had 6 sons.
ಈಗ ಇನ್ನೊಂದು partition suit ಏನು?
ಈಗ
ಅಲ್ಲ ಒಂದೇ
partition
suit ಇದೆ.
suit, there was no partition, only
Petitioner's
rectification.
father
Release date was executed.
was not part of the joint family.
You are the beneficiary of the compensation
Yes.
amount. The sole beneficiary?
No, there are 4 children. What happened is Nanjundappa had 6 sons. 2 of them were not in the family. So in 2002, when the family partition took place amongst the father and the other 4 sons, 2 sons were kept out of the property.
These are the 2 persons.
Yes, petitioner's father was out of the, he was not party to the partition deed. Subsequently, in terms of that, mutation was also changed in the.
How can you leave out family members?
He was not part of the joint family. He had other part. I have produced page.
Why?
Page 12 of the statement of objections. I have produced that.
What is this now? What is the stage of the partition
Now,
suit?
suit is at the stage of evidence.
Evidence ಅಷ್ಟೇ. My submission is twofold. One, in 2004 itself, there was a mutation that was changed. Where petitioner's father name was not reflected. That is one. Second is he had executed a relinquishment deed, page 15 of my statement of objections.
When is that?
That was in 2018, where he received a consideration of around 10 lakhs. And he says, I have no right over any of the property of the family.
Where is that?
Page 15 of my statement of objections. I filed my objections. Was on 30th of January. Page 15, if my lords may come to, annexure R4. Second number, this is executed by
But that has
Siddhaganga.
been challenged because it was around 6 acres, Your Honor. Now the
Relinquishment.
that is also challenged, Your Honor, in the suit itself. Your Honor. It is not correct. They have been forcible and by mistake.
Forcefully.
Forcibly
ಈಗೇನ್
means they have been
ಕಾಂಪನ್ಸೇಷನ್ ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಬರ್ತಾ ಇದೆ ಅದಕ್ಕೆ ಎಲ್ಲ
ಇಲ್ಲ ಸುಮ್ಮನೆ ಆಗ
ಯು ಆರ್ ಡೂಯಿಂಗ್ ಅ ವೋಲ್ಟ್ ಆಫ್ ಫೇಸ್ ಅದೇನ್
No, no, no,
ಕಾಮನ್ ಹ್ಯೂಮನ್ ಟೆಂಡೆನ್ಸಿ ದಟ್ಸ್ ಆಲ್ ರೈಟ್
No,
ಏನ್
Your Honor,
ತಪ್ಪಿಲ್ಲ
kindly see, 6 acres was the total extent, Your Honor. He has been given only 10 lakhs and says that they have been deceived, Your Honor, by, he was.
ಈಗ ಎಷ್ಟು 6 ಎಕರೆಗೆ 10 ಲಕ್ಷನಾ
Entire extent.
Entire
require
extent
ಆಗಿಲ್ಲ.
ಎಷ್ಟಿದೆ?
Entire extent is ಒಬ್ಬೊಬ್ಬರಿಗೆ
Entire extent is 7 acres 3 guntas.
ಎಷ್ಟಕ್ಕೆ ತಗೊಂಡ್ರಿ
Out of it, only a portion has now been acquired.
ಆಯ್ತು ಈಗ ಕನ್ಸಿಡರೇಷನ್
ಈಗ ಗುಂಟಾಸ್ಗೆ 2.5 ಕೋಟಿ 3 ಕೋಟಿ ಕೊಡ್ತಾರೆ.
10 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀವಿ ಇದ್ರ ಪ್ರಕಾರ. Relinquishment deed says.
10 ಲಕ್ಷ ಎಷ್ಟು ಎಕರೆಗೆ?
It says by releasing his this thing in respect of the entire family properties.
ಅದು ಎಷ್ಟು ಎಕರೆ ಅದು?
7 acres.
7 acres.
7 acres. ಯಾವಾಗ ಇದಾಗಿದ್ದು?
This was in 2018.
2018. ಎಲ್ಲಿ ವೇರ್ ಇಸ್ ದಿ ಪ್ರಾಪರ್ಟಿ?
ಸೋಂಪುರ ವಿಲೇಜ್.
ಸೋಂಪುರ ಎಲ್ಲಿ?
ನ್ಯಾಷನಲ್ ಹೈವೇ ತುಮಕೂರು.
ಇಲ್ಲಿ
ನೆಲಮಂಗಲ ತಾಲೂಕಲ್ಲಿ ಬರುತ್ತೆ.
7 ಎಕರೆಗೆ 10 ಲಕ್ಷ.
ಅಲ್ಲ, please appreciate this.
There should be some semblance of fairness in it. Anything else? You should don't disburse compensation.
No, may I make.
ಅವ್ರಿಗೆ ಒಳ್ಳೇದು ಇಟ್ಕೊಂಡಿರ್ತಾರೆ.
May I make alternative submission? Today the suit is for 1/6 share. There is an interim order directing not to disperse.
Share is not
the
yet
entire
determined.
extent.
It is not yet determined.
No, the maximum that they are entitled to, they are claiming under only one son.
ಎಷ್ಟಿದೆ compensation?
Compensation amount, I am not sure.
Crores, Your Honor.
So, that,
of course, crores.
ಹೌದು 1/6 share, let it be deposited wherever it is. The balance,
Your claim is 1/6 share.
Yes, sir.
Then we'll direct them to withhold that and deposit the remainder of the compensation and disperse the remainder of the compensation.
Very good.
Yes, madam. The,
Yes, that we are agreeable anyway.
compensation ತಗೊಂಡು you have to, ಅವ್ರದ್ದು ಮಾತ್ರ ಇಲ್ಲ. We'll do that.
1/6 will be depositing in OS and 5/6 to be.
With disbursed to them, yes. The petitioner will dispose it then.
Much.
The petitioner is before this court seeking restraint on the respondent from, which respondent?
13 year.
ಬೇರೆ respondents ಇದಾರ ಇಲ್ಲಿ?
ಅದೇ all.
You are appearing for everybody?
Not everybody, the contesting private respondents, 1, 2, 4 to 7 and 12.
ಎಲ್ಲರಿಗೂ ಇದ್ದೀರಾ? 1, 2, 4, 7 and 12.
4 to 7 and 12.
8 to 11?
They are subsequent purchasers.
Purchase of the property.
Yes.
Anyway, contesting respondents are represented.
Yes.
The petitioners are before this court seeking the following prayer. Heard so and so. The petitioner is said to be the legal heirs of one Siddhagangappa. Siddhagangappa and Basavarajaya, the family members, is said to have entered into a partition way back in the year 2004.
2002, 15/4.
2002. In the said partition, the petitioners and their father were not parties. The claim is manifold, which is pending adjudication before the civil court in OS 449 of 2019, instituted by the petitioners, all the legal representatives of the deceased Siddhagangappa. The respondents, the contesting respondents in the subject petition are also defendants in the said case. The issue is not with regard to the merit of the matter pending before the concerned civil court in OS 449 of 2019. The issue is with regard to the compensation that the property has received pursuant to the acquisition for the formation of national highway at the hands of the National Highway Authority of India. The learned counsel for the petitioner submits that the compensation is determined in the year 2024. And the suit had been instituted way back in the year 2019 in IEOS 449 of 2019. He would submit that the petitioners are also entitled to compensation amount as being the joint family members who have deliberately been given up at the first instance when partition was arrived at between the family members. The learned counsel appearing for the respondent Rajendra contesting respondent Rajendra would refute the submission in taking this court through a document in the statement of objections, which is a release deed executed by the petitioner. The release deed so executed by the petitioner concerns 7 acres of land, for a consideration of 10 lakhs. Consideration of 10 lakhs. The learned counsel for the petitioner submits that the compensation determined today of the same land that is released is several crores, and therefore the relinquishment deed was taken by force. Be that as it may, all these issues are to be thrashed out before the concerned court, civil court in OS 449 of 2019. Insofar as the compensation is concerned, the learned counsel for the NHAI, Srimati Shilpa Shah, submits that the compensation order for compensation is passed. It is not yet disbursed. The claim of the petitioner ultimately is 1/6 share in the property. Therefore, compensation cannot be beyond his share, what he has claimed before the civil court. In that light, the claim of the compensation, the 1/6 share shall not be dispersed to any person any person till the conclusion of the suit. Insofar as the 5/6 share of the remaining claimants, the National Highway Authority, the respondent is 13th respondent is at liberty to disperse the same in accordance with law. In accordance with law. Compensation I'll deposit ಮಾಡ್ಬಿಡಿ. The 1/6 share of compensation which is directed not to be dispersed to anybody shall be deposited before the civil court in OS 449 of 2019, which shall remain subject to the result of the said OS. Will dispose it. In the light of the after receipt of the compensation from the hands of the NHAI, the other respondents who are now been directed disbursement of 5/6 of the compensation shall hand over possession without broking any delay.
That amount, court may be directed to deposit, make it.
The amount so deposited, the amount, i.e. the 1/6 share that is directed to be deposited before the civil court shall be invested in a interest earning fixed deposit in any nationalized bank, which shall however remain subject to the result of the petition. Result of the suit OS 449 of 2019. With the aforesaid observations, the petition stands disposed.
87.
Counsel for petition, my lord.
You Chennakeshava?
Yes, my lord.
ನಿಮ್ಮ ಹೆಸರು ಯಾವಾಗ ಚೇಂಜ್ ಮಾಡಿ?
Chennakeshava, my senior is Suresha. I am
Okay,
Chennakeshava.
I've received the copies today, my lords. Grant me some
Learned
time.
counsel Ajay Kumar seeks 2 weeks time to file statement of objections. List the matter.
Actually, ಇದು ಖಾತಾ ಆಗ್ಬೇಕಾದ್ರೆ ನಮ್ಮ ಹೆಸರು ಬಂದು ಎಲ್ಲಾ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಮ್ಮ ಹೆಸರು ಖಾತಾ ಮಾಡಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟು ಆತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
List the matter on 5th Saka 12th.
12th.
List the matter on 12th August. Our time ಕೇಳಬೇಡಿ.
I'll interest. Great.
Yes, next.
88.
Notice in this matter, notice I appear for the petitioner. Not the petitioners are
88 ಯಾರು ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಅವಾಗ್ಲೇ?
Not they are asking time. Not the fact is this. Not these are the not the petitioners are the decree holders. Not they obtained a decree against not the respondent number 1 and 2, who are not the judgment debtors. Now not they have set up not their sister as not the objector. Not the who is the not
2197 application.
Yes, not the fact is this. Not the suit is for not the declaration and injunction, not the mandatory injunction. Not after full-fledged trial, not the suit is decreed. Against which not they have preferred and not the RF regular first appeal before this honorable court. Not that not also dismissed. But thereafter not we approached the trial court or executing court. Not kindly I may be permitted to execute the decree. Accordingly, not the order has been passed. Not while executing the not may take not the ADLR not the report.
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಹೇಳಿ?
ಅಲ್ಲ ಇಲ್ಲಿ ನಾನು only not I have filed an application before the trial court. Not the objector is not the objecting for the portion of the property which claimed to be seized in possession of the property. Not the remaining portion they themselves said that not it is the JDR not they are in possession that may be not demolished. I may be permitted to take page number 28 not.
Yes, sir.
Not.
ಒಂದು ನಿಮಿಷ.
The petitioners here have filed a original suit in OS number 10.
ಅಯ್ಯೋ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ 1950 ಹೋಗ್ಬೇಡಿ. ಇದು ಆರ್ಡರ್ ಏನ್ ಹೇಳಿ?
ಕೇಸ್ ಹಾಕಿದ್ರು, ಆ ಕೇಸ್ ವಜಾ ಆಗಿದೆ ಸರ್.
ಯಾವ ಕೇಸ್ ವಜಾ ಆಗಿದೆ?
ಇದೇ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದ್ರು. 10/480 of 98.
ಪೇಜ್
ಪೇಜ್ ನಂಬರ್ 103
ಅಲ್ಲ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್
ಅಲ್ಲ ಇದು ಹೇಳ್ತೀನಿ ನಮ್ಗಾದ್ರೂ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಡಿ.
ಏನದು?
ಪೇಜ್ ನಂಬರ್ 103 ಸರ್. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್
103 ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಪ್ರೇ ಫಾರ್ ಟೈಮ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೇನೆ ನಾನು.
ಹಾಕಿ
ಪ್ಲೀಸ್.
may I request may I take not 1 minute madam. I will not take more than that.
Let him file his objections.
ಅಲ್ಲ page number 20 ಒಂದೇ ನಿಮಿಷ ನಾನು ತೋರಿಸಿಬಿಡ್ತೀನಿ. ನೋಡಿ what is their claim. Not they kindly see the page number 140. Not this is the ADLR sketch which has been accepted by the trial court. Not they declared the suit. Not in that not 40 into 41 is our property. Not that exactly come to not of the C, A, C, F and H. Not page number 140. Not page number 140. Not.
Yes, sir.
The decree is not of the A, C, F and H. Not F and S. Not this is 40 into 41. Not east to west. Not of the 40. Not north to south 41. Not now they are claiming is not the property D, B, G and E.
Page 140.
140.
ಸ್ಕೆಚ್ ಇದೆಯಾ?
sketch, ADLR sketch. ನೋಡ್ರಿ ADLR sketch ಮಾಡು. Next,
ನಾನು ಅದನ್ನೇ
next.
ನೆಕ್ಸ್ಟ್ ಇದು.
ಅಲ್ಲ ADLR sketch.
ನೀವು ಸ್ಕೆಚ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಹಾಕಿದ್ದು. ಅಲ್ಲೇ ಪಕ್ಕದಲ್ಲಿ.
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ನೋಡಿ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನ್ ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಅವ್ರ ಪೋರ್ಷನ್ ಬಿಟ್ಟು ಉಳಿದಿರೋ ಪೋರ್ಷನ್ ನಾನು ಡೆಮಾಲಿಷನ್ ಮಾಡಿ ಅಷ್ಟೇ. ಇದರಲ್ಲಿ ಐ ಮೇಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಆಲ್ಸೋ.
ನಿಮ್ ಕ್ಲೈಮ್ ಎಷ್ಟು?
ಅಲ್ಲ ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಯು ಆರ್ ಕ್ಲೈಮಿಂಗ್.
ಅಲ್ಲ ಎಂಟೈರ್ ಡಿಗ್ರಿ ಇರೋದು
ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿ ವಜಾಗಿದೆ
ಪೇಜ್ ನಂಬರ್ 28 ಅವರೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ
ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದ್ರ?
ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
They had filed not they are stating that not they had filed a injunction suit. Not this is a declaration suit.
ಸಾರಿ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದ್ರ?
ಅವ್ರು ಹಾಕಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಮಾಡು.
ನೀವು ಹಾಕಿದ್ ಸರ್?
ಇಲ್ಲ ಸ್ವಾಮಿ ನಾನಲ್ಲ.
ಪೇಜ್ ನಂಬರ್
ಅವರೇ ಹೇಳ್ತಾರೆ ಪೇಜ್ ನಂಬರ್ 103 ಪ್ಲೀಸ್ ಮೇಲೆ.
103
our statement of objection.
ಇಲ್ಲಿದೆ
ನಿಮ್ ಅಬ್ಜೆಕ್ಷನ್.
ನಾನು we will produce the entire documents before the court.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ವಾ?
ಇದು objection.
103 of the statement of objection ಅಂತ ಇದ್ದೀರಾ?
Before the trial court. I will file my entire
moment page number 28 notes. ಒಂದೇ ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಅವ್ರದೇ ಸಬ್ಮಿಷನ್ ತೋರಿಸ್ತೀನಿ.
ಪೂರ್ತಿ ಪ್ರಾಪರ್ಟಿ ಕ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಅದನ್ನೇ ನಾನು ಒಂದೇ ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತೀನಿ. ಪೇಜ್ ನಂಬರ್ 28 28 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಇಟ್ ಇಸ್ ದೇರ್ ಸಬ್ಮಿಷನ್. ನೋಡಿ learned friend has not the submitted before the page number 28 notes second para notes bailiff filed a report. Counsel for the objector has stated that as per the order of this court the property is in possession is not demolished and part of the property in possession of the judgment debtor have been demolished. It is their statement only, not before the trial court. Immediately we have made an application before the trial court.
List the matter on 30th. Objections by the respondent if by the objections by R1 and R2 na?
I appear for the R3.
R3 na? Objections if any by the third respondent by then. Yes. Who R2 and R1 and R2 yaru?
R1 and R2 they only not representing in trial court.
See Rajanna yaru?
I appear for.
Rajanna and Muni Gangappa are different.
Muni Gangappa he saw time they went away. He was here
on 30th. Yes.
89 party in person.
My lord, as per the instruction passed on by this honorable court.
For
instructions,
my lord, in this matter.
I appeared before the committee.
For response number 6, my lord. I need to file wakalat and objection, my lord. Yes,
Bhimaya kottidira?
Please, my lord. And we need to file wakalat.
Copy is served on you?
Yes, my lord.
The learned counsel KS Bhimaya seeks 10 days time to file statement of objections. Objections, if any, by the 5th of August. List the matter on 5th of August. Yes. Let them file their objections. Yes.
Thank you.
Next.
This IAP for responding. This may be connected along with another petition between the same party.
Kodi, tag the petition along with number barcode.
16908 of 2025.
Yes, so and so. List the matter after 2 weeks. Interim order subsisting will continue to the next date of hearing. Next.
91.
May have this matter day after tomorrow. Whether it is covered or not, I'll make submission.
Learned counsel for the respondent TP Vivekanand seeks 2 days time to go through the papers and make his submissions. Friday. List on Friday.
Please.
92.
In this matter, I pray for 10 days time to file objections.
Objections. Counsel for TP Vivekanand seeks 2 weeks time to file statement of objections. List on 12th August. Objections, if any, by then. Yes, next.
93.
Only challenging the annexure H. Mila.
Yenadu?
I have obtained the requisition to NOC Mila, 1 acre land. The land was acquired the acquisition Mila. And
Respondent ಬರ್ಲಿ
then
ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ 1 ಎಕರೆ ಬಿಟ್ಟಿರೋದಕ್ಕೆ ಅನ್ವಸಿ ಕೇಳ್ತಾ ಇದೀವಿ.
From R2 and R3. There is no representation on behalf of the respondent. Howda? Registry to appropriately print the name as AV Gangadaraya in place of KV Gangadaraya. List on 5th August. Next.
Please.
94,
For petitioner. My lord, connected matter.
Not yet received wakalat.
Learned Counsel H.L. Pradeep Kumar seeks 3 weeks time to file statement of objections. 12th August, objections if any by then.
Connected matter. Annexer in my lord. Page number 61.
Tag the petition along with page
61 my lord.
page 61.
Kindly grant
List
interim
them both on 12th. Adil interim order idea?
order. My lord.
In the light of the interim order subsisting in the aforesaid petition, there shall be an interim order as is obtaining in the aforesaid petition. Yes. Idea interim order?
Not to precipitate antide.
ಅಷ್ಟೇ ಸೇಮ್ ನಾಟ್ ಟು ಪ್ರೆಸಿಪಿಟೇಟ್
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀನಿ ಎಲ್ಲದರಲ್ಲೂ
ಹಾಕಿ,
ಸ್ಟೇ
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
ಇಟ್ಸ್ ವೆರಿ ಡಿಫಿಕಲ್ಟ್.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ಯಾ? ಎಸ್ ಹಾಕಿ. ಎಷ್ಟು 5th 12th ತಗೊಂತೀನಿ.
hearing on IA, 95,
Responding to you.
2006
Lord, it is
Amendment
remanded by
petition
my
is
lord the
not-
Supreme Court recently. My lord, I don't have writ petition.
Filed
copy,
IA,
my
my
lord.
lords,
Amendment petition.
Lord, recently my lord the
Apex
Supreme
Court
Serve a copy,
remand
my
ಮಾಡಿದ್ದಾರೆ.
lords. I'll serve a copy, my lords.
ನಮ್ಮ ಹತ್ರ ಏನ್ ಕಾಪಿ ಇಲ್ಲ.
ಡಿಲೇ ಕಂಡೋನ್ಡ್ ಅಪಲೆಂಟ್ಸ್ ಪ್ರೇಯರ್ ಯಾವತ್ತಾಗಿರೋದು ರಿಮಾಂಡ್?
Lords, it's on, I filed a memo, my lords, on 11/6. It's on, my lords, 7th March 2025.
ಇವಾಗ ರೀಸೆಂಟ್
11/6
Copy.
memo, my lords.
Dismissed as withdrawn.
Lords, what has happened, my lords, the writ appeals were allowed, my lords.
Permission is granted to withdraw these appeals, meaning thereby the impugned order will stand. The parties are granted liberty to work out a remedy
If any
pursuant to the impugned order.
Please, my lords.
Where is the revival of these proceedings?
Lords, what has happened, my lords, writ appeals were allowed, my lords, reverting the writ petitions back to the single judge, my lords, on the ground whether scheme under 18 to 23, my lords, whether.
So now the impugned order will stand. What was the impugned order? The division bench
Writ
order?
appeal was allowed, my lords.
Writ appeal was allowed, the matter was remitted back to the single
On
judge.
the scheme, whether the scheme has been, my lords, followed, 18 to 23 was followed or not, my lords. That was standing before the Supreme
Apex
Court in
Court.
SLP, my lords. SLP was withdrawn because it was long standing there.
Oh, SLP is 2013.
Please, my lords, it was withdrawn, my lords, to work out the remedy. As a scheme, my lords, 18 to 23.
Papers.
ತಗೊಂಬನ್ನಿ
ಕಳ್ಸಿದೀವಿ, ಕೊಡ್ತೀವಿ ಸುಮ್ಮನೆ.
ಆಲ್ ಓವರ್ ಅಗೇನ್ ಒಂದು ಕೊಡಿ.
Please, ಕೊಡ್ತೀನಿ.
ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್?
But recently, my lord, Supreme Court held that, my lord, the pre-requisition of the scheme, my lord, before initiation by acquisition
ಆಯ್ತು, ಈಗ
proceedings
ವಾಪಸ್
is not.
ಬಂದಿದೆ, ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಇನ್ನೊಂದು
But the
ಕೇಸಲ್ಲಿ
initiation, my lords, whether it's been to be implemented or not, my lords, subsequent to the acquisition, that was, my lords, to be looked into, my lords, before the
We'll
single
see.
judge.
The subject petition is of the year 2006. It is back on board on a particular circumstance. The division bench had allowed the writ appeal and remitted the matter back to the learned single judge for further consideration, for a consideration afresh. This was called in question before the Apex Court in 2013. The Apex Court in terms of its order dated 11/3/2025 has permitted the appellants therein to withdraw the petition and observes that the order of the division bench would stand affirmed. In that light, in the light of the division bench remitting the matter back to the hands of this court, as observed here in above, the matter is back on board. The learned counsel respondent, Pradeep Kumar, seeks 2 weeks time to go through the papers and make his submissions. Petitioner to serve set of papers upon the said counsel. List on 7th August.
My name may be shown, my lord. Mr. Sabras.
Registry to print the name of
HL
ನಿಮ್ದ
95.1 ಅಲ್ಲಿ.
95.1 registry to delete the name of Basavaraj V. Shabrad and print the name of HL Pradeep Kumar. Yes. 7th August. Copy ಎಲ್ಲರಿಗೂ ಕೊಟ್ಬಿಡಿ.
96,
96 more, Lordship, permit me to appear through video conference because I could not come. Sorry.
Yes, sir.
We have filed an application for early hearing, my lords.
Rule issue ಆಗಿದೆಯಾ?
Neither possession is
Early
taken
hearing
nor
ಇಲ್ಲ.
Reading, sir.
Who's the contesting respondent? State.
PDM.
BDM.
Who appears? BDA ಯಾರು? Who appears?
Lord Girish. NR Girish.
What's the matter, sir?
The 2001, my lords, is a notification. Neither possession is taken nor compensation is paid. Therefore, we are seeking for a declaration that the entire acquisition proceedings stand lapsed. But a recent judgment of the Honorable Justice, my lord, if lords permit me to state about Justice Devdas, where in that nice matters, my lord, series of matters, his lordship has quashed it. Where, of course, it was under the KIDB Act, but the principle is, my lord, neither possession is taken nor compensation is paid. 24 years since then.
All right, yes. Heard the learned senior counsel Prabhuling Navadgi appearing for the petitioner. There is no representation on behalf of the BDA. The learned senior counsel submits that the issue in the list stands answered by a judgment delivered by the coordinate bench in series of cases where acquisition is quashed owing to the fact that no possession is taken nor award is passed.
Correct.
The learned senior counsel submits though those cases where under the Land Acquisition Act,
KIDB.
under the KIDB Act, the principles laid down therein would have become applicable to the case at hand as well. Awaiting the appearance of the counsel for the BDA, list this matter on 7th August. In the event the counsel for the BDA would not be present, appropriate orders would be passed on hearing the learned senior counsel for the petition. Next, intermodal, yeah? Yes, next.
Great.
97.
Petitioner.
ಇದ್ಯಾಕಲ್ಲಿ ಟ್ಯಾಗ್ ಮಾಡಕ್ ಹೇಳಿದ್ನಲ್ಲ?
ಟ್ಯಾಗ್ ಮಾಡಿ ಇದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿದೆ, ತಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ.
Yes.
Second and last occasion, your lordship's executive officer was present and filed the photos of the present condition of the building in lots. If the
ಈಗ you suffered orders, is it?
Yes, my lord, suffered orders.
Then
now the question is, my lord, the orders from this honorable court has taken on a premise that they are going to demolish the building.
We'll recall it.
That's
We
right.
hear it. Review ಹಾಕಿದ್ದೀರಾ ಏನಿದು?
ಇಲ್ಲ, application that coordinate bench has application has to be filed ಅಂತ ಹೇಳಿ application ಹಾಕಿದ್ರು.
ಏನ್ application? Recall.
Recall.
ಇದು order on IA 2 of 2025 seeking recalling of the order ಅಂತಿದೆಯಲ್ಲ ಮೇಡಮ್, ಅದರಲ್ಲಿ ಬರೀದೆ. ಮೇಡಮ್ ಬೇರೆ my orders. Batch of alignment. Conglomeration of these cases were disposed on 26th March 2025 on a particular premise. The premise is captured in the order. Therefore, I deem it appropriate to paraphrase the order as the order of the subject application. The order reads as follows. Full application. The application, the petitions come to be disposed on the score that the buildings in which the petitioners were doing their business in the precincts of the temple was in a dilapidated condition. The submission by the respondent appearing for the temple was also that it was in a dilapidated condition, while the petitioners throughout disputed. A paragraph of observation has become the bone of contention today. The submission then was that if the petitioners would give way on their own by delivering vacant possession of the property, the shop building would be demolished, and in the event the new shops would be constructed, the petitioners would be given precedence over any other person to restart their business or continue the business as the case would be. The petitioner, the respondent now would seek to contend that they are not going to reconstruct the shops, as there are no funds with the temple to reconstruct the shops, and therefore they would demolish the building and leave it at that, and demolish the building, make the place a ground, make the place a plain ground, playground alla, plain ground, and leave it at that. Therefore, the petitioners who are vending, ಎಷ್ಟು ವರ್ಷದಿಂದ?
Nearly 30 years.
Petitioners who are doing their business for now close to 30 years would be left in the lurch. Therefore, the order that was disposed on the premise of on the aforesaid premise is necessary to be recalled and the matter to be heard on its merit. In that light, for the aforesaid reasons, the order dated 26 March 2025 stands recalled. Lists the matter for hearing on 1st August. The petitioners shall not be evicted from their business or the premises till the next date.
In another connected two matters, there is an interim order of interim.
Apart from the said order, if any other kind of interim order is subsisting in any of the cases, shall continue to the next date of hearing.
Lordships, in the second and third matter, my lord, but they have not paid arrears, damages, my lord, 5 lakh.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ನಾವು 1,100 ರೂಪಾಯಿ ರೆಂಟ್ ಇದೆ, ಅದು ಕೊಡ್ತಾ ಇದೀವಿ ಕ್ಲೀನ್ ಆಗಿ. ಅವ್ರೀಗ ಅದರ 4% ಡ್ಯಾಮೇಜಸ್ ಅಂತ ಹೇಳೋದು. ಇಲ್ಲಿ ಹೇಳುವಾಗ ಅವ್ರು ಏನೂ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳೋದು.
ಡ್ಯಾಮೇಜಸ್ ಯಾಕೆ?
ಅದೇ ಅವ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಡ್ಯಾಮೇಜಸ್ ಯಾಕೆ ಮೇಡಮ್?
They are enjoying the premises, my lord.
ಅದೇ ಡ್ಯಾಮೇಜಸ್ ಕೊಡ್ಬೇಕಾ?
From the year 2015, my lord, they are in possession and they are not paid any rent and all, nothing.
ರೆಂಟ್ ಕೊಡ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ, ರೆಂಟ್ ತಿಂಗಳ ಕೊಡ್ತಾ ಇದೀವಿ. ಜನವರಿಯಿಂದ ಅವರು ಚೆಕ್ ಅನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
False submission.
ನಾನು ಕೊಡ್ತೀನಿ ಅದನ್ನ. ನಾನು ಕೊಟ್ಟಿರೋದು
ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, ನಾನು ಅವ್ರು ಕೊಟ್ಟಿದ್ದನ್ನ ದಾಖಲೆ ಕೊಡ್ತೀನಿ.
ಹಿಂಗಂದ್ರೆ
ಕೊಟ್ಟಿದ್ದನ್ನ ದಾಖಲೆ ಕೊಡ್ತೀನಿ ಅಂದೆ.
ದಾಖಲೆ
Check.
ಅದಕ್ಕೆ ಯಾಕೆ ಹಿಂಗ್ ತೋರಿಸ್ತೀರಾ?
My lord, they are giving check in wrong address, my lord. The check is bounced.
ದೇವಸ್ಥಾನಕ್ಕೆ ರಾಂಗ್ ಅಡ್ರೆಸ್ ಬೇರೆ ಇದೆಯಾ?
ಅವರೇ ಬಂದು ಕಲೆಕ್ಟ್ ಮಾಡೋದು. ಇನ್ನು ನಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು ಬೇಡ, ಔಟ್ ಆಫ್ ಕಂಟೆನ್ಷನ್ ಹೇಳೋದು ಬೇಕಾಗಿಲ್ಲ.
My lord, that is not correct. Karekal Anjaneya Swami temple, they have to write, supposed to write, my lord. They are
ಬೇರೆ ದೇವರ ಹೆಸರು ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ ಹಾಕ್ಕೊಡೋದು.
KA Anjaneya Swami temple, they are.
ಇನಿಷಿಯಲ್ ಇದೆಯಾ?
They are putting, my lord.
ಆಂಜನೇಯ ಸ್ವಾಮಿಗೆ
Purposefully they are putting and bouncing the check, my lords.
ಅಲ್ಲ, ದೇವ್ರಿಗೆ ಇನಿಷಿಯಲ್ ಕೊಡಕ್ಕೂ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಈಗ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
KA ಆಂಜನೇಯ ಸ್ವಾಮಿ
ಇವು 15 ವರ್ಷದಿಂದ ಹ್ಯಾಕ್ ಕೊಡ್ತಾ ಇದೀವಿ, ಹಾಗೆ ಕೊಡ್ತಾ ಇದೀವಿ. ಅದನ್ನ ಅವ್ರು ತಗೊಳ್ತಾ ಇಲ್ಲ. ಚೆಕ್ ಅನ್ನ ಈಗ ಜನವರಿವರೆಗೆ ಕೊಟ್ಟಿರೋದನ್ನ ತಗೊಂಡಿದ್ರೆ ಕ್ಯಾಶ್ ಆಗಿದೆ.
ಈಗ ಅರಿಯರ್ಸ್ ಅಲ್ಲಿ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಜನವರಿವರೆಗೆ ನಾವು ಕೊಟ್ಟಿದೀವಿ ಎಲ್ಲವೂ.
ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ
ದಾಖಲೆ ಕೊಡ್ತೀವಿ. ಅವ್ರು ಈಗ ಜನವರಿಯಿಂದ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ಈಗ ಹೇಳ್ತಾರೆ ಅದು ಇದಾಕಿದಾರ ಅಂತ ಹೇಳಿ.
ಚೆಕ್ ಅಲ್ಲಿ KA ಆಂಜನೇಯ ಸ್ವಾಮಿ ಅಂತ ಬರ್ದಿದಾರ?
ಬರ್ದಿದ್ದಾರೆ, ಅದನ್ನ ರಿಟರ್ನ್ ಆಗಿದ್ದನ್ನು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕೊಡಿ, ಫೈಲ್ ಮಾಡಿ ಎಲ್ಲ.
Yes, my lord.
ನೀವು ಡೋಂಟ್
ಇಲ್ಲ ಆತರ
ಡೋಂಟ್ ಬಿಗಿನ್ ಟು ಪುಟ್ ಇನಿಷಿಯಲ್ಸ್ ಟು ಗಾಡ್.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Let them give the DD, my lords.
ಎಲ್ಲ ಡಿಡಿ ಕೊಟ್ಬಿಡಿ. ನೋ ಮೋರ್ ಚೆಕ್ಸ್.
ಆಯ್ತು.
ನೋ ಮೋರ್ ಚೆಕ್ಸ್ ಅಂಡ್ ಬ್ಯಾಲೆನ್ಸ್, ಓನ್ಲಿ ಡಿಡಿ.
ಆಯ್ತು.
Within 1 week they have to.
1ನೇ ತಾರೀಕಿಗೆ ಇಲ್ಲಿ ತಂದು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಫಸ್ಟ್.
98.
Petitioner's land is acquired by KADB. Mandamus to my lord release compensation, my lord, insofar as the land has been acquired.
One moment.
Petitioner's land came to be acquired, my lord, in 2020 by KADB. Pursuant to which, my lord, Tahsildar has given a report to his custodian of the revenue records, stating that, my lord, all the revenue records are in my name. And there's a joint measurement committee, my lord, which goes into the area and measures, my lord, whether physically we are in possession to the extent which has been acquired to. JMC committee also, my lord, has given a report in my favor. And before this court, my lord, seeking compensation, release of compensation, my lord, in the statement of objection filed by KADB, they said that they can consider my prayer, my lord.
Will consider in accordance with law, my lord. We have filed an affidavit.
We are appearing for impleading applicant, my lord.
Impleading applicant, who are you?
Proposed R4, my lordship.
Who is that proposed R4?
We are the family
member.
Family member of the petitioner number 4, my lordship. There is a compromise petition which is executed. The IM.
Shivaprasad, ಏನದು?
My lords, may kindly go to the compromise petition. In that compromise, that is not related to this survey number at all. This
page.
Kindly see
compensation ಬರ್ಬೇಕಾದ್ರೆ ಸುಮಾರು ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಬರ್ತಾರೆ.
Their compromise, my lord, is at annexure A1. Kindly see, my lord, the alleged compromise is with respect to survey number 261 measuring 3 acres.
ಇದೇನು?
This is, my lord, survey number 119/261
ಏನ್ ಸಂಬಂಧ?
119/P23 measuring 16 acres. Now, my lord, they're before this court only based on the alleged compromise petition, my lord, they're before this court saying that they have a share.
And pass out.
Lord, in the light of the Tahsildar report and the JMC committee report,
which is that annexures?
Annexure, my lord, that is annexure H and annexure J.
Annexure H page
number 74 and annexure J page 76. In the light of the reports, my lord, let them consider my case and them pass appropriate orders.
Yes, post 2 months. Yes,
please.
Next.
59.
The acquisition proceedings pertaining to the Arkavati layout was referred to the committee, this is Keshan committee, and the report has been submitted.
The committee's recommendation is to delete the land, my lords. Now the BDA will have to write to the government with a recommendation whether the land is needed or not. It is at that stage. That is pursuant to the order passed by the learned single judge of this honorable court.
Oh, that Keshan are in committee. Sumar matters ಆಗಿರ್ಬೇಕಲ್ಲ ಆಯ್ತದೆ.
ಆಗಿದೆ.
So once the recommendation of deletion has been made, the contention of the my learned friend is that that should suffice, and the question of again BDA to apply its mind or the government to
So
say.
whatever the coordinate benches have passed, I will pass.
It's that ratio has not been altered, my lord. My lord, the entire committee constitution was by the learned.
Covered ಅಲ್ಲ ಅಂತನ.
Covered ಅಲ್ಲ. It is not.
ಎಲ್ಲದಕ್ಕೂ covered ಅಲ್ಲ ಅನ್ಬೇಡಿ. Covered ಇದ್ರೆ covered.
ಇಲ್ಲ ಇದ್ರೆ if it is there, my lord, I will also have the
Kindly peruse the sketch which is annexed.
No. How do you say this is covered?
Now, this particular aspect has been considered by the committee that so far as my land is concerned. For a moment, I take my lord to the sketch.
There is a recommendation.
There is a recommendation. It holds that
these
all
are also
over
cases. These are also cases where recommendation was there.
Recommendation was
Just
there.
watch and
And,
appeal ಆಯ್ತು ನೀವು.
I've not seen it, my lords, but in this case, my lords, I'll just see if the BDA had written to the government, my lord, for.
Let's see. List on Thursday in preliminary hearing.
Hello.
Friday.
Contention of the petitioner where this is the island. So it was dropped.
Yes.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಇದ್ರಲ್ಲಿ
Let's see.
ಇದ್ರಲ್ಲಿ ನಾನು ಅಪಿಯರ್ ಆಗಿದ್ದೆ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು, once the committee had made the recommendation, BDA had written to the state saying that we need the land. State had seconded the opinion of the BDA, and then that was looked into by the honorable single judge. In this case, the said
Committee report is also placed before the court in these matters.
All right. Let me see. List on Friday. Let me also see.
This coming
List on Friday in preliminary hearing.
This coming Friday, my lords. Please.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಅಷ್ಟೇ.
Please.
100.
Lords, appearing for the petitions council. In this matter, Lords, survey number 31/1 measures 2 acres 10 guntas.
You're out?
Lords, yes. Lords, survey number 31/1 measures 2 acres 10 guntas. Entire property was subject matter of acquisition. When the acquisition was alive, 18 guntas was utilized for formation of the road. Applications were moved by the notified khatedar for denotification of the land. 1 acre 10 guntas is denotified. So what is remaining with the BDA is 22 guntas. Now this 22 guntas was converted into sites, and they have allotted 5 sites. May I just pass on a memo of calculation as to how the extents are working out, Lords? May I just pass this on? Lords, if your lords were to see land retained by BDA is at serial number 4, 22 guntas. They formed 5 sites and they have already allotted 21 guntas. It's actually 22 guntas in substance. By going by the square meters, it is 21 guntas. It's showing 22 guntas is allotted. Now what they do, we are the purchasers from the notified khatedar Pilliga under 4 registered sale deeds in relation to site numbers 2, 3, 5 and 6. Now they have allotted this portion of the property, which is essentially the denotified portion, in favor of respondents 5 and 6. If your lords were to see the cost title minutes. At the internal page number 7.
5 and 6.
5 and 6. They don't have anything to allot. Aster.
ಇನ್ನೇನಾದ್ರೂ ಇದೆಯಾ? Cost title is his case.
Annexure R1 to my statement objection can be seen.
How did you allot a denotified land?
It is not the correct matter. Denotified area is my lord, this is the denotified area 1 acre 10 guntas. The sites are allotted, my lord, this portion is acquired area. The sites are allotted in this.
Who is the 6th respondent?
Lord, 6th respondent is also given this on the premise. It's an alternative site. We definitely don't know, but fact remains. If BDA has already
ಅವ್ರಿಗೇನ್ ಕ್ಲೌಟ್ ಇಲ್ವಾ?
ಇರ್ಬೋದು, ಇಲ್ದಲೆ ಏನ್ ಕೊಡೋದಿಲ್ಲ. ಈ ಜಾಗದಲ್ಲಿ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಅಂತ ಕೊಡಬೇಕು ಅಂತಂದ್ರೆ ಹಾಗೆ ಅಂತೂ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ.
ಈಗ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ MLC ಅವ್ರಿಗೆ ಯಾವಾಗ ಹೆಂಗ್ ಕೊಟ್ರಿ ಸರ್?
2006 my lord.
ಅವಾಗ ಕೊಟ್ರದ?
2006 it is allotted in the 2006.
2016.
6.
ಅಲ್ಲ.
ಅದು annexure మరి annexure
Page. Where is the allotment? How can it be
Page
2006?
181, ಹಂಚಿಕೆ ಪತ್ರ 2016, 27/7/2016.
Page 1.
161, 181. And 182. Lords, it's what they require to answer, which they will never answer, is how can you allot beyond 22 guntas? You have retained.
22 guntas is denotified.
Yes.
Correct.
22 guntas is retained. 1 acre 10 guntas is denotified.
No, 1 minute. Out of total extent, heli.
Lords, total extent is 2 acres 10 guntas.
No, this memo
Lords,
is.
may kindly have a look at the memo, Lords.
Memo
See.
is illustrative.
Yes.
Now, so 31/1 is 2 acres 10 guntas.
Yes.
Denotified land is 1 acre 10 guntas.
10 guntas.
All right.
18
left
guntas.
behind for formation of road, 18 guntas.
18 guntas admittedly has gone for formation of the road, which is at page 49.
Correct.
So what is retained by the BDA is 22 guntas.
22 guntas.
Yes. Now we have produced the copies of the 5 sale deeds which has been executed by the BDA for site numbers 1, 2, 3, 4, 5.
ಈಗ ಈ 22 guntas cover ಆಯ್ತಾ ಅಲ್ಲಿ?
Completely covered.
ಯಾವುದು 5 sites?
5 sites. Even going by the square meters, it is 21.01 guntas.
How that denotified land comes to you?
Yes. I have purchased it from Pilliga.
Correct.
Who is
You
the notified
purchased it,
khatedar.
that was denotified. You have
Yes.
formed sites, sold the sites.
Yes.
Now the sites that you have sold are now allotted to this MLC.
Yes.
That is not. No.
No.
I undertake.
ಆರನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ
5th is
ಇಲ್ಲ ಸಿಟಿ ರವಿಗ
5th.
ಎಸ್
In so far as that road, the 18 guntas which they are showing, my lord, now the BDA record says it is not 18 guntas utilized for the formation of road, it is only 12 guntas.
6 ಗುಂಟೆ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ?
ಅಲ್ಲ, ರೋಡ್ ಇವ್ರು ಹೇಳ್ತಿರೋ 18 ಗುಂಟೆ ಯುಟಿಲೈಸ್ ಆಗಿಲ್ಲ as per the BDA
ಎಲ್ಲಿದೆ
records.
ಬೇರೆ ಅಬ್ಜೆಕ್ಷನ್?
That is what it is not yet filed, my lord.
Filed the objection.
Award is passed for 18 guntas.
My lord, in the annexure R1 kindly see the I have filed all.
Number 56.
They are claiming the portion of that land on the other side.
20th
2024.
6 is not yet served.
ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, statement of objection.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ?
ಅವರು 5 and 6 are.
5 ನೀವಾ?
5 I undertake to file.
Objections ಹಾಕಲ್ವಾ?
ಇಲ್ಲ, not yet filed, my lord. I am undertaking to file wakalat for R5.
ಈಗ ಎಷ್ಟು alert
R6 is
ಆಗಿದೆ
await service ಇದೆ. R6 I am not.
ಎಷ್ಟು ಅಲರ್ಟ್ ಆಗಿದೆ?
Only one site, my lord.
ಡೈಮೆನ್ಷನ್
Dimension.
Page 181.
ಅಲ್ಲ ಅವ್ರು ಯಾರಿಗೋ
479 square meters.
ಅಲ್ಲ ಲೇಔಟ್ 5 sites ಫಾರ್ಮ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಆ sites ನಿಮಗೆ ಅಲಾಟ್ ಮಾಡಿದ್ದು ಹೆಂಗೆ?
Swami, sketch ಅಲ್ಲಿ ಈ sketch is only
Dispute is, my lord, which is the portion, my lord. This is, my lord, 31/1.
ಈಗ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ? ಅವ್ರು ಇದಾರೆ ಎಲ್ಲ?
Yes. Then what? These are all constructed areas. Wherever they have made the allotment, there are constructions.
ಇಲ್ಲ, that is not.
This is the 31.
So ಅಲ್ಲ ರವಿಶಂಕರ್ sir,
Lordships.
if all of you are there deciding, that cannot be allotted obviously.
Yes.
First thing. And if that 6 guntas is allotted in the land allotted to BDA, why, how are you aggrieved?
Lords, I will not be aggrieved if this land is not, is allotted out of the land which is retained by BDA.
Yes.
If we go by the numbers.
18 guntas of land.
Lords, kindly have a look at page 56, because BDA should not speak beyond their records, and I do not understand
No,
why.
Ravishankar sir.
Page
now,
56 will not
left
speak.
land left for formation of BEL road.
Correct. Page 56, that details are forthcoming. Whatever I have put it on the memo, my lords, is what is there in the note sheet of the BDA, for which the award is constituted.
Page 56 note sheet.
Note sheet, survey sketch ನಂತೆ. 009 ನಲ್ಲಿ ದೇವಸಂದ್ರ ಸರ್ವೆ ನಂಬರ್ 31 2 ಎಕರೆ 10 ಗುಂಟೆ.
10 ಗುಂಟೆ.
ಭೂಸ್ವಾಧೀನದಿಂದ ಕೈ ಬಿಟ್ಟಿರುವ ಎಕ್ಸ್ಟೆಂಟ್ 1 ಎಕರೆ 10 ಗುಂಟಾಸು. ಅದ್ರದ್ದು ಚೆಕ್ ಬಂದಿ ಕೊಟ್ರು. ಇದರಲ್ಲಿ ರಸ್ತೆಗೆ ಸರ್ಕಾರದಿಂದ ಅಧಿಸೂಚನೆ ಆಗಿರುವ ವಿಸ್ತೀರ್ಣ 18 ಗುಂಟೆ.
18 ಗುಂಟೆ.
ಉಳಿಕೆ 22 ಗುಂಟೆ. 22 ಗುಂಟೆ ಈಗ ಅವರಾಗ್ಲೇ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಾಗೋಗಿದೆ.
ಅಲ್ಲ 22 ಗುಂಟೆ ನಿಮಗೆ ಬಂತು ವಾಪಸ್ ಉಳಿಕೆ.
No, 22 guntas is retained by BDA in the acquisition.
In the acquisition.
Yes, so it is subject matter of acquisition, it is retained in the acquisition. BDA has allotted in excess of this 22 guntas to third parties already. This is what I had given.
I'm asking you, how are you aggrieved by?
Lords, now the property which is now being shown as being allotted is the property which falls beyond this 22 guntas. 22 guntas, they have already lost title.
Beyond 22 guntas, ನಿಮಗ್ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆಯಾ?
Yes, this is exactly the property which on which they are. How? Lords, that's what we notice. The allotment letter which is now giving the boundaries is exactly overlapping on the property which belongs to me.
ನೀವ್ ಏನ್ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದ್ ಯಾಕೆ? ಲೇಔಟ್ ಮಾಡ ಅಥವಾ ರೋಡ್ಗ? ಆಯ್ತು.
Let them give a sketch indicating the 5 sites which they have allotted out of 22 guntas.
File your objection and produce all records.
Lords, they have to indicate where is this 5 sites allotted by them out of this denotified, the retained extent of 22 guntas.
Correct sketch ಹಾಕಿ.
Lords, that sketch is there at page 56 because they are not producing it as a part of the objection statement.
Yes, sir. Learned counsel for the BDA to produce the original records that led to allotment of sites in favor of respondents 5 and 6. The learned senior counsel for the petitioner submits that the sites, the land that was denotified which fell to the share of the petitioner, sites are formed and sites are distributed to 5 people. There is no land that is remaining that could be granted to 5 and 6. The land that is now allotted to 5 and 6 directly overlaps on the lands that the petitioners have purchased, converted to sites and sold them. In that light, they are aggrieved. The learned counsel K. Krishna to produce the entire records of allotment to respondents 5 and 6 on the next date of hearing. The learned counsel Mahesh submits that he has entered appearance for respondent number 5. Registry to print the name of so and so is appearing for the respondent number 5. List on 5th August.
Lords, there is a amendment which is filed, my lords, where, lords, there is amendment is, lords, they have now executed a sale deed, my lords,
along with the main matter.
Please, that can be considered.
The application IA2 of 2025 shall be considered along with the main matter.
Lordships.
Yes. Barley, August 1st, yes. 5th, sorry, 5th, yes. August 5th.
So, the petitioner, my lord.
Copy, sir. Petitioner to serve set of papers upon counsel K. Krishna forthwith. In the event copies are not served, the interim order would get automatically vacated. Subject to the aforesaid condition, interim order stands extended. Next.
102.
Appear for the petitioner. Lords, on 22nd of April, my lord, your lordships had passed an interim order. Lords, directing the petitioners to deposit 10%, my lords, of the amount due. Surface Act, my lord. My lords, I filed an IA for clarification. My lord, what happened was, my lord, when I went, my lords, to my lords deposit the money. My lords,
we will follow the latest Supreme Court judgment and send you back to DRT.
My lords, now, my lords, what has happened, my lords? My lords, now the position is, they forcefully evict the entire tenants from the property, my lords. My lords, this is the only source of my livelihood. My lords, the property which is
sympathy and ashtond entertain matter.
Kindly consider.
Now said in the other case. Now this will go and.
My lords, kindly consider this, my lord. My lords, they have notified the property for sale for 5 crores 56 lakhs.
This interim order is not complied.
Interim order is not complied, my lord. My lords, please consider this, my lord. The lord.
Please consider this also, sir. I cannot. Yes. The petitioner.
My lords, one submission.
Sneha constructions a problem ಆಗಿದೆಯಾ?
My lords, one.
No. ನನಗೆ ಬೇರೆ problem ಆಗಿದೆ. I can't entertain this.
One submission.
No, sir. The petitioners are before this court calling in question an order dated 9/11/2023 passed by the Debt Recovery Tribunal, passed by the learned magistrate under section 14 of the Surface Act 2002. Owing to the submission made by the learned counsel for the petitioners, plethora of orders were passed by this court, a clarification of which is sought and the petition is back to this court. This court on 22/4/2025 had passed the following order. The learned counsel for the respondent bank submits that not a rupee has been paid pursuant to the order dated 22/4/2025. Even otherwise, the petition which calls in question proceedings instituted by the respondent bank under the Surface Act cannot be entertained at the hands of this court under Article 226 of the Constitution of India. In the event it is entertained, it would run foul of the judgment of the apex court of Kurtini. So it's in that light, leaving open the remedy that is available to the petitioner of knocking at the doors of the appropriate fora, the petition stands disposed.
Property which is worth, my lords, 8 crores, my lord, they want to sell it at 5 crores 56 lakhs, my lord. This is the only livelihood, my lords, which I have. My lord, that is why I have approached your lordships, my lord. The petitioners are at your lordship's mercy, my lord. Kindly, my lord, so he is 68 years old, my lord.
No mercy.
My lord, he is 68 years old. He suffered a grievous accident. My lord, his wife is
These submissions have only led to entertainment of the petition, Honorable Apex Court saying that we should not entertain time and again.
My lord, if the property is sold for a paltry sum of 5 crores 56 lakhs, my lord. My lord, so it is worth more than 8 crores, my lord.
Once
Property
bitten, twice shy, sir. Yes.
Lords, I bow down to your
Next.
lordships, my lord, kindly.
103.
For the petitioner. Land, my lords, was initially acquired for Nadaprabhu Kempegoda layout.
Covered, dispose
No,
madam.
this subsequently, my lords, they issue a notification saying that you pay the betterment charges. Now conversion orders are
Yes,
issued.
Ajay Kumar.
Now they are not sanctioning the plan to put up construction of a residential building, saying that they intend to acquire for Nadaprabhu Kempegoda layout.
Intention baralla.
That's the only endorsement, my lords.
Justice Indresh or judgment is
My lords, that, my lords,
intention.
judgment, my lords, insofar as this property itself is concerned, is at annexure L, page 71. At page 78, my lords, is the finding. Conversion.
No, there is intentional baralla. Teek tane follow madde. Where is it, Nishan?
My lords, that in this
intending to the formal layout will not give right to acquisition. The intention will be for 20 years, sir. Yen madakkaga. Which is that? Mic use ಮಾಡಿ ಯಾಕೆ?
So far as the consideration of the application for the sanction of the plan, Millards, will do it. We'll do the need. We'll consider it in accordance with law.
Because it's settled.
Please.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಫಾಲೋ ಮಾಡಿದ್ದೀನಿ. We should get ಒಂದು judgment ಇದೆ.
I'll give it to the court.
Not for the betterment taxes or otherwise.
Consider the, I will not observe anything. I will direct you to consider the representation and pass necessary orders in accordance with law. Bearing in mind the law laid down by this court.
Please.
The petitioner is before this court, calling in question a communication dated 17/5/2025 passed by the second respondent BDA, who declined to accept the representation of the petitioner seeking seeking sanction of a plan for construction of a residential building in the subject property. The learned counsel for the petitioner Nishant AV submits that the BDA has sought to reject the application for sanction of plan on the score that the subject property may be required at a future point in time. The learned counsel for the petitioner Nishant AV submits that the application of the petitioner seeking plan sanction is kept in abeyance on the score that the land may become necessary to be acquired at a later point in time for formation of the layout. The learned counsel further submits that on such reasons, this court has quashed those reasons and directed consideration of those cases of the respective petitioners in accordance with law. The learned counsel Ajay Kumar would submit that if reasonable time is granted, the application of the petitioner for sanction of plan would be considered in accordance with law, and necessary orders would be passed. The learned counsel, therefore, the petition, I deem it appropriate to dispose the petition with a direction to the respondent BDA to consider the case application of the petitioner seeking sanction of plan to construct a residential building strictly in consonance with law, bearing in mind the law laid down by the coordinate benches of this court. The application shall merit consideration within an outer limit of
12 weeks.
12 weeks. ಮನೆ ಈಗಲೇ ಕಟ್ತೀರಾ? 12 weeks from the date of receipt of the copy of the order. As a matter of form, the impugned communication stands quashed in the light of the aforesaid reasons. Yes.
Ordered accordingly. Please.
As a matter of form, FORM. as a matter of form, FORM.
My lords, this
The
matter,
petitioner in this case, my lord.
sought for instructions, my lord, lordship may kindly grant me 2 weeks' time to file my objection.
Learned counsel, B. Vachan seeks 2 weeks' time to file statement of objections. Objections, if any, by the 12th of August.
Obliged.
List on 12th August.
Further hearing, 3:30 PM, 105 agenda.
Smart meter ತೊಗೊಂಬಿಡಿ ಮೇಡಮ್. ಎಷ್ಟನೇದು?
8,
ಅಲ್ಲ ಕರೆದ್ಬಿಡಿ, 4 ಇರೋದು. It's okay. 1 minute. Only 4 meters, 4 matters.
106,
Smart meter is 4 meters. Yes. Yes. Adit, this is the one I passed an order and called.
Yes, my lords.
Notice ಆಗಿಲ್ವಾ?
It was ordered, but
ನೋಟಿಸ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್. R2 ಆಗಿದೆಯಾ? Emergent notice to the second respondent complainant returnable by the 13th of August, list on 13th.
Great.
Interim order subsisting would continue till the next date of hearing.
107,
That's on 4/6/2025, my lords had granted my lord a stay of further proceedings, my lord.
That's the mistake I've committed.
No, my lords had dictated a detailed order, my lord.
306
306, my lords. By quoting my lord Tangavelu, the recent judgment, my lord, of the Supreme Court.
Recent judgment.
My lord,
How the recent
2025, my lord, the Tangavelu. That also I have produced, my lord. But my lord, the interim order, my lord, is not to be
Where
seen,
is
my
the
lord.
interim order? I have not granted any interim order.
My lords have granted the interim order, my lord, but it is not to be seen, my lord, either in the order sheet, nor, my lord, in the.
Interim order is not in the order sheet.
It's not there in the order sheet, my lord, but it is
ಮತ್ತೆ?
there in YouTube, my lord. I have checked, my lord. I
YouTube
verified.
interim order. ಅಲ್ಲೇ
No, my lord,
ತಗೊಳ್ಳಿ.
it's very
Implement
much
ಹಂಗೆ
there, my lord.
ಮಾಡಿಸ್ಕೊಳ್ಳಿ.
My lords have dictated, my lord, on that day. But it's
YouTube
not-
interim order.
My lords, I verified, my lord, whether the interim order was there or not. my lord.
No, I did grant an interim order. 306 ಅಲ್ವಾ? ಅದಕ್ಕೆ interim order ಕೊಡಬಾರ್ದು ಅಂತಿದೆಯಾ? ಮತ್ತೆ? ನೋಡಿ ಚೆಕ್ ಮಾಡಿ. ಯಾರಿದ್ರು ಮೇಡಮ್? We'll check it and get it.
Please, my lords.
Post immediately after service of notice upon the second respondent. The learned counsel for the petitioner submits that on ಯಾವತ್ತು ಮೇಡಮ್ ಅದು?
4/6/2025. 4/6/2025.
4/6/2020? 2025, this court had granted an interim order which is missing in the order out of inadvertence. Therefore, the stenographer's diary would be verified, and if the order is indeed granted, would be printed. Yes.
May be extended.
List on ಬರ್ಲಿ post immediately ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು.
My lords, it appears, my lord, the service is also complete, my lord.
ನೋಡಿ ಮೇಡಮ್, ಎಲ್ಲ appears interim order, appears service. Yes.
Great.
one 108,
ನಿಮ್ದ ಮೇಡಮ್?
Your Lordship, Mr. Fanindra can
Pure
complete
today.
and I will just sum it up in the end, please.
Because I've heard, reheard and reheard.
Because they keep coming up with more
Allah.
and more and more concocted documents, I cannot help it.
What is this AGR? Concocted documents.
I shall show it. Let Mr. Fanindra
Madam,
finish. I shall-
board resolutions and proceedings can be concocted, is it?
Without dates, Your Lordship.
No, that may not be correct, my lord. This is part of the original record which is filed alert.
That is why on the first occasion, Your Lordship had asked them to produce all the records. Had that been done, this we
subject
would not
matter
have
of-
come to this.
Subject matter of this case is at best guidelines which is internal, my lord. Ultimately, I said, your lordship may go by the central regulation and KRC, my lord. Even if, and that regulation, the guidelines can be read down to, which is still to the extent it is contrary to KRC regulations, my lord. If your lordship, because your lordship pointed out.
In case.
In case, my lord.
In case. Who is, ಯಾರು? How long will it take, sir? 10 minutes? ಅಷ್ಟೇ, see. Where is Prabhuling, sir? I'm not adjourning the matter.
No, I will be brief, but we have prepared one note, we'll just circulate.
Where are you, sir? You are here, yes. All right, yes, sir.
We have just prepared a short.
My apologies, my lord. I'm not in a position
no
to
problem.
confiscate perhaps.
My lords, one short question.
ಅದೇನಂದ್ರೆ
Arguments to.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸಿಗಲ್ಲ ಅಷ್ಟೇ.
My lords, as I.
ಅದು ವಿಸಿಲಿ ಟೆಕ್ನಿಕಲ್ ಗ್ಲಿಚ್ ಇರುತ್ತಲ್ಲ, ಕೇಳಿಸೋದೇ ಇಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡೋ ಅಂತ ಕೇಸ್ ಇರೋದು.
ಬೇರೆ ಯಾವ್ದೋ ಮ್ಯಾಟ್ರ್ ಎಂಟ್ರಿ ಮಾಡೋಕೆ ಇರ್ಬೇಕು.
No, today genuinely, my lord, there is some difficulty, my lord. If not, I would. And the last person, particularly before your lordships, whatever be it, I always come physically.
Yes,
Today,
sir. Yes.
Genuine difficulty. Yes.
So far as, my lords, the petitioner in 12987, as I had submitted, my lords, one is on locus.
This is your note, Mahesh Chaudhary. Yes.
That's,
First
my lords,
is locus,
our
is
reply.
it?
There are arguments and we have just said our reply. So far as the arguments.
Questionnaire format ಅಲ್ಲಿ ಇರ್ಲಿ ಬಿಡಿ.
So that we don't go all over, my lords.
It's like FAQs, frequently asked questions.
Lords, apart from that, one is on the locus. Now, my lords, what the other side seems to have missed is they are referring about locus to file any writ petition. Now, I am not saying the petitioner does not have locus to file a PIL. The question is locus to maintain a private interest litigation. Now, my lords, one of the arguments repeatedly being made is this cost of 9,000, which will be paid over time to me, that is the successful tenderer by BESCOM, will be passed on to the petitioner and hence locus. That, my lords, last time I had passed on the judgment, my lords, in just by. That is, my lords, 1976 1 SCC 671.
Judgment.
One
single judgment.
Only in the initial stage, my lords, I have not given any compilation. Otherwise, I will pass on the other.
That's all. ಇರುತ್ತೆ. Just a moment. ಎಲ್ಲ AG ಅವರು ಕೊಟ್ಟಿರೋದೇ ಇದೆ, ಅಷ್ಟೊಂದು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ.
In peace means
1974 2 SCC ಅದಾ?
ಇಲ್ಲ 76 1 SCC, my lords.
Court officer. Can I give it? If a lordship permit, we just consolidate, make one.
One consolidate ಮಾಡ್ಬಿಟ್ಟು.
I will just.
No, your things are all consolidated. They are all right. Yes.
Yeah, lordships have. Lords, that is still holding the field, reiterated.
No problem.
In.
ನಾನು ಯಾವುದೋ ಹೊಸದು ಕೊಡ್ತೀನಿ.
ಇಲ್ಲ. In that, my lords, please come to para 36 and 30.
Yes, sir. Person aggrieved.
Lords.
Person aggrieved.
37 also, my lords, distinguishes.
He must have suffered an injury.
Steps. And also the gray zone. Their lordships hold, if somebody falls in the gray zone, that's
gray.
My lords, that's how they classify that, my lords, the categories. Where, my lord, that's why I said the petitioner is attempting to make out locus for a private interest litigation to say that this cost will be put on me, so I have a locus to challenge. That, my lords, that is something which their lordships considered in just by, reiterated in Kishore Sambriti and others, where they say if somebody is.
So that is the law even today, sir.
My lords, that's
because you need not go there. You see the Constitution bench in Calgas, 1965, 595 or something. It's a Constitution bench. The apex court says, who is a person aggrieved to approach the court under Article 226?
So, my lords.
That's celebrated judgment.
Oh, my lords,
Calcutta
226, of course, you can maintain a writ. That's why, my lords, 226 writ is maintainable. But we have now categorized that into a private interest litigation.
226 writ is maintainable, PIL.
PIL, that's what I am trying to make out. That somebody, I can't, my lords, any writ, it is a question of any writ is maintainable. Whether it is entertainable is the issue.
The two are two different concepts.
Now, my lords, here if they don't have locus, that's why, my lords, I pointed out.
Everything is maintainable under Article 226. Whether it is
entertainable is the issue. Now, my lords, so far as the other issue, please come to Annexure A in the writ petition. With regard to the impugned order at what they have challenged, my lords. I will first take your lordships to the rate so that your lordships wanted to know whether the prices what is fixed for each smart. Locus is that, my lords. I am saying since no cost is imposed on them. Absolutely.
No cost is imposed on the petitioner.
Petitioner does not suffer anything. Lords, it is a tender.
Petitioner is a consumer.
Consumer.
Consumer will suffer.
If,
how do you say
Lords, that's why. Now, according to the scheme, smart meters as on date is being supplied only to
New connections.
new connections.
That can be a plausible argument.
Yes. So the
But petitioner
the
does not
petitioner-
suffer under not
I'll submit. The petitioner in the present case on hand has not even filed any application seeking a new connection. There is no application. The only thing what the petitioner says is, I gave an application, this is Annexure A which they have given. Now, the application which the petitioner has filed, the state has filed it in their counter. Bescom has filed. Your Lordship sees they only ask for information. Information is given. There is a
So
format.
it is not an application for connection at all.
Absolutely not. So as on date, petitioner is not a consumer or a new maybe the petitioner is an existing consumer, but not a new consumer. So this as of now, the scheme is only for new consumers only. Now, my lords, the petitioner asserts that this 9,000 which will be payable in terms of the tender. Now, my lords, the entire writ petition is challenging the tender, but except the prayer not being there.
One clarification. In the PIL, tender is challenged?
Yes.
PIL, the challenge is to the tender that is awarded inter-alia.
Inter-alia to me.
All right. So decision, tender.
Please.
As my learned friend, except the prayer, pleadings is the same.
If your lordships,
In the
lords, in this writ, I pointed out on the last occasion.
Then madam will.
Yes. So, my lords, in the tender, there is a discovery of price for meter. So, if that discovery is this 4,998 per smart meter, insofar as single phase system. Same logic applies to, my lords, the 3-phase meter also for the present. So, this discovery of price, which is discovered through a tender process, unless you challenge the tender process, you cannot be agreed by the price is number one.
Tender can't be challenged because not a participant.
Not a party. Then, my lords, then question comes, in which forum do you challenge if you are not a party, this price fixation? That can only be in a public interest litigation, unless you show you are affected. In the entire pleadings, there is not a single sentence how the petitioner is affected. If the petitioner asserts that this cost of 9,000, my lords, which is paid over a period of 10 years, is being imposed on
10 years,
my lords, that will be paid by Bescom, my lords, over a period of 10 years to me, which will amount, that's a maintenance cost.
Paid to you.
Paid to the successful, the person, my lords, who installs the meter. Now that, my lords.
Smart meter install agide. Allala, ega AG avare. Smart meter ella kade install agide.
No, my lords.
Nowhere it is started.
No, it has started.
It started. 20,000 has been installed from December 15th of December till now, my lords.
20,000 smart meters
Has
Lords,
been
I'll
installed. It
just
is only
submit.
for new connection, my lords.
As on, my lords, 10th of July.
You have installed.
Yes, as on 10th of July 2025, the information which we have is post-paid smart meters is 10,679.
Prepaid.
Prepaid smart meters 8,974. That
close
is
to
as on
20,000.
10th of July, my lords. I am giving it 10th of July.
Your lordship make case why is
Now, my lords, it has
Bescom paying them the money is one other. The reason is, my lords, because of the savings that we do, my lords. That is meter. We don't have meter reading. We are taking away meter reading instrument is taken away. Battery for meter instrument is taken away.
Those overheads are taken away.
Taken away. We save huge amount of money, my lords. After that also we make profit. Out of that amount,
You are servicing the tenderer.
so it is not that public money we are giving, my lords.
Lords, this 9,000 is divided in 10 years. So it comes to about 75 rupees per month.
Per month.
Per month, which per meter, my lords, which Bescom will pay me. That is the tenderer. Now, my lords,
Sorry, my lord. If I have to increase the price, my lord, only KSE can permit me.
No, that is correct.
That-
Price is controlled by them. That's
No, if additional price.
Additional,
Yes, my lord.
so this 75 rupees, why they are not passing it on as on date to a consumer is because they are saving money on, lords, the lineman,
those
visiting,
overheads. Yes.
then stationery, every point they are saving money. As on date, it has not been passed on. If it was passed on, my lords, to a consumer who has not even installed a electricity smart meter, Lord, the petitioner would have been the first person to show the electricity bill to say that this extra 75 rupees is spread over to me also, which is not done. Oh, my lord, the scheme of things is this. As on date, they will not pass it on. In future, my lords, I'm only saying, I'm giving future Suppose, my lord, 75 rupees is what they are giving me. And the savings, what they expect to save is because of all these overhead costs getting reduced. Suppose they save only 50 rather than 75 rupees. So that 25 rupees they'll have to make up. I'm only giving an example. Even for that 25 rupees, unilaterally, they cannot impose on the consumer. They'll have to still go to KERC for a tariff fixation under section 61. That is the position of law. So as on date, my lords, there has been no passing of any cost on the petitioner. So even their locus is not available. Now this 4,999, my lords, the repeated contentions raised is 4,998, which is discovered is more, it is 900 rupees only in neighboring states.
Neighboring states.
Now that's why for a moment, Annexure A, if your lordship sees.
Annexure A of?
The writ petition, my lords, 12,987, page 38. In that, my lords, please see.
4998.
4998. Then please see the next column, that is regular electrostatic meters. That's a regular meter which is still operating. Now, if your lordship sees the price, the price for a not a smart meter.
No audience. For Prabhu sir, yes.
Avaru gottagilla ansutte adukku.
No audience for him. Yes.
No, not from my side. Not from my side. That's for sure.
Yes,
it must be some other, not from us, because we have put it on mute.
Yes, sir.
Now, if your lordship kindly see the last column there, my lords, for a
958.
For a non-smart meter, which is a prevailing as on date. I'm only saying, my lords.
Per unit ನೀವು ಹೇಳ್ತಿರೋದು.
ಇಲ್ಲ ಪಕ್ಕದ್ದು awarded rates.
Awarded rates.
958.
Inclusive GST. One ನಿಮಿಷ, come to this column.
Yes.
4,998.
That is my smart meter. No difficulty on that.
No difficulty. Fine.
Now I am only trying to say 900 rupees. They are saying a smart meter is available in the neighboring state. Please see the electrostatic meter amount itself presently, which is existing. The last column.
900 rates exclusive GST. This is for electrostatic meter,
yes,
not
yes,
a smart
because
meter.
If your lordship sees the column on top.
So it is, what you are saying is it is not a smart meter but electrostatic meter.
No. My meter is 4. Lords, there are 2 columns there. If your lordship sees on top.
You are not answering the question. See, the submission was in the neighboring state.
It is 900 rupees.
No, what is 4,998 in Karnataka? Is 900 there?
Yes, I will go to that.
That is correct or wrong?
That's absolutely wrong. What I'm trying to say is, first contention is, if your lordship just sees this table itself, a smart meter here is costing about 4,998. The first one.
Correct.
First 3.
Idu heading smart meter details. Regular electrostatic meter details.
4,998.
4,998 smart meter.
Please see regular
electrostatic 950.
Rate 950. What I'm trying to say is, even a regular
electrostatic ಬರಲ್ಲ ಅದಕ್ಕೆ.
Electrostatic ಬರಲ್ಲ, ಇಲ್ಲಿ ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಎಲ್ಲಿ 900 rupees ಅಲ್ಲಿ ಯಾರು ಕೊಡಕ, and this is prevailing price exclusive of GST. So I am only saying this, electrostatic meter ಸಿಗ್ತಾ ಇಲ್ಲ ನಿಮ್ಗೆ, 3310 ಸಿಗ್ತಾ ಇಲ್ಲ, Apple 16 ಬೇಕು ಅಂತೀರಾ. That is what.
16 ಹಳೆದಾಯ್ತು. Oh, 16 correct.
Lords, I am only, because it's a electrostatic meter. Now, my lords, we have prepared a chart. From
Nokia
there,
1100.
Lords,
Nokia 1100. Yes.
Lords, we have just prepared one chart. If your lordship kindly see this, it is from their own. We have taken it from the data given by petitioner in 12/5/35 of 2025, because they have filed a memo, my lords, 10th of July 2025. If your lordship keeps that memo.
Now, Karnataka 4235. Delhi 845, Punjab and Haryana, Odisha 5760.
We have given the particulars, my lord. If your lordship sees the particulars.
Delhi is more than Karnataka.
Yes, it is.
And
please see Odisha.
6,796.
It is not my details. In their memo, I am extracting the details from their memo. Because my meter, my lords, is
this is 3-phase. Next is 3-phase.
3-phase, my lords. And in
So where is this 900 rupees?
Madam,
Madam, you will have to.
That 900 is the subsidy given
900
under RDSS scheme.
RDSS, Manoj. Actually, that is a 2019 rate. They said that if meter is 6,000 rupees, 15% of 6,000 comes up to 900 rupees. That is why that is struck as 900 rupees is a meter. That's actually incorrect, Manoj.
So nowhere in the country 900 rupees meter is given.
Impossible.
No, 900
Electrostatic baralla.
electrostatic ಬರ್ತಿಲ್ಲ smart meter ಕೊಡಿ. If your lordship takes that memo, my lords, which has been filed in 12,535, memo dated 10th of July.
Yes.
They have given the details in that. I am extracting that.
Petitioner ಹಾಕಿರೋದಾ?
ಹೌದು, petitioner in 12,535 of 25 ಅಲ್ಲಿ.
Yes. ಅದರಿಂದ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿರೋದು.
ಅದರಿಂದಾನೇ ನಾನು ತಗೊಂಡು this graph is prepared based on that. It is not my.
ಯಾರು this problem ನವರಿಗೆ
our writ petition ಅಲ್ಲಿ ಹಾಕಿರೋದು.
Yes.
And we have given cross. Now, my lords, for Uttar Pradesh, if your lordships have that memo dated.
This is illustrative, not necessary.
Because I am only saying.
This is self-explanatory. Yes.
If this is the price and my price of 4,998 my lords, it involves several components. It involves the hardware, that's the smart box.
ಹಿಂಗ ನೀವು several components ನ ಬೇರೆ ಏನೋ.
My lords, it's like this. They buy it, it's tested, I install it, then my lords, it is to be integrated. Then my lords, it also will have a SIM card. It has two features.
Smart on the level.
No, there are two features in this. That's another additional smart meter feature is, one, it can run on a SIM card, my lords. That is, my lords, that's one. Suppose, my lords, there are some buildings where it's under basement 2, basement 3, where there could be no signal.
Network.
So that time, my lords, there's something known as a NIC card. That is, SIM card is removed and a radio frequency card is installed. So, my lords, it can operate if there is no signal, it operates on that. And the advantage of this smart meter is, entire thing is monitored by BESCOM. There is a special app created for which I have been given that. I have to maintain even that app, software app, where, my lords, the consumer can open it anytime. He will know daily consumption. He will know what is the monthly consumption. And if it is a prepaid, my lords, there are warnings given that, suppose like a phone, my lords, your prepaid consumption is coming to an end. So he has to reload it. And, my lord, in case he does not pay or postpaid does not get paid, it is not the lineman who has to come here, cut, remove the fuse. It gets, by following the due procedure, even that there is a procedure, but it gets done at the station itself through me. Oh, my lord, that is why I said, if this price I am able to demonstrate that it is not there, and petitioners have not demonstrated anything about 900 rupees, except, my lord, saying it is only under RDSS scheme. Now, RDSS scheme.
So the subsidy under the RDSS you have not taken.
RDSS, yes.
BESCOM has
state has not taken. State, my lord.
The scheme itself is not in the state.
Lords, the scheme is a policy where the central government said it's an option available to the states. Now, the states.
No, few states have taken, few states have not taken.
State says, I will not take it, nobody can question it.
Correct.
That's a policy on economics, my lords. Having adopted
we
this.
We can't issue amendment, must take it.
That if we come to that also, I don't think. That's why, my lord, this should satisfy your lordship's prima facie, though I would say locus itself is the main issue here. Then the other issues I will only have to repeat is, my lords, I have given question and answers.
The FAQs.
My lords, FAQs I have given. In fact, my lords, I have also said how it works, everything. This is my submission.
We'll see.
Beyond this to say, my lords, your lordships wanted differentiation in that BESCOMs. This is operational guidelines. That operational guidelines, first of all, my lords, it is only for the purposes of BESCOM employees. It is not for any consumer.
The internal guidelines.
It is an internal guideline. And there also, my lord, maybe their English is bad. If your lordship is 40, a little, nobody can be perfect.
The problem agirade.
No, but if you're that in the writ petition at page 40, your lordships always point out to this, all new installations. All new installations, all category of consumers except temporary are obligated to install with smart prepaid/postpaid meter at their cost. So what they did, they said smart meter is a must. Prepaid is one, postpaid is one.
Correct.
Then, my lords, provided availing power supply through a smart prepaid meter shall be at the option of the consumer. What they meant by this is, You have an option of postpaid and prepaid, because till now the regime has been postpaid only in electricity, my lords. For the first time, we are bringing in the concept. That's why KERC guidelines, BESCOM guidelines are only for prepaid. Postpaid is anyway governed now. We always pay after we consume electricity. That's why they said you have an option of choosing a smart prepaid meter, where you load your currency and then use as per your requirement. Shall be at the option of the consumer, except temporary installations for which it is mandated. For a temporary installation, that's why I said, my lords, English could be a little, but the meaning which we can only ascertain by this is this.
But this operational guidelines and the other things are before the division bench.
Divisional.
And that same thing.
It's all becomes a part of it.
It is also there, but the main issue is ultimately the tender. Here
For
it's
the division bench.
please.
My lords, if the tender collapses, everything goes. If the tender, and my lords, BESCOM, as the learned senior counsel, Mr. Holla, had passed on one document on the last occasion.
He's on the way from Chennai.
He is in Chennai. My lords, where he had pointed out the rates of different meters, my lords, as obtained from the OEMs, original equipment manufacturers, which, my lords, insofar as we are concerned, what I am giving is much cheaper than if they procure directly. If a consumer goes directly to a retail outlet of, let's say, HPL or Linkwell or Schneider, my lords, the smart meter of the same calibration will be much more than what I am offering, because I buy it in bulk.
Correct.
That's the end of the story.
Yes.
That is what
Just one
Anything
judgment,
else?
just one paragraph.
Of judgment, huh?
One judgment.
Kodi.
Just above paragraph 5, my lords, on conjoint reading of section 26 and regulation 31 for, I have no difficulty in rejecting the contention urged on behalf of the petitioner that the board does not have the power to replace a meter once provided to the consumer by a more sophisticated equipment, which in the opinion of the board is better than what was installed earlier. The obligation to provide and maintain a correct meter would, in my opinion, carry with the right to change the metering equipment also, not only in situation where the earlier installed meter is found to be working unsatisfactory, but also where the board considered it necessary so to do so with a view to improving the quality of equipment and making the same more dependable and tamper proof. So therefore, one of the right to
No, they are not saying don't replace it. The price.
the price is, that is the question of tender. The person who has lost the tender, he's a consumer. According to the petitioner here also, the consumer.
Then, my lords,
In
one. At 215 is the KERC regulations, my lords.
215 of?
My lords, I am only referring to WP 12987. Your lordship said, posed a doubt at page 218 alli, regulation 3. This was for, my lord, these regulations are for prepaid. In 3, my lords, your lordships pointed out the proviso. Provided that availing power supply through a smart prepaid meter shall be at the option of the consumer.
Yes.
Except temporary installations. That, my lords, again, that is, my lords, what I am trying to say. Postpaid is compulsory. Please see 3.1. That is made further
Prepaid
clear.
is optional.
Lords?
Prepaid is optional.
Prepaid is only an option. Please see 3.1 therein, my lords. Just below. Existing new consumers of the distribution licensee may make an application to the licensee for arranging power supply through a smart prepaid meter. So, my lords, there is no option given that you want a smart prepaid meter or you don't want electricity bill. It is only option is between prepaid and postpaid, but there is no option of a smart. Now, one other allegation which was, my lord, made across the bar, but without any material in the writ petition was that I have been given the tender, though only BESCOM had given the inputs. I have been given tender for all over Karnataka and I am doing it. With great respect, that's not correct.
You're doing only BESCOM.
BESCOM is the only place where I am supplying the hardware, that's the smart meter. So far as the infrastructure, that is the software maintenance, my lords, the tender was modified. I have been given tender to provide software so that there is uniformity in their software across Karnataka. So
So
far
you are-
as smart meters in Dharwad or Gulbarga or any other division, methods,
So it's only knowledge sharing.
it is
Software matra.
software. That is, tender was modified so that for that they are paying me charges for software because
Just more than the smart meter. Huh?
no, that comes in that 9,000 rupees. That comes in that 9,000 rupees. Because my lords, I'll have to keep everything on
You'll have to keep everything.
maintenance. It is, my lords, virtually I am maintaining there. Now that, my lords, as long as the consumer is not affected, if Bescom puts 75 rupees on a person who is not even installing a smart meter, or if he has installed a smart meter, my lords, I have to, the infrastructure, my lords, that's why I said the concept of smart meter is this. Entire thing is.
Concept of this smart meter is smart maintenance.
Smart meter. That's, we are progressing, my lords, that's all.
Yes, progress.
My lords, somebody sits in the office today can monitor everything instead of one lineman going. He will read the meter, he will, if it is 200 units, sometimes by mistake, he will record as 180 units.
Deliberately.
It could be. I will not, my lords, I can't make, but these are the things which Bescom thought we can save. And anyway, the policy of smart meters is made, my lords, by the central government, which we are implementing. So, lords, if the petitioner does not satisfy this initial thrust of a locus, we should not even enter with great respect.
Or enter into other things.
Other things, my lord, because that is where the door has to be shut.
No locus, no submissions.
Absolutely. Now we have satisfied so far as the costing is concerned. Beyond that, if it is.
Whom have you satisfied?
Lords, we have only given from their data that 4,000. Lords, the first thing is.
We have satisfied
Lords,
regarding
I
cost
can
of
only say
management.
this.
Where have I
Lords,
said so?
Lords, I am only saying this. It is the petitioner who has to establish that the cost.
Burden is on the petitioner.
It is. Whereas their data is showing that my cost is much better. And if it is a cost discovery, it's a part of tender. That's
Yes, madam.
Lords, we have the bills. I don't want, but if they deny it.
Yen bills, sir?
The electricity bills, my lords.
From the smart meter.
Of the smart meters, of the other.
One smart meter bill kodi 75 rupees and hogadi adra.
We'll give.
Pass it on.
Give me one bill.
Which?
In the smart meter, 75 rupees goes from a consumer who does not have smart meter.
Yes, my lords. If they can show that, my lords, I'll be more than.
The last page, Your Lordship.
ಎಲ್ಲ ಬರೀ ಸಬ್ಸಿಡಿನೇ ಇದೆ.
ಎಲ್ಲಿದೆ ಇದು?
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಆಗ್ತಾ ಇರೋದು. As Mr. Holla said on the, as Mr. Holla said the last time.
ಅಲ್ಲ ನಿಮ್ ಬಿಲ್ ಅಲ್ಲಿ -145, -116, -380 ಪ್ಲಸ್ ಏನ್ ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
ಏನಿದೆ ಇದರಲ್ಲಿ? My lords, this is a
Where is
smart
75
meter
rupees,
holder.
madam?
Is it a smart meter holder?
75 rupees ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಹೋಗಿರೋದು ಎಲ್ಲಿದೆ?
Your Lordship.
This is a smart meter holder.
ಇದು ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಇದು?
ಇದು ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಇದು. If they can say, my lords,
non smart meter holder giving money towards smart meter charges. Maintenance.
Maintenance charges.
That's not there at all.
It can't be, my lords.
Doubt that will be there.
Lords,
I'll explain.
when Bescom says it on affidavit,
I've stated in
and
my
my lords,
affidavit.
there is no material produced. We can't now, my lords, assume things.
No, the AG is saying this. Yes.
The same bill we have that, my lords. What my learned friend
This bill is all right. I want a bill. ಅಂದ್ರೆ ಇದ್ರೆ
ಅಲ್ಲ petitioner ದೇ ಇರಬೇಕಾಗಿತ್ತಲ್ಲ.
Did not generate a bill.
ಅಲ್ಲ petitioner ದೇ ಇರಬೇಕಾಗಿತ್ತಲ್ಲ. Petitioner does not have a smart meter.
You don't have a smart meter?
So they can always show their house
bill
bill.
of yours which says 75 rupees towards maintenance of smart meter.
ಇಷ್ಟೊತ್ತು ಬರ್ಬೇಕಾಗಿತ್ತು.
ಕೊಡಿ.
Please.
ಬಿಲ್ ಕೊಡಿ.
Which bill?
Bill ನಿಮ್ಮ ಮನೆ ಬಿಲ್ ಕೊಡಿ.
Your Lordship, we have already asked what is the difference between smart meter and whether it's compulsory or
No.
not.
You
They have
said
it is
every consumer has to pay 75 rupees towards smart meter maintenance charge, whether he has smart meter or
whether
not.
he has or not.
Adike, you don't have a smart meter.
I don't have a
Give me
smart
the bill
meter.
where it shows.
The increase in the costing, it's not going to come to us separately.
Oh, it is inclusive.
It is inclusive. And what happens here is they are claiming we are not even charging the person who has a smart meter. They are paying it. They're very generous. Adu Kannadadalli they say yardo duddu yellaman jatre. This is what that is. So what happens is, no, I don't want jack in the box pop-ups. I will if I start. That is the problem. I will not let him finish. Let him finish.
We have to act, lords, that's why please take the pleadings, my lords. We are going beyond the pleadings. Please see the pleadings, my lords, in the writ. We can't, it's an, my lords, a settled position of law You can't go beyond the pleadings. Please see the pleadings.
ಆಯ್ತು ಈಗ ಮೇಡಮ್ ವಿಲ್ ಕಂಪ್ಲೀಟ್ ದಿ ಜಾತ್ರೆ ಕಮ್.
ಅಷ್ಟೇ.
Yes. He will be quiet. Yes.
Your Lordship may kindly take the note, the office note that Mr. Holla had passed on the last occasion.
Yes.
Your Lordship has that minute.
ಮೇಡಮ್ ಕೊಡಿ ಅದು ಯಾವುದು ಒನ್ ಮೊಮೆಂಟ್ ಇದರಲ್ಲಿ
Doesn't have a memo.
ಅದು ಇಸ್ಕೊಂಡ್ಬಿಡಿ ಮೇಡಮ್.
ಇಲ್ಲ ತಗೊಳ್ಳಿ.
ಕೋಡ್ ಆಫೀಸ್
ಅದೇನಾ?
ಅಲ್ಲ
ಅದು ನೋಟ್
ಅದು ಅಲ್ಲ ಅದು ಯಾವುದು ಅಲ್ಲ
ಅದಲ್ಲ ಇದು ಕೋಡ್ ಆಫೀಸ್ ಇದು ತಕೊಂಡ್ಬಿಡಿ ಅಲ್ಲ ಪ್ಲೀಸ್. ಸಿಕ್ಕಿದ್ರೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಪರವಾಗಿಲ್ಲ. ಕೋಡ್ ಕರೆಕ್ಟ್ ದಟ್ಸ್ ಔಟ್. Thanks.
May I? Your Lordship may kindly see the note sheet. Now, the manager SD and the manager TIC starts with number 1, column number 1. Now, what they're trying to say is, these are the rates of Genus, HPL, Linkwell, Schneider, all of them. One is, Genus also sells in Rajasthan, and this is not the rate. Now, the second aspect is, this is not the way now, if they actually had to produce, they would have had to produce how they had sought for from each manufacturer, and they would have produced the details as to how they approved any of these people. Nothing. Now this office note very strangely does not have the signatures, the page does not have any dates mentioned. Lordship may kindly turn to the next page. Your Lordship will kindly see they have extracted. Your Lordship has that extracted portion which has serial number 406 to 315.
Yes.
Please. This, Your Lordship may kindly see, is as a result of what we had referred to in page rejoinder. Your Lordship may kindly see, we had referred to these KERC 2023.
Yes.
This is what we had referred to, stating in 2023, our own KERC says that the price of the smart meter, Your Lordship may kindly see serial number 408, what they refer, is 2461. Now this, Your Lordship may kindly note, is what we have produced in our rejoinder at page 244. Last time I had taken Your Lordship through page 244, which dealt with the KERC 2023 regulations, which said that the price of the smart meter would be 2,461, serial number 411, price of the three-phase would be 32, and LT would be 4,000. Now, since I made this argument, strangely it seems to find itself in the office note. Now they want to
This is why you
explain
say
this.
it is concocted.
Absolutely. Now Your Lordship may kindly see the explanation. As per the recent KERC regulations directives issued in 2024, which mandates effective implementation, there's a clear need to procure latest generations. Also, as per so-and-so letter, smart meter shall be specified in so-and-so, so-and-so. It says that, considering next paragraph there itself, considering the fact that the SR rates have not been updated to reflect current market conditions, it is not advisable to rely solely on the outdated SR for rate evaluation. Your Lordship has that?
Yes.
This is below that.
That I'm seeing.
Now, what they seem to say is, this is outdated. We don't seem to have a new thing. Now, strangely, inflation seems to have struck only Bescom. If this inflation actually had occurred, KERC would have modified it uniformly for all ESCOMs. Bescom Somoto decides that what KERC had decided is outdated as of 2023, and strangely prices from 2023 to end of 2024 double. And that's their inflation, which only Bescom seems to be hit. Next. And your lordship, this we had referred to in the energy department common schedule of rates. So they are all required, KPTCL, ESCOMs, PWD, all of them would have to follow this. So therefore, this next, your lordship may kindly see next page. Then the signatures, your lordship, they have an MD signing, they have GM signing, but strangely again, no dates at all.
The dates you find only in the end, in the note sheet.
Your lordship, even
Now
in the
come
end.
to the last 15/3/25, 15/3/25 is the date on which they have signed. I think the interim order is granted on 9/4/25.
Correct. And
I guess so.
by then tender was cost is all
Huh,
over.
everything was
So the
over.
question then this wouldn't have arrived. That's why I'm saying my petition came later, tender came prior. If at all this was the issue, then this would not have arisen because they have concluded everything. So for them to come up with explanations would not have arisen. And if it did, it would reflect in their annual general body meeting, which we have produced. Therefore, if at all they had this, this would have had a mention in their annual general body meeting. Next, they also refers to the discussions with respect to single phase, three phase, all of these details. Your lordship, none of this would be of relevance since this seems to be a concocted document. Had they produced an entire file and this was there in that file, then I would
Direct them
probably
to
agree.
produce.
Please, they have not complied with that order, your lordship, of your lordship's earlier order.
To correction. These are of 24, not 25.
15/3/25 ಅಂತ last ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Signatures are all of 2025. 15/3/25. ಯಾಕೆ ನೋಡಿ.
There was a board of directors meeting on 22/11/2024. So if
That
at all
is-
this was there, as he says in 2024, then which was at that point of time, this would have been referred.
What is that 15/3/25 then?
They'll have page number. All this was in.
ಅದು
Lord's
ಉದಯೊಳ್ಳ sir
approvals
ಕೊಟ್ಟಿದ್ದು.
tender.
Last time ಉದಯೊಳ್ಳ sir ಕೊಟ್ಟಿದ್ದದು.
Lord's, if your lordship sees, the tender was in November 24.
All right, 15/3/25 signatures are there.
My lords, I will just see, because we don't have the copy. It's only continues, my lords, from beginning.
Correct. It ends at 15/3/2025.
Yes, before that, all those things have occurred, my lords. My lords, if your lords, I'm sorry, it's your copy. Lords, my lord's copy. Now, my lords, if your lordship sees page 2 in
Let
the.
madam finish, wait. Yes, madam.
Your lordship, if your lordship takes the additional affidavit that Bescom filed on the last occasion, to which right now we have passed on the reply.
Reply to the additional affidavit, yes.
Please, that additional affidavit, if your lordship could kindly take. Paragraph 16, your lordship.
Additional affidavit. Madam, additional affidavit. I have your reply, but
This is,
what do you want to say, madam? I'll get it. Hey.
please, your lordship. Paragraph 16 is what they had read. I state that this charge is to be paid on a monthly basis amounting to 75 rupees per smart meter. I state that this 75 rupees is not being passed on to the consumer, irrespective of the fact that the consumer has availed the smart meter or not. That is because respondent number 2 will save money on infrastructure, logistics, as so and so, giving a detailed list. Lordship may kindly see 17 then. I state that smart meter model is a self-sustaining model, does not require passing on AMI SP to consumer. As of now, there's no such directive from KRC to collect the said AMI charges. That in the event this cost has to be passed on to the consumer due to unforeseen losses. Now, Bescom's not in a profit making, nevertheless, in respondent number 2 company, this action would have to be approved. We have asked their.
How can it be profit making? You saw the bill, ella minus. Ella subsidy.
This action will have to be approved by KERC in tariff fixation after public notice, as is general practice. They themselves say. Now, this tariff revision, they have never taken the approval of KERC, which they should have done had we been told that this is the smart meter cost. There is a huge difference. Then you would have to pay this adverse amount. That tariff revision never happened. KERC never called for that. Public the call for was only with respect to smart meter, not with respect to tariff. Now here, your lordship, with respect to my rejoinder that I had filed. Your Lordship, in page
Page.
page 58, Your Lordship.
ಸ್ಮಾರ್ಟ್ ಮೀಟರ್ ಆಗಿ ಆಸ್ತಿ ಮೇಲೆ 2% ಸೆಸ್.
Already they have barely started with it, and their proposal is, besides property tax increase, this will be also an increase of a 2% cess. And therefore, by stating that I will not pass it on to the consumer, they will pass it on to the consumer, and they've already decided to do that, is my argument, Your Lordship. Your Lordship may kindly take section 163 of the Electricity Act, which Mr. Holla had referred to, please. 163, Your Lordship, in that paragraph.
Well, where is the AG is coming?
I think he should come.
But clarification, yes,
Please.
smart 2% cess.
163, power for licensee to enter premises or remove fittings or any other apparatus of licensee. Now, Mr.
Correct.
Holla's argument was that I can at any point of time change a meter. I have the right to do so, and 163 provides it for me. Now, this is ultimately a right of way. Any agreement between an owner and a tenant, it says at any point of time, the owner gets access, prior notice at any reasonable point of time. That is what this is. This is more with respect to access. Might I read further? A licensee or any person duly authorized by the licensee may at any reasonable time and on informing the occupier of his intention enter any premises to which electricity or has been supplied to him of any premises or land under, over, along, across, in, upon which the electricity lines or other works have been lawfully placed for the purpose of inspecting, testing, repairing or altering the electric supply lines, meters. So we have altering. Meters, fittings, works, apparatus, so and so, ascertaining the amount of electricity supplied in quantities. C, removing where a supply of electricity is no longer required or where the licensee is authorized to take away and cut off such supply, any electric supply lines, meters, fittings or apparatus belonging to the licensee. Now, this is critical, belonging to the licensee. All of this is where the licensee held the meter. Here, under this person has to purchase a smart meter. Now, I will go back then to section 5, which I had taken Your Lordship through, where he says he can buy it himself under 5. Therefore, when it gives you that option, and 163 speaks of licensee where it is his meter which he's talking about, then he has the right to enter the premises at any point of time. Now, we have separate smart grid regulations which have come in. So this is not with respect to smart grid regulations. This is not even with respect to a smart meter. Even if it is with respect to smart meter, the person who is purchasing a meter has the right to purchase, and this only deals with the licensee who is the owner of the meter. So there's a huge variation, Your Lordship.
But the only, I may consider all your submissions. The only thing is division bench.
Your Lordship, in fact, the division bench of our honorable court, which I had read on the last point of time, in fact, in that, it was an even more complicated case where, in that matter, Lordship Justice Dikshit and Justice Varale and Justice Dikshit's matter, where they say, in fact, the other side had raised the issue that, in fact, it was a fraudulent concocted document and that he did not have the authority. They overlooked all of that. They said the larger question is so and so, and it need not be looked into in public interest. When a person is affected, everybody has a right to approach the court, and even in a single bench writ jurisdiction, Your Lordships have the authority to go into that issue.
You are not a rival tenderer.
I'm not a rival tenderer, though they want to say so. If at all rival tenderers were there, Your Lordship, December 2024, the tender went on. Anybody who was aggrieved, whether it was through a front or whatever, would have approached this honorable court in January, not when we come before Your Lordships just prior to vacation, wherein slowly we are realizing how smart meter works and how each individual is aggrieved. And Your Lordship, where they also went wrong was, We had come first before your lordship. They seem to say that we didn't get
PIL was first or this?
PIL was filed, but it never got listed.
No, anyway,
Meanwhile,
it
please,
was filed before the petition.
before, what they seem to mention to your lordship is PIL order sikilla il bandru. That is not the case. What was first listed?
PIL stay madalla.
No. Even otherwise, that was their argument. So I'm trying to say that we came before your lordships first. What the matter came before the PIL was listed much later.
After the interim order.
After this order.
Was it brought to the notice
It
of
was
the division
brought,
bench?
of course, would they leave? They went on and on harping the same story about identical mistakes are the same. They went on and on about this. The division bench wanted to club, since they were already prior to us, there were 2 other PILs filed by other persons. Therefore, all of them were to be clubbed. And now objections and rejoinder, if any, that is where it lies. So therefore, there's been absolutely no misleading. Now, if I can come to those judgments in the end, where I will show your lordship that we would have, not just on the locus, that your lordships could also go on the aspect of whether it is in contravention of the regulations, because that is where I am at.
No problem at all.
That is where I am at.
The only thing is about
I
pendency
would
of
not
division
go
bench,
beyond
that's all.
that. I would not go beyond that.
Division bench pendency is what holds the
I
hand.
understand, but that is with respect to the tender. Here's an issue where a person, individual, is allowed.
Otherwise, definitely we could go the whole hog.
Your lordship, even the whole hog, I will restrict it only to whether the guidelines are in conformity with the regulations, and which I'm allowed to do as an individual when I raise a matter.
PIL submission ilva? That argument is not there.
We have put everything, but we have not raised the issue with respect to anything with respect to the tender is not raised here. We have put all the tender documents and brought those points only to show the fraud angle, nothing else, your lordship. Please.
Yes, Aita.
Your lordship, 5 more minutes. Please. Your lordship, even the KRC regulations that were discussed with respect to electrostat,
Madam Hagar, 1 nimsha. 2:30 mood matters ide. I'll take it. Give me 10 minutes. I'll get back.
Your lordship, we are at any point of time.
Yes.
Please.
5 o'clock. I'll resume back. I'll finish those 2:30 mood matters.
Please. By then, in fact,
They'll be waiting.
In fact, by then the AG will also be back.
No
Please,
problem.
please.
Madam, AG's colleague.
No, AG's
AG's colleague. Yeah.
Anyway, he'll convey it to the AG.
2% cess ಬಗ್ಗೆ information I want.
Let's say lordships wants on cess and?
No, 2% cess. Is it already being imposed on smart meters being installed? That information I want. Ask the Learned Advocate General to take it. 2:30 mood matters.
2:30 mood matters. Serial number 1. Ashik Raj.
Between me and the sites, sir. Yes.
My lordship.
ಅದೇ ಸೇಮ್ ರಾಜೇಶ್ ಎಕ್ಸ್ಪೋರ್ಟ್ಸ್ ಯಾವುದ್ರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಮ್ಯಾಚ್ ಆಗಲ್ಲ
ಸರ್ ಶೆಡ್ಯೂಲ್ ಇದೆ
ಎಲ್ಲಿದೆ
ಇಲ್ಲ ನಾವು
ಶೆಡ್ಯೂಲ್ ಮ್ಯಾಚ್ ಆಗಲ್ಲ ಅಂದ್ರೆ interim order will not come into operation. I will observe that. This court in identical matters has granted an interim order of stay of the eviction of these petitioners. The interim order would become operational insofar as these petitioners and the present petitioner is concerned only if the schedule as found in the petition or in the suit in which the eviction orders are passed would match, failing which the interim order would be inoperational. ಮಿಕ್ಕಿದ್ದು ಅದು ಐಡೆಂಟಿಕಲ್ ಮ್ಯಾಟ್ರ್ ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಮಾಡ್ಬಿಡಿ. ಎಸ್ ಮಹೇಶ್.
Number 2, withdraw.
In terms of memo.
Withdrawal.
Learned counsel for the petitioner has moved the matter seeking to withdraw the petition on account of the redressal of his grievance. Yes, next. Petition disposed as withdrawn.
Serial number 3, Moinuddin and converted to
Convert to CRP.
Yes, ma'am.
The counsel for the petitioner files a memo seeking conversion of the petition to a civil revision petition. In the light of the memo, the permission is granted to convert the same civil revision petition for the sake of statistics. Yes, next.
preliminary hearing. Serial number 4, Lokesh R.
Ajay Kumar is here. Counsel Ajay Kumar is directed to accept notice for the respondent BD petitioner to serve set of papers upon the counsel forthwith. List the matter on Friday in the preliminary hearing. Yes, Parmeshwar.
My application for recalling the
Witness.
plaintiff witness
1817.
has been rejected.
Order 18 Rule 17.
Yes, my lord. Though the order has been this court in RFA set aside the entire judgment and decree and remitted the matter back for the fresh disposal.
When was that?
My lord, say it is on 6th of March 2025. 6th
The
March.
petitioner shall serve on the counsel who represents the respondent in the trial proceedings. The petitioner defendant is before this court calling in question an order which rejects the application of the petitioner under Order 18 Rule 17 seeking recall of which witness yaru?
PW 1 and 2.
PW 1 and 2 for the cross-examination. The learned counsel submit that this court had remitted the matter back to the hands of the concerned court on 23rd March.
6th March.
On 6th March 2025 to consider the matter entire issue afresh. Therefore, he was entitled to seek recall of PW 1 for further cross-examination. That having been denied, the denial of which prima facie is contrary to law. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. List on 4th August.
My lord, sir. Prayer alli OS number mention madilla, I may be permitted.
Change agbaka.
Illa, mention madilla. OS number.
In OS number so and so. Next.
Please.
Number 6.
Kodi. File kodi madam mention ಮಾಡಿ.
So in this, the
Yenidu Kabbanpet silk handloom weavers. What's the problem?
They are struggling from 1964 to get back their properties.
ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅದು ಸೈಟ್ ನಮಗೆ ಇಯರ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ they have taken that site the CD from us, and earlier also on 16 to 2025 they notified it for public auction, and I have made an application before this government passed the order not to proceed with the public auction so and so. But thereafter
ಯಾವತ್ತಿದೆ ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್?
ನಾಳೆನೇ ಇದೆ 23 ತಾರೀಕು.
To be held to.
ಏನಿದೆ? What's the problem?
I'll just inquire, take instructions.
Huh?
I'll take instruction, Lordship may have it tomorrow.
ಆಕ್ಷನ್ ಆದ್ಮೇಲೆ?
ಇಲ್ಲ, ನಾಳೆ 23 ನಾಳೆ bidding start ಆಗ್ಬೇಕು. Lordship may have it as top of the list tomorrow morning.
Well, I also have to serve copy on 17 itself.
I have, they had served me copies, but they. Tomorrow.
Let's tomorrow.
Morning of.
Tomorrow in preliminary hearing.
10:30 ಗೆ ಇದು public.
Oh, we'll take it at 10:30. You be here, Murugesh. Get instructions and be here.
Yes.
Yes.
7.
Withdrawal. Mood for withdrawal. Conversion. ಯಾವ್ದು ಮೇಡಮ್? Withdrawal ಅಂತಿದೆ. Listed on Friday. Will not permit withdrawal. Yes.
Pastoral matters. Pastoral matters. 22.
Yes, Murugesh. Registration ಏನು?
The 13 sites have been executed.
Filing an affidavit. Lord, the sale deeds which were executed by the BDA in respect of survey number 93 landowners, Lord, are also a subject matter of adjudication before the Lord. This one court, Lord, may pass on.
ಈಗೇನ ಕಾಪಿ ಕೊಡಿ affidavit ಅವರಿಗೆ.
ಹಾ ಕೊಡಿ. ಇಲ್ಲ ಅವರಿಗೆ. What we are saying is the sale deeds which were executed in favor of the landowners of survey number 93. Lord, they are also before Lord the BMTF. BMT, we had executed a sale deed. Thereafter, a complaint was lodged saying that the records are fabricated.
Cancel ಆಗಲ್ವಲ್ಲ ಹಂಗೆ?
ಇಲ್ಲ, ಇನ್ನು cancel ಆಗಿಲ್ಲ because they are all
before the BMTF. Now, my lord, what the present petitioner is asking is, execute, since you have already decided to allot, and my lord, there is a formal sale deed which has been, is yet to be registered. You registered those sale deeds, is the, my lord, the contention. My lord, in an affidavit, my lord, what we are trying to say is, before we could come to know about this, we have executed, but after it's coming to know about the land being, the documents being forged at the end of the, my lord, the revenue officials, we have not gone ahead and
Yes,
we have
sir.
not done.
Let me kindly appreciate here, my lord.
What?
There is the point for consideration here, 13 sale deeds are executed by the BDA. The
ಅಷ್ಟೇ ನಿಮ್ ಗ್ರೌಂಡ್ 13 ಸೇಲ್ಡ್ ಆಗಿದೆ,
ಹೌದು.
ನಿಮಗೂ ಆಗ್ಬೇಕು.
In the remaining 8, in fact, your lordship, there is no complaint or FIR or in the charge sheet, the name of the present petitioner or husband.
ಪ್ರೆಸೆಂಟ್ ಪೆಟಿಷನರ್ ಇರಲ್ಲ,
ಅಲ್ಲ, petitioner.
ಬೇರೆಯವರದಿದೆ.
In fact, BDNಲ್ಲಿ ಎಲ್ಲೂ ಸಹ so far the FIR or in the charge sheet, the ಅನ್ವಯ.
ಈಗ ನಿಮ್ ಸೇಲ್ಡ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ರೆ ನಿಮ್ ಮೇಲೆ ಬಂದಿರೋದು, ಇನ್ನು ಆಗಿಲ್ವಲ್ಲ.
In fact, so far the 18 sale deed, suppose assuming for a moment, my lord.
We'll see, we'll prima facie hear it.
Why I am telling my lord, here my lord, you will me kindly the point for consideration. Once the sale deeds of 13 sale deeds are executed, and in 2019, my husband passed away. Now the husband of the petitioner, because of the COVID, he passed away. Later, authenticity of
ಎಲ್ಲ ಸೈಟ್ ನಿಮ್ದೇನಾ?
ಹೌದು, ಎಲ್ಲ
ಮಿಕ್ಕಿದ 13 ಇವ್ರದೇನಾ?
ಹೌದು,
ಇದು ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ.
ಹೌದು,
13 ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ ಯಾರ್ದು?
ನಮ್ಮದು. I am the land loser to an extent of 4 acres.
ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ, ಇದು 13 ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ ಯಾರ್ದು?
ಹನುಮಯ್ಯ ಸನ್ ಆಫ್ ಹನುಮಯ್ಯ ಮಾಡಿದ್ದು.
ಹನುಮಯ್ಯ, ಹೂ ಇಸ್ ಹನುಮಯ್ಯ? ಪೆಟಿಷನರ್ ಹನುಮಯ್ಯ ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಮಾಡಿರೋದು.
ಹೌದು, 13 sale deed ಬರ್ತದೆ.
ಅದು ಎಲ್ಲ
ಒಂದೇ ನಿಮಿಷ ಸರ್.
They are all before, not the BMTF. BMTF is taking note of
1 minute.
the entire.
You have registered 13 sale deeds in favor of Hanmaya.
Yes.
Correct?
Yes.
Hanmaya is the wife of the petitioner is the wife of Hanmaya.
Yes.
Hanmaya dies. Now what is the change in circumstance that you are not registering?
Change in
All those 13 sale deeds are complained of?
Yes.
Who
Lord,
has complained?
Lord, may kindly see one, a complaint was filed.
According to you, Hanmaya was not the land loser?
No, this complaint says one by Puttaswamy.
Who is that?
Lord, page 7, Lord.
Page?
Page 7 of my statement of.
Any crime registered against them?
Lord, there is an FIR registered. And BMTF is considering this entire all.
What is the allegation against Hanmaya?
Lord, against Hanmaya is the one Hanumaya, there are no, their records are fabricated in the revenue section, showing it that the grants are, even though there are no grants, the records are created as if not the grants are there in their favor, and compensation is to be secured from the BDA. But that is an allegation. Based on that allegation, not a complaint is filed. Not they seize all the documents, and not BMTF is looking into it. So the clear, not we have no objection.
You produce those complaints before the BMTF.
Please.
BMTF is a party here?
No.
Solid, you can access it. I will not permit further registration, sir.
May I request, my lord, your lordship kindly appreciate their own legal.
They what anta kelta idini avaginda.
No, ತಮಗೆ ಗಮನಕ್ಕೆ ತರ್ತೇನೆ. There is a.
Appreciate what?
Appreciate the legal opinion given by the VDA.
Should appreciate legal opinion.
No.
Excellent opinion.
No. One Srimati Marama, kindly for a minute. Wife of late Hanumaya submitted a representation, the land situated Kannahalli village being 93, Yeshwanthpura, Bangalore, measuring 4 acres, was acquired by the authority for the formation and perpetual level. Accordingly, the developed sites have been allotted to her husband, Hanumaya. Meanwhile, her husband was passed away on 30/4/2020. Therefore, she sought for a transferring the executed sale deed in her favor. Peruse the Mahadar, death certificate, family tree, and the other relevant documents.
Legal opinion.
In fact, your lordship, the authenticity of the LRs has been verified. Mahazar is conducted and based on that, the legal department has given an opinion. Proceed for the further executive.
So we will issue mandamus on the legal
Exactly, your
opinion.
lordship. That's all.
Exactly.
That is the prayer for only to remaining sale deed to be executed. That is my submission. Your lordship kindly appreciate and the.
Appreciate it. Yes.
Lord, the legal opinion is given on the basis that the Marama makes an application. saying
Maramma?
So, please.
Who is Maramma now?
Marama is the present.
Wife
petitioner.
of the, this is
Present petitioner.
Anmaya.
Maramma, yes.
Marama makes an application saying that my husband was allotted with the sites. After his death, I am entitled for an allotment of those sites in my favor. Under those circumstances, whether she can be allotted a site, she being a wife who's claiming. Under those circumstances, Lord, the legal opinion was given saying that she is a wife and Kodabodu anta only. But the fact here is that, Lord, with regard to the genuinity of the documents which are basically that. That is what is my response.
One more, one more point here, my lord.
Yes, side ಬೇಕು.
Remaining 8 sites ಅಷ್ಟೇ. the 4 acres was, my land was utilized. 33,000.
Your land alva.
Your land, the government land, ಇವರು
ಸರಿ ಒಂದ್ ನಿಮಿಷ ಸರ್.
That is an
I'm
allegation.
appreciating
Lord,
your
I
submission.
have not come to that conclusion. Lord, I have not concluded. Says it's a government land and there are records are fabricated.
Government land compensation ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
Government land ಗೆ ನಾನು grant land ಅಂತ ಹೇಳಿ fabricated.
Misrepresenting the facts.
Misrepresenting the facts.
When sir, there is a consent award is passed, that is a BDA responsible institution, statutory body acted upon it. No.
Don't say that, sir. ಅಲ್ವೇ ಅಲ್ಲ.
No, the statutory body acted upon it.
PDA responsible institution ಅಂತೆಲ್ಲ ಟೈಟಲ್ ಕೊಡ್ಬೇಡಿ ನೀವು.
A statutory body acted upon it and 13 LDDs are executed. Can they say now, after lapse of 3 years, no, I will not prepare to execute in the name of a wife?
I want those complaints against the husband.
Lord,
Get the complaints.
Please.
And merely because 13 are registered and those are now termed to be illegal, unless I look into the records, I will not direct these to be registered.
Lord, may permit me to receive those documents from the BMTF.
The learned counsel Murugesh Charati, representing the BDA, submits that 13 sale deeds no doubt were registered in favor of the late husband of the petitioner. What remains is the 8 sites that are sale deeds of 8 sites that are not registered. The learned counsel submits that the husband of the petitioner, while registering the sites, had forged certain documents, and those complaints, allegedly forged documents, and had those complaints are pending before the BMTF. Therefore, the counsel Murugesh Charati is directed to correspond with the BMTF and place the complaints against the late husband of the petitioner, the 13 sites that are already registered. In the light of the illegality projected in the registration of the 13 sites, the 8 sites that are now sought for registration cannot be granted. Prima facie, there is no negative equality in law. If it is illegal for 13 sites, it cannot be said another 8 sites will also be directed by a stroke of pen at the hands of this court, unless the records are seen. List on 1st August. 5th August, sorry.
Instead of my name, BDA to correspond.
BDA to correspond.
In fact, let him produce the certified copy of the, we have produced the grant register also, my lord.
Godly document.
No, ತಾವು kindly.
Our allegation ಹೇಳಿದೆ ನಾನು.
2019 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋ consent award can they say after lapse of many years, no, it is not correct. No steps has been taken by BDA. All these years.
Let us see.
There must be fairness on the part of the BDA.
ನೀವೇ responsible institution ಅಂದ್ರಲ್ಲ.
I do agree with you. ನಾವು ಹೇಳೋದು ಅಲ್ಲ ಈಗಾರ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆಗ್ಲಿ ಅಂತ.
47.
ಹತ್ತು ದಿನ ಬಿಟ್ಟು ಸರ್ವ್ ಮಾಡಿದಾರಾ?
16th they have served it. 16th they have, not 17th.
16th
they have
just
served.
ಯಾವತ್ತು entry order 7/7.
7th is the interim order, 9th it was released, 10th we have served the copy of the interim order. Yes, we have the acknowledgement. 10th we have served the copy. ಕೊಡ್ರಿ ಅವ್ರಿಗೊಂದು. 10th we have served this with an acknowledgement from the BDA. 16th we have served the writ petition papers.
What was the order?
Lord's order.
1 minute, sir. 1 minute.
Directing 7/7, my lords, if your lords were to see.
7(7)
Yes.
is directed to accept notice to serve set of papers on the aforesaid learned counsel.
Yes, my lords.
Is the advocate in record understanding the order or not?
My lords, if there is some lapses, my lords, we owe an apology to your lordships, my lords, that they served the interim orders on.
This is not correct.
That's-
When I say
Lords,
immediately serve, why do you take 10 days to serve?
Lords, there is
We'll
some.
vacate the interim order on that ground only.
Lords,
This is not correct.
I understand, my lords. I don't want to say that your lordship's directions. once
Now,
it
why
is
do we
directed-
direct immediate services? We can post it on the next day or 2 days later.
Lords, your lordships are directed the
conclude.
matter to be listed on
ಇದೆಲ್ಲ old
22/7.
style ಎಲ್ಲ ಬಿಟ್ಬಿಡ್ಬೇಕು.
Lords,
Late ಆಗಿ serve ಮಾಡೋದು ಬೇಕಂತ ಇವೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು.
ಮಾಡಕ್ ಆತರ ಏನು
ಇವೆಲ್ಲ
ಮನ್ಸ್ನಲ್ಲಿ
ಹೇಳ್ತಿರೋದು.
ಇಟ್ಕೊಂಡಿಲ್ಲ.
Yes.
ಅವ್ರು ಸರ್ವ್ ಮಾಡ್ಬೇಕಾರೆ ಒಂದ್
ಇವರು
ಸ್ವಲ್ಪ
ಅಲ್ಲ,
ಸೆಳೆತನ
previous
ಕೊಟ್ಟು-
council.
ಅದಕ್ಕೆ.
Yes, why did you do that? Apology, vacate and interim order will vacate. ಇದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. 10th ಯಾರು ಕೂಡ ಕೇಳಿದ್. Aforesaid council ಅಂದ್ರೆ how did you serve it to the BDA?
ಇಲ್ಲ ಅವರಿಗೂ ಕಮ್ಯುನಿಕೇಟ್ ಆಗಿ ಅಂತ
Why did you not serve on him?
ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಯಾಕಂದ್ರೆ ನಾನೇ ಸರ್ವಿಸ್ ಮಾಡಿದವರಿಗೆ ಇಲ್ಲಿ ಯಾವುದು
Not correct at all. This is not the way. Yes, sir. ಹೇಳಿ.
Lords, I would only say this, my lords, your lordships may accept the apologies of the learned counsel, my lords. There is some lapse on our part. I don't want to say.
No, it's a
anything beyond
deliberate
it.
lapse. That is what I am saying.
I don't say that.
See, what, they don't, it is, I don't think it's so complicated to understand the order.
Certainly not, my lords. This.
On the aforesaid
in the
council,
usual
Murugesh
course-
Charati ಕೊಡಿ ಅಂತ 10 ದಿನ ಆದ್ಮೇಲೆ ಕೊಡಿ ಅಂತನಾ?
In the usual course, this is being served, my lords, to the council. It's
Not
that-
usual course.
The usual course, these copies will be served.
Council
my
has
lords, to the
taken
council.
10 days to serve. Why?
Lords, the copies is come and then they have served it on 16th. The matter was directed to be listed on 22/7.
Yes.
By about a week before that, lords, they have served it. There is no deliberate intention that just a day before or on that day they have served it. There is some lapse on our part, my lords. There is no way that I will come before your lordships and say that there is no lapse. There is some lapse. But lords, the question now as has been brought about.
No, ಇದು 10th release ಆಗಿಲ್ಲ. Hand delivery ಇದ್ದಿದ್ದು ಅವತ್ತೇ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ.
9th it was released, my lords. If your lordships were to see, the order is there.
All right.
I have produced that order copy also. It was released on 9th. And 10th, my lords, we have served it to the BDA along with the acknowledgement.
ಈಗೇನೀಗ?
Lords, now this very property they are putting it for auction. Serial number 5, my lords, in the public notice which
No,
they
no,
have issued.
there is an order of the coordinate bench already to take police protection and evict you from the property.
Lords, after that, we went before the division bench. My lords, division bench made an observation which was also confirmed, my lords. This observation is confirmed even by the, lords, I can understand, my lords. Now, the question is, now there is an order which is passed by your lordships. I can understand. They will have to adhere or seek for your lordships modification. It is not that ex post facto they want to come and say that this is something not right on the merits and therefore whatever action they wanted to do. Notwithstanding your lordship's order is to be given a justification.
We'll-
That's not
we'll
the
take-
stand they can take.
We'll take it tomorrow at 2:30.
Lordships.
Yes.
Lords, could it be day after tomorrow? It's tomorrow, 2:30 there is.
Day after tomorrow, yes.
23rd, 24th.
ಇಲ್ಲ ಫ್ರೈಡೆ ಬೇಕು ಫ್ರೈಡೆ
Friday, my lords.
ಫ್ರೈಡೆ
Please.
ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಎಸ್
Lords, the auction is there tomorrow, my lords. Let them not conduct the auction.
What has happened is, on 2nd, the demolition was completed of what they claim is of 21 guntas. But this court has come down heavily onto them, saying that in spite of an interim order, by giving a police
ಡೋಂಟ್ ವರಿ
protection.
ಆಕ್ಷನ್ ಇಂದ ಏನಾಗಲ್ಲ ಎಸ್
Lords,
Friday.
page 124, your lords may kindly see.
ಫ್ರೈಡೆ
lords.
ಫ್ರೈಡೆ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ಫ್ರೈಡೆ
This is a, my lords, auction if it is conducted third party rights. I'll have one more opponent to oppose.
ನೋ ಪ್ರಾಬ್ಲಮ್ ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ನಾಟ್ ಟು ಇಶ್ಯೂ ಎನಿ confirmation orders.
That if your lordships were to direct.
The learned council senior council submits that the auction is slated to be held tomorrow. The
Lord,
respo-
18/7 is the, Lordship may kindly see the.
respondent BDA shall not confirm the auction sale without the leave of the court.
Lordships.
The date of.
List on 25th.
Date of commencement is 28/7.
28/7.
28/7.
List on 25th, yes.
Please.
No problem, list on 25th.
Date of
No order,
commencement is.
list on
28.
25th ಅಂತ ಮಾಡಿ. Friday Ravishankar.
68.
Lords, the last date to, date and time to express interest of participation is on 18/8.
18th August, sir.
Yes.
18th
ಟೈಮ್
August.
ಇದೆ.
21 ಆಯ್ತು. ತುಂಬಾ ಟೈಮ್ ಇದೆ ಹಂಗಾರೆ.
ತುಂಬಾನೇ ಟೈಮ್ ಇದೆ.
25ಕ್ಕೆ. ಆಯ್ತು. Lords, interim order, my lords.
25ಕ್ಕೆ ತಗೊಳ್ಳೋಣ ಇಲ್ಲಾಂದ್ರೆ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 29 ಬೇಕಾದ್ರೆ.
Very well, my lords. 29th.
List on 29th.
Please.
What's the interim order, my lords, which is granted? by
Interim
the-
eviction, the interim
Yes.
order subsisting will continue till the next date of hearing. Yes.
Noted.
Lords, the interim order is not till today, my lords. The only
Absolutely.
direction
ಮತ್ತೆ
is,
ಯಾಕೆ ಬಿಡಿ,
please.
ಏನು ಬೇಡ, ಸುಮ್ಮನೆ ಇರಿ.
68.
We'll take it on 29th.
70.
Same 29th.
78.
ಅದು 29th. 29th.
ಲಾರ್ಡ್ಶಿಪ್, ಒಂದು ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಲಾರ್ಡ್ಶಿಪ್, ಅದು
ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಕದ್ದಿಲ್ಲ ತಳಪ.
Serial
29th. Yes.
Serial number 78.
All 29th.
Instead of 29th, what matter 230.
ಯಾವ serial number?
Serial number 78.
ಆಯ್ತು, ಎಲ್ಲ 29th ಬೇಡ, 5th August ಹಾಕಿ.
Serial number.
All matters 5th August.
ಅಲ್ಲ 28.
5th August. Yes.
Even serial number 70 on 5th August.
5th August.
Dharwad matters, my lords.
ಒಂದು ನಿಮಿಷ.
Serial number
79. Interim order may be extended.
ಎಲ್ಲ interim order continue ಆಗುತ್ತೆ. Wherever interim order is there, they'll continue.
230 mode SV Lakshman.
SV?
5 ನಿಮಿಷ ಮಾಡ್ತೀನಿ.
Permission to convert.
Conversion, madam?
Yes, yes.
Same, converted in terms of, converted to CRP, na?
Yes, your worship.
Yes, converted to CRP for the statistical. ಈಗ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ನಲ್ಲ, ಈಗ ಒಂದು ಮಾಡಿದೆ, ಗೊತ್ತಾಗಲ್ವಾ? ನೀವ್ ಯಾರಿಗೆ?
ಅಲ್ಲ, ಒಂದು 230ಗೆ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಮೂವ್ ಮಾಡಿದ್ದೆ,
ಬಂದಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಬಂದಾಯ್ತು.
ಎಲ್ಲಿದೆ? ಹಾ, ಲೋಕೇಶ್ ಶುಕ್ರವಾರ ಹಾಕಿದ್ದೀನಿ.
ಹೌದು ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಒಂದು ಎಂಟ್ರಿ ಮಾಡ್ರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್.
ಒಂದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕೊಡಕ್ಕೆ ಇರ್ಲಿಲ್ಲ ನೀವು.
ಮೈ ಅಪಾಲಜೀಸ್ ಮೇಲೆ.
ಏನ್ ಹೇಳಿ?
ಮೆಲೋಡ್
ಸರ್ವ್ ಮಾಡಿ. ಸರ್ವ್ ಆನ್ 25th ಬೆಳಗ್ಗೆ ಹಾಕಿ ತಗೊಂತೀನಿ. ಎಸ್.
ಅಲ್ಲ, ಅಲ್ಲಿ
ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
15 days ಒಳಗಡೆ ಪೇ ಮಾಡಿ 3 crores 85 lakhs ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಡಿಸ್ಪೈಟ್ ಇಶ್ಯೂಯಿಂಗ್
ಅಲ್ಲೊಂದು ಬರ್ಕೊಳ್ಳಿ ಅದಕ್ಕೆ. ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಶಲ್ ನಾಟ್ ಪ್ರೆಸಿಪಿಟೇಟ್ ದಿ ಮ್ಯಾಟರ್ ಟಿಲ್ ದಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಎಸ್.
ಒಬ್ಲೈನ್.
ನೀವು ಇರ್ಬೇಕು ಕರೆದಾಗ. ಮತ್ತೆ
ಆ ಕಡೆ ಕೋರ್ಟಿಂದ ಈಗ ಅಪಾಲಜೀಸ್. ಗ್ರೇಟ್.
ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಕರೆದ್ಬಿಡಿ.
Matters pertaining to Dharwad bench. Seal number 1 being spoken to. Seal number 1.
ಎಸ್, ಎಲ್ಲ 1st August ಹಾಕಿ ಮೇಡಮ್.
My lords, one request on serial number 6, my lords.
Yes, sir.
My lords, the earlier matters in serial number 6 were.
Serial number 3, Lordship.
1 minute, I'm calling the list. 1 ನಿಮಿಷ. 3.
Appealing for the petition, Lordship. ಇದರಲ್ಲಿ extension ಆಗುತ್ತೆ ಸರ್. Premature release, Lordship. Already 90 days grant ಆಗಿತ್ತು, Lordship. 90 days grant ಮಾಡಿದ್ವಿ.
spoken to ಯಾಕೆ?
Tomorrow is going to be.
ಇಲ್ಲ, being spoken to ಯಾಕೆ?
ಇಲ್ಲ, being spoken ಇಲ್ಲ. ಇದು
ಒಂದಿರೋದೇ being spoken.
ಇಲ್ಲ Lordship, ಅದೇನೋ ಒಂದು ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಆಗಿತ್ತು, ನಾವು ಅಂತ ಹೇಳಿದ್ದೆ ಕೋರ್ಟ್ ಹಾಲಲ್ಲಿ.
ಹಂಗಾರೆ ಈಗಲೂ ವ್ಯತ್ಯಾಸ ಆಗಿದೆ.
ನಾಳೆ ಹೋಗಿ
Day after tomorrow.
Lordship, tomorrow is expiring.
So what? Ask him to go back to the goal. List day after tomorrow.
Much.
In IA ಹಾಕಿದ್ದೀರಾ?
ಹೌದು Lordship. 90 days, Lordship.
Under the caption interlocutory application. Yes. Orders first time, what is that?
Earlier you had granted.
ನಿಮ್ದಲ್ಲ ಸರ್. Next matter. Notice.
5. Fresh matter seal number 5.
My lords, I'm for the petitioner, Your Honor. It's the respondent number 2. May. My lords. May. Respondent number 2 has lodged the counterblast complaint after receipt of notice from the family court, Your Honor.
The petitioners are accused 1, 2, and 3. The second respondent is the complainant. The complainant registers a complaint against the petitioner's husband, mother-in-law, and father-in-law, mother-in-law and brother-in-law of the second respondent, alleging offences punishable under section 498A inter-alia. The subject petition stood withdrawn on the score that the charge sheet was filed during the pendency of the petition. A perusal at the summary of the charge sheet would not indicate the ingredients of the offences under section 498A or any other against 2 and 3. The permitting further proceedings against the respondents 2 and 3, the mother-in-law and brother-in-law, would run foul of the judgment of the apex court in the case of Dara Lakshmi Narayana, 2025, 3 SCC, page 735. In that light, there shall be an interim order only insofar as petitioners 2 and 3. Insofar as the first respondent husband is concerned, the same would be considered on the appearance of the complainant. One HCGP, 2 emergent notice returnable by the 22nd of August. List on 22nd August. Next. Sir, 6 Tirumalesh sir, ಏನು ಹೇಳಿದ್ರಲ್ಲ?
Milords, what I suggest is that this may be sent to the regular bench because the earlier orders passed by your lordship were on monetary limits. The earlier orders were petitions were allowed on monetary limits, not on merits.
Post the matter before the bench having roster at the bench at Dharwad. Yes. Ordered accordingly.
Much.
Yes. Nadav. ಇದೆಲ್ಲ 7 to 11 interim order subsisting will continue till the next date of hearing. List on.
My lord, one submission, my lord. Serial number 11, my lord. There is no interim order, my lord. But case and counter case, my lord. In counter case, my lord, interim order has been granted, my lord. As per annexure F1, F and F1.
Which is that criminal petition?
Criminal petition, my lord. That is 101605 of 2025.
1605 of
25, my lord.
And 11. Tag this petition along with criminal petition 141605 of 2025. List them both on 1st August. 11
matra. One submission, Allah, ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಅದರಲ್ಲಿ.
Sorry, 1st August. Next.
101283, my lord. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ.
1st August, sir.
ಅದೇ ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ 101283 of 25.
ಅದೇ ಹಂಗೆ ಕನೆಕ್ಟೆಡ್.
ಅಂದ್ರೆ
ಕೇಸ್ ಕೌಂಟರ್ ಕೇಸ್ ಗೊತ್ತು, ಇನ್ನೊಂದು ಎನ್ಕೌಂಟರ್ ಕೇಸ್
ಅಲ್ಲ my lord, that accused my lord, one to different accused have filed different petitions, man.
Tag so and so again. The number ಕೊಡಿ.
101283 of 2025.
101283 of
25. My lord, my lord, in my petition interim order is not there, my lord.
Not there, sir. On 1st, yes.
ಅಲ್ಲ ಅದರೊಳಗೆ interim order ಇದೆ sir.
No, there is assault. We'll see. Yes.
ಅಲ್ಲ ಅದರೊಳಗೂ assault ಇದೆ, my lord. Same offenses.
Correct. ಆ assault ನು ತೆಗಿಯಕ್ಕೆ ಅಂತಾನೆ ಫಸ್ಟ್ ಹಾಕಿದ್ದೀನಿ ಈಗ.
ಅಲ್ಲ charge
we'll dismiss all the 3 cases. Yes.
My lord.
List on 1st.
Please.
12 to 16.
Lord, serial number 16, my lords. For respond number 2.
Lord.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ 16, my lords. Respond number 2 is police official. Government advocate may can be directed.
ಆಯ್ತು, learned HC ಇದು 12.
Lord, serial number 14, my lord.
12 interim order ಇದೆ ಮೇಡಮ್. ಅನಿಲ್ ಕಾಳೆ recalling. Recalling
in this, my lordship will not please to allow my petition. The complainant, my lord, has filed my lord impleading application.
Complainant was not heard.
My lord, he was not heard. Now, my lord, your lordships were pleased to allow his application. My lord, he has already come on record, my lord.
Then we will have to recall
considering the, my lord, material charge.
The petitioner, this court had disposed criminal petition on 10th August 20, subject criminal petition on 10th August 2023. The complainant was not made a party to the proceedings. The complainant has now sought to implead himself and the impleading application is allowed. In the light of the complainant not being heard at the time of disposal of the petition, the order stands recalled, the petition is restored to file. List the matter on 14th August.
My lord, serial number 10, my lord. There is no interim order. Serial number 10.
No interim order also will continue for next date, sir. Yes. 13, 14, 15. Interim orders would continue. List on 22nd.
16 also interim order is there.
Idre 22nd, yes. Adu learned HCGP is directed to accept notice for the second respondent as well anta ಮಾಡಿ. 16 ಅಲ್ಲಿ.
Please, sir.
Next.
18 minutes.
Hearing on IA.
17. Further orders. 132. List on first.
18 minutes. Minutes. 18 government has made this application for extension minutes. The Lordship are pleased to dismiss the review petition on 11/7/25 minutes. The earlier direction was minutes, your Lordship's order 12/2/25. Lordship had granted 30 days time to issue the.
ಈಗ ಮಾಡಿದಾರಾ?
ಇನ್ನ ಮಾಡಿಲ್ಲ minutes. Contempt ಹಾಕಿದಿತ್ತು, therefore they filed this application.
The state appears to have filed an application. State has filed an application in IA 1 of 2025 seeking extension of time. The order was passed on 12/2/2025 directing compliance within 30 days. 3 months have passed by and no compliance is made, and what comes about is an application. There is no justification for extension of time as we are in August, and the order had to be complied with within in the month of March. The application stands disposed. Next. 19.
Minutes. 19 appear minutes
on
at
Friday.
Your Lordship, he has already surrendered, Your Lordship, on 17/4/2025 itself, Your Lordship.
Then list on Friday. 20 also list on Friday.
Obliged minutes.
Further hearing 21.
Further hearing. Release the matter from the status of being parted. Post the matter before the bench having roster.
22.
Idu successive writ idu. Yes. Same. Release the matter from the status of being parted. Post the matter before the bench having roster. Interim order subsisting will continue till the next date of hearing. 23 is in the order. Yes.
23 minutes. I have produced the citations with the court officer.
List on 14th. Interim order subsisting will continue till the next date of hearing. Next.
Please.
24.
My lords, 24 I appeal for the petitioner, my lords, in this matter.
My lords.
Girish.
Please, my lords. My lords, it has been.
Hopefully,
ASD was. Please, my lords, they were. Hopefully, it was there, my lords.
ASD was there. We'll take it on Thursday.
My lords, next week, my lords, some briefing.
Problem. Bharat VC ASD is attar bide. It's habit of seeking time, is it?
No, my lords. My lords, in this matter only we are seeking time, my lords. In other matters.
My lords, 2:30, my lords.
Another case ilva.
Please, my lords.
Case illa adike time kelta idira.
Alla, my lords. Since notification is challenged, my lords.
Yes. List on Friday.
Please, my lords.
My lords, 2:30 would 2:30 be convenient?
2:30 ಗೆ ಹಾಕಿದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ ಸರ್? 2:30 ಗೆ 5:30 ಗೆ ರೀಚ್ ಆಗೋದು.
Kalburgi bench, still number 1.
Kalburgi bench. Your Lordship, Your Lordship, in this case, application was filed for recalling the impugned order dated 6/3/23 for non-compliance of objections, and therefore the application was
non-compliance of office objection idu.
Office objections.
Review petition, sir.
And subsequently, I filed the medical treatment report of my wife and myself. That is page number 11 and 18. Page number 11 to 18. Which medical treatment of my wife. And
the review petition dismissed agita. The review petition stood dismissed by an order of the registry for not complying with the order for the reasons not complying with the office objections. The petitioner has preferred an application seeking recalling of the said order for the reasons indicated in the affidavit accompanying the application, and being satisfied with the same, the application stands allowed. The order stands recalled. The review petition is restored to file. List on 7th August.
Great respect.
Agidya? Notice agidiyalla already?
Our question of delay, Your Lordship. Our question of delay in filing.
Notice on delay. Returnable
notice
by,
is issued.
notice on delay returnable by 22nd August. Yes.
Great respect.
Next.
Till number 2.
EN review.
Review of my lord's order, my lords, and dated
Huh?
16th April 2024. There was an order passed by my lords. But the review petitioner herein was placed ex parte, though service was done.
Sir, those served. Avella don't placed expert ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, those are my lords may kindly take my lords at page 130.
You are not present. What to do, sir?
Now division bench has given me liberty to file.
ಎಲ್ಲಿದೆ division bench order?
Starts at page 119. The relevant portion would be at page 130, para 8. My case is this only, it's para 8. What is extracted at para number 8?
Para 8.
Yes, my lords. Page 130. May I read, my lords?
List on 14.8. Sorry. 1.8.
There's an order in my favor.
1.8.
Without bringing that order to the notice of the revenue authorities, my lords, they had got an order done. In para 9, my lords, liberty is granted. In fact, my lords, now, my lords, the respondent has filed the objection, my lords, is more than the review petition. There are several documents which needs to be brought to the notice of the single judge.
Notice ಮಾಡಿದೀವಾ?
Thereafter, this objection has been.
ಯಾರು ರವೀಂದ್ರ ರೆಡ್ಡಿನಾ? ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವಾಗ ಬರಲ್ಲ. ಲಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಲ್ಲ ನಿಮ್ದು.
This lady, my lords,
ನಿಮ್ದ. Anyway, we'll hear it. List the matter on 22nd August.
Yes.
Or will restore the fire, restore the case and.
My lords may restore the writ petition.
My submission, Lord, I think I am audible.
You're audible. Your other submission nimdu.
I'm sorry. Now, your lordship may kindly bear this order. Your lordship's order was passed only on the basis of order passed by.
Correct, sir. Division bench has passed some order.
Division bench only that writ petition only based upon the civil court proceedings, the order was passed.
Right, we'll see. We'll hear on 22nd. Yes, next.
3.
ಇದು 22nd ಹಾಕಿ ಮೇಡಮ್. Both.
4 also.
3 and 4. Yes. ಎಲ್ಲ ಆಯ್ತಲ್ಲ? ಇನ್ನೂ ಇದೆಯಾ? Yes, in terms of memo.
Please, sought liberty to file a fresh petition.
ಏಕೆ?
ಇದರಲ್ಲಿ ಪ್ರೇಯರ್ ಸರಿಯಾಗಿ ಕೇಳಿ.
In terms of the memo. Yes. ಎಲ್ಲಿ ಅವರು ಬಂದ್ರೆ? That says, are you imposing that says?
No, in fact, my lord, the central power minister, my lord, had said, because from the Haryana model, what they did, my lord, the Gram Panchayats were not paying this electricity bills and all. What they suggested was, you charge the people of the, for example, street light. Because of that, they said, charge the people of the Gram Panchayat area 2% cess. That has nothing to do with this.
ಇಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲೇನ್ ಮಾಡ್ತಾ ಇಲ್ಲ. That has nothing to do with this. That is a policy where the panchayats are not paying. The central minister, power minister, when he came to Karnataka, he said, being from Haryana, we did this, was his statement. And insofar as this is concerned, this is one is tender was awarded in the month of November. The
file notice.
The file notice.
13/5/25. ಏನು file notice?
Your Lordship, can you take this? There are two different files. That is, my lord, one is smart meter market analysis, page 1, 2, and 3. First subject. Second subject is approval for split cost of smart meter and meter box. What is the actual? That this is after the tender, my lords. This is the month of March of February of 2025.
Yes, madam.
Please. Your Lordship, the issue with respect to the guidelines and the regulations. Your Lordships on the last occasion had found that in the guidelines, there are 2 points that your lordship had caught on immediately with respect to their wordings. One said with respect to supply, with respect to installation. The
Yeah, that
lordship
I've
had said installation agbodu, supply beko ilvo.
Oh.
It is left to you. Now, to say that there is some problem with English, probably the language, now to bring that about, in fact, I would say it's absolutely contrary, and I would go on to compliment them that the wordings have been so fabulously drawn that it looks like you have taken it directly out of the regulations, but then some small little twist makes it mandatory. Now, when they started off, they said, all right, we will say that it is not mandatory. You don't have to take it. There ends the matter. But as they have evolved over the period of time with all of these arguments, as of the last argument, it is mandatory. The electricity, the Central Act states so, 163 states so, I have the power. It is mandatory. Now they have to choose whether they want to move with the last occasion's arguments or the arguments that they started with. Either way, if we are to say that, all right, we have to modify, your lordship, I'll have to go back to the regulations. The regulations make it optional. Now, if they have to change it and make it mandatory, then the regulations would have to change. And if that has to change, then again, they will have to call for a public review on the entire issue, your lordship.
That's why all this is fine. Division bench. That's the only problem.
Coming to that, your lordship.
You convince me on that.
Please.
The rest we will
Please.
look into.
I shall just read their affidavit, the reply to their affidavit at page 21, if your lordship may kindly see. The reply to their affidavit at page 21. Given 2 copies, no? 1 second. Huh? Your lordship, it would start at page 11, which is 188, the Bangalore Electricity Supply Company board agenda. Your lordship, the board meeting.
No, division bench.
Yeah, lordship, I'll finish with this and then answer both your lordship's questions. In this, your lordship may kindly see their internal page 196, your lordship.
In the affidavit, is it?
The reply to their affidavit.
Your reply.
Our reply, your lordship.
Today's.
Ivatta.
No, we have given.
Adarda?
No, we have handed over.
Yes. The
The last page, your lordship.
Yes.
That's the internal page 196.
196.
First paragraph itself. Last page, your lordship.
This.
Please. Last but one. We
it's
don't
here,
have
yes.
the last. Your lordship, page 196 of their internal
Yes,
page.
yes.
BESCOM intends to select service provider who would supply smart meters. Cost shall be borne by consumers. And install, commission, maintain the smart meters, communication infrastructure INT systems for the contract duration. Most importantly, brackets. Cost shall be borne by BESCOM and passed on to the consumer during tariff revision.
Yes.
Now this is their admission. This they say ultimately I have to pay. Now what they bear, money doesn't come out of nowhere, as I had explained last time. It comes from their pool, BESCOM pool. And the pool, as I had explained last time, is
tariff revision ಆಗೋವರೆಗೂ BESCOM ಕೊಡ್ತಾರೆ. Revision ಆದ್ಮೇಲೆ consumer pass.
Immediately it's passed on. And here, your lordship, I will again, your lordship, I shall just refresh with respect to the 900 rupees and what they've made some tabular bars with different coloring, claiming that it is Mr. Nawadgi's petition. Now,
Not in your petition.
not in our petition. Nevertheless, in that, with respect to the explanation, 900 rupees, you said, your lordship said that they say 900 is not possible.
Even the electrostatic meter you will not get.
Now, 900 rupees, I will explain if I round it off to 1,000. Central government is giving 1,000 rupees.
They're not taking
1 minute, your lordship. I will explain on both. One is with respect to RDSS scheme. I'm talking about even that 900 rupees in RDSS and those states that do not have RDSS, the pricing that they're talking about. In RDSS, around 1,000 rupees is given by central government. Another about 1,000 plus is put by the ultimately the successful tender, because it's roughly around 2,000 rupees is the smart meter. After he puts in on his own that 1,000 rupees, it is collected from the consumer only by way of Their electricity charges where there would be an increase of say about 60 rupees, which would
That
include
has to go before the KERC.
that. I'm talking about other states, Your Lordship. Here
Other
it's
states.
different.
Other
I'm
states.
talking about the comparative analysis. Now, what happens in that 60 rupees, maintenance, service, cost of meter, everything is inclusive. Now, coming to those places that do not have the RDSS scheme.
Okay. You already.
Those places that do not have the RDSS scheme. Now they seem to give the comparative analysis. In fact, they have not even extracted what is actually in the petition. Now, in that matter, what happens is, Your Lordship, that 5,000 rupees, 8,000 rupees that they're showing, no consumer in any state is paying. Those are all paid in installments by all of them, which again comes to 60 rupees, 70 rupees. Now they are trying to say, here also we're charging you 70 rupees. No, we are paying both. We are paying double the rate of a smart meter at 5,000 rupees, which is not charged anywhere. And the others are paying say 5,000 to 8,000 with only 60 rupees is all everybody is paying, which includes service and maintenance. Whereas here it is divided into two. One is I have to purchase the meter at double the rate. And two, I am compelled to pay maintenance charges for 10-year period where they get about 9,000 rupees. So it's 5,000 plus 9,000 for a single phase meter. And 9,000 plus 15,000 for a three-phase meter.
9,000 plus 15,000?
Yes.
24,000?
That is the exact. But this is, so this chart that they seem to send, it only extracts what's the amount in the other states. It doesn't say, do they pay lump sum? Do they pay it in installments? Do they pay separately for maintenance or service? That is not covered very smartly again, Your Lordship. Maintenance, everything is included.
Smartly left off.
Smartly left out.
All right.
Your Lordship, I was to the judgments, Your Lordship, which I had.
Smartly locus is not told.
Exactly what I'm coming to now.
Tell me, that's most important.
Please, the
Yes.
judgments, Your Lordship.
Judgments on locus. Memo of citations. Paragraph ಹಾಕಿದ್ದೀರಾ ಇದರಲ್ಲಿ?
Please.
Yes.
Your Lordship, from 2 to 6, all of these are with regulations and guidelines not in conformity, all of that, Your Lordship. I have anyway mentioned the paragraph, so I shall not read those. Which one I start now? Your Lordship, the serial number 10. Shivaji Rao, Your Lordship, at page 314.
314.
To serial number 9, I have left out. This is Dixit. I have to read his. Huh?
Yes.
Please, page 333 is the relevant portion. 36 paragraph, Your Lordship.
Yes.
The allegations made in the petition disclose a lamentable state of affairs in one of the premier universities of India. Petitioner might have moved in his private interest, but inquiry into the conduct of the examiners of Bombay University in one of the highest medical degrees was a matter of public interest. Such state of affairs have been brought to the notice of the court. It was the duty of the court. Your Lordship has
I'm
it,
there.
please. It is the duty of the court to the public that the truth and the validity of the allegations may be inquired into. It was in furtherance of public interest that an inquiry into the state of affairs of public institution became necessary, and private litigation, next line, private litigation assumes the character of public interest litigation, and such an inquiry cannot be avoided if it is necessary and essential for the administration of justice.
Yes.
And Your Lordship, this, in fact, this judgment, Your Lordship had mentioned the Calcutta.
Calgas.
Please, that roughly covers also what I have brought out in Shivaji Rao, Your Lordship. The next one, Your Lordship, is page 342, relevant portion at 370 and 371.
What is my judgment here?
Please.
Oh, this. What is this?
That paragraph 19, Your Lordship. In such glaring facts, what is involved is inaction of the board, a state under Article 12,
I
qua
think
the
this is
property.
reversed by division bench.
No, no, no. No, Your Lordship, they didn't approach. I checked that, Your Lordship.
Enagilva.
Please. And question of locus standi of the person who brings before the Constitutional Court, such illegality gets blurred. This is the key word, blurred, as the issue that is brought before the court must over the issue of locus. I shall read this other.
I am told it was reversed.
Not reversed,
No.
modified to a certain extent, to a certain observation, that's all.
It is not modified.
All right.
Your Lordship, I had passed on the last occasion, the division bench. This has attained finality. This matter I had just passed on separately. I'm sorry.
Yeah, that against this order.
No, no, this is against a single bench order, which went on further on the. Internal page 10. Page 10.
Point number 3 was set aside, Madam. That petitioner shall be given an opportunity.
Well, that's much matter.
Please, Your Lordship, please.
Yes.
Internal page 10. Para D.
This I'm aware.
Last portion. An argument to the contrary would do a lot of disservice to public interest in as much as no person other than a rival claimant can challenge the grant, and therefore even the grants that are otherwise unsustainable would go with impunity if the rival claimant takes refuge in silence. Writ courts, in a sense, being the custodians of public properties, cannot turn a Nelson's eye to the apparent illegalities with which the grant of public property is fraught with. This idea, of course, in a different terminology, has animated the view of the learned single judge that the writ petitioners do have locus and locum. There is no reason to upset such a finding. Please. Now, Your Lordship, one might say that I have only asked what is the difference between both the tariffs, and I have not asked for a new tender. Reason being, I'm unable to even afford that. So I asked, and then they specifically respond stating, is it mandatory or not? How they respond is according to the guidelines number so and so, because the guidelines have made it mandatory, and therefore I'm aggrieved. Now we have two other petitioners. One petitioner is before Your Lordship in this matter. All of these people, one of course has taken a smart meter. I have asked for these details and come before Your Lordship because I am aggrieved. Now also with respect to my locus, if I have not taken a smart meter, as I've already shown Your Lordship, all of us would have to bear the brunt of it, irrespective of whether we take a smart meter or not. To close, Your Lordship always has a particular term for any matter. Oh, this is the fishing matter. Oh, this is that matter. So in the words of my senior, he used to always have a favorite line, and that seems to be very apt for this matter. Rob Peter to make meter. And this is absolutely relevant in this case. If this had to have a title, it would be Rob Peter to make meter.
Yes.
Smartly
close them. Yes, Prabhu sir, fast.
I am the last man and the night watchman. I will not take much time. Much arguments have been advanced by both sides. Just one or two small points what I propose to make. Number one is about locus standi. But insofar as the petitioner is concerned, but that question may not arise at all.
I don't think we should too much labor on locus.
Yes. I just want to
I will answer locus, not a problem.
No, I'll come factually.
The only thing is division bench it is pending.
In order to overcome that only, I'm bringing.
The only question I'm asking is division bench identical matter is pending.
Insofar as the petitioner is concerned, to whom I represent a lot, it is not pending.
Have you seen Manipur and Sikkim? They are beautiful places.
No, I want to say something. I want to say something that this petition of ours, which is this Jayalakshmi petition, is a matter nothing to do with the public interest litigation at all, is what I want to support. This is a matter where she files an application seeking for installation or conversion from a single phase to three phase. Now that is rejected, saying that you have to opt for smart meter. And that is called into question before Your Lordship. Now, kindly imagine a situation if I had to go before the division bench by
that was the trigger point of everything. They should not have told that.
No. Therefore, my lords, I cannot maintain a public interest litigation. All that I am bringing to lordship's notice.
No, I'm not on that. You can't maintain a public interest litigation. Qua you or qua the second petition, we will answer. About the locus, yes, we will answer.
No,
I'm aware, but as
the
I
problem-
told you, the only thing that is holding my hand is the division bench. That's
No, the pendency of the division. No, what I am trying to say. Kindly look at this situation. Here is a consumer who is before your lordship. I'm just only. Now, merely because there is some rival tenderers are agitating before the court, before another court, about the price of the meters. I cannot suffer. Is what I am doing. Ultimately, last time also I said the whole electricity sector is consumer centric.
Watch it insofar as you are concerned. Don't install smart meter.
Yes, and then the second issue about the pricing comes across. Which is
if
also,
you are not installing smart meter, why pricing?
Lordships are saying day one onwards. No, I will. Ultimately, it is a very simplistic way. Obviously, after the respondents exorbitantly charging the consumers this and saying that I will pay you money or I will ensure that you don't, but please do not expose my misdeeds. They can't say that. They can't afford to say that. Learned advocate general is there. That contractors lawyers is there. They must answer the question which has been raised. They can't get away by saying we will ensure that the petitioner's grievance is satisfied. So therefore,
they've answered all the queries of madam.
Lordships must kindly consider this. Therefore, I have yes. But two things, just two things. From day one, our argument has been that making it compulsory is not is prohibited under the KERC regulations, which has been repeated.
Yes,
which has been repeated before your lordships on number of. I'm sorry.
Installations ge smart meter ಮಾಡಲೇಬೇಕು ಅಂತ ಹೇಳಿ.
Yes, ma'am. Yes, ma'am. No. This is not that KERC regulations do say that insofar as the temporary installations are concerned, it is made compulsory. Insofar as permanent installations are concerned, it is optional. That is what has been. We have read the KERC regulations. Number one. Of course, it is sought to be interpreted in a different manner, and a plain reading of the regulations would indicate that it is made optional. That is one submission. Secondly, as regard pricing is concerned, it's a complex issue, I must, in all fairness, say. But the tabular column which we had brought before your lordships did not say. I did not say it is costing 900 rupees. Ultimately, for the consumer, it costs 900 rupees. So that is something my lords may kindly take note by gaining subsidy.
Yes. Ashtena?
One point. There is one note we have circulated. One note we have circulated. I'll place it on record.
That's better. Give it.
Yeah, yes, we have one submission I just want to make. I'm instructed to submit before your lordships that in that note Mr. Holla gave the other day.
Yes, sir.
But what was brought to lordships notice was that note records the quotation or the price of those 4 companies.
Yes.
In that my note which is now passed on to your lordships, that lordships will get it at page number.
Page 6.
Yes, page 6. That is the note of Mr. Page 6.
Market value rate analysis.
Yes, with Genus, HPL, Linkwell, and Schindler. Now, what is very interesting to note is these are not third-party persons from whom they wanted to discover the market rate. These are the persons who ultimately supplied the smart meters.
Correct.
Therefore, they could not have.
They are the manufacturers of these smart meters.
Therefore, they could not have given an objective or impartial price. Now, what was the endeavor which was being made before your lordships is, look at this, we got the price quotation from these 3 people, then we added up. Obviously, they were going to quote high. I'll also
these are manufacturer's price.
Manufacturer's price.
What you say is right. You can't draw parallel with this and the other states' prices.
Yes, and secondly, my lords, when you the way it was put across was we try to do the price discovery through calling prices from the manufacturers to see what is the benchmark to be fixed, etc. But I am told, my lords, and we have produced now, normally GEM, that is the GEM portal of the Government of India is there. they always go to jump portal and see what is the price. I have produced the jump portal extract before your lordships.
2,710.
That is 2,710, page 31. Now, this is what had to be done, but this is completely, it lacks any kind of transparency, completely, my lords, done in a manner in order to favor a few groups and enhance this. But kindly look at, there nothing prevented them from to go to the jump portal.
Why is the consumer saying this?
But obviously, my lord, ultimately, my lords,
obviously to favor some groups and other things.
No, my lord, ultimately, my lord, I am the one, my lord, I will close by, ultimately, my lord, very interesting, my lordships are aware.
Product details ನೋಡಿ, page 29 ಅಲ್ಲಿ.
ಇವಾಗ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಹೌದು, 2,710 ಅಂತಲ್ಲ, page
ಹೌದು.
29. ಹೌದು. ನೋಡಿದ್ರೆ price for one piece, MRP is 15,000, offer price.
ಏನಿದು ಇಷ್ಟು ಕಮ್ಮಿ?
Offer price ಯಾರೋ ಡಿಸ್ಕೌಂಟ್ ಕೊಡ್ತಾರೆ.
This ಅವರು ನೋಡೋದಿಲ್ಲ. See, please, they cannot go on justifying here, my lord. The principle what I am saying.
And then they said 2,700. I can't justify it, is it?
All right. Yes.
The principle, no, the principle is not price. The principle is how do you do price discovery? That is through going to an impartial Government of India jump portal. You don't go and ask the persons who are going to supply to you. They will obviously hike up the prices. That is one aspect. But about these are my submissions, Murad. Just one more. Everything is covered.
You also have a. Have you filed a note? Argument notice. You have already filed. Hey, Akilba. Written Allah. This kind of a thing you have not filed?
We'll
Then
give a
do it by the next 2 days.
Please.
Lords,
highly educated consumers we have, man.
No. Lords, one statement I want to make, Lord. Lordships asked about consumer. I'm reminded of that very famous judgment, Lords. 1951, Bombay, Lord, prohibition was imposed. But the petition was filed by one FN Balsara versus State of Punjab. Very famous Palkewala argued. Now, what was his locus standi? He had a vodka bottle with him and a half whiskey bottle. He said, "I am unable to drink because of this prohibition. Therefore, I am aggrieved."
Then
he had locus, absolute locus.
He had locus. Therefore,
I'll carry a bulb.
If I am a consumer of electricity, you can't go to the. But that famous 1951, if Mr. AG's or Panindra's documents were accepted.
In place of those two things, you are holding one electrostatic meter and smart meter.
No, if their arguments were accepted, that famous
I am not on locus, sir. Locus, I will answer. I am not on locus at all.
I'm just bringing to lordship. No, it is linked to this division bench.
All these documents at 29 to 34, those prices which.
The only problem is division bench.
Also, these prices which they have quoted in this present memo which my learned friend passed. Everything is with discount of 85%, 65%, 40%.
Yaar ashton discount kodadu?
We don't know, my lord. Somebody puts like this. Somebody has given some 40 meters.
Allah, yaradru meter ge 15,000 anta hakbittu 85% discount kodtara.
The difference is
they must have given only 15% of the meter, man.
The cost of the meter is only 15%.
Maybe photo kodtara ashte meter du.
No. Senior is saying it's from the jump portal. Then it's Government of India portal.
But whatever it is, and another issue is, my lords, if he is going to buy from a OEM, that's a manufacturer will sell it to you in his shop. You have to then.
That is true.
You have to
install. You are buying in bulk, so you are giving in.
All that is being given.
Giving with so-called rebate prices.
I'm grateful for the patient hearing. I'm grateful for the patient.
There's also
my learned friend pointed out about the two files. Your lordship said that
I will answer.
20-25 signatures ಇದೆ ಅಂತ. That is for
breakup.
That is for breakup figures. That's all. Nothing to do with the
Lordship, if they could comply with the earlier order wherein the entire file is submitted.
File ಯಾಕೆ ಇಟ್ಕೊಟ್ಟಿಲ್ಲ?
I'll just point whichever file will. So what has been challenged is the guideline, internal guideline. Whatever files, if they say which file will be submitted.
So which file?
Suddenly one office note surfaces like that, maybe they
records that went into this
tendering,
tendering document.
No, but what I don't know what is required. Will place it because.
So you will give
whatever document.
Those records which goes into price discovery.
For the perusal of the court, you produce the records that went into the pricing policy.
Please.
I'll give it, that is clear.
Only the pricing policy.
I'll do that. Malad.
Locus, I will answer.
Prices.
Again,
Your Lordship, judgment support us. Your Lordship also,
Say,
Your
Manipur,
Lordship, there's a
Sikkim, Manipur,
PCR.
Sikkim ಎಲ್ಲ beautiful places. But vacation go ಚೆನ್ನಾಗಿರುತ್ತೆ.
Your Lordship, no such thing, Your Lordship. Your Lordship, PCR has been filed. PCR has been filed in the same aspect.
PCR.
Tomorrow orders are going to be passed. PCR has been filed by 3 MLAs, sitting MLAs on the same issue.
Against whom?
On the chairman, who's also the energy minister.
Against whom PCRs are filed?
By 3 MLAs.
Is that
The
relevant?
complainants.
That's all. Right.
On the very same issue, I am just bringing it to your Lordship's notice, that's all.
Making me all the more difficult.
No, in fact,
That is
the
why
pres-
locus is important.
So that is on the aspect of one particular person on personal
No,
gain.
that means, Malad, show
So-
that they're not interested in consumer, they're doing interested in politics here. They're doing strictly politics. Somebody is politically motivated, Malad. Otherwise, look like it, Malad. My
Looks
learned
like
friend
it.
knows.
Yes,
I mean,
yes, absolutely,
they filed a
absolutely.
petition. I mean, this is
As
quite
a con-
surprising.
Whatever
Malad.
they think.
As
it
a
is-
consumer, I will only know bill kattidina, current idya, manage, current
Therefore, who is before?
chairman mele yav
Trying to
case
split the
hakidare?
three. Who is before your Lordship? The consumer. Who's before in the public interest litigation? The public at
consumer.
large. All
Is
of
the
them put
consumer, is
together
it?
in the interest of the state.
One more thing. Who is the petitioner before the?
There are
division
4
bench?
different petitioners over there, your Lordship.
And
All consumers or what?
And what is
Of
in-
course, consumers. Yes.
I'm sorry
And-
for repeating,
and-
my lords. The consumer here and there, identical paragraph is copied and pasted. That means, my lords, somebody is driving this litigation as well as that litigation.
Nobody is driving. Unfortunately,
And
Mr.
that's
Akash
the-
filed a PIL, which was reported in the newspapers. Therefore, we had individuals coming. In fact, we would have had a flood of them. But every single BESCOM official goes to every single area and deters anybody from raising this issue. Even the
But I
petitioners
think
were
now we are
threatened.
going
If they want to bring it up, I will bring this up. If an affidavit is required to be filed, I'll file it. They were threatened and asked to withdraw. When threats didn't work, amounts were offered. All of this is transpired.
Who is she
So
appealing
let
for,
them
Madam?
not get there, because then I will ask them to file an affidavit
Let
to
them
that
file an
effect.
affidavit.
No
Who
problem.
is she appealing?
Don't enlarge the scope of this.
Well,
petition.
whom is my learned friend
That's
appearing
the
for?
point
Malad?
is your lordship's proceedings go live.
Yes.
And this is what, without pleading, somebody goes on say, let's settle principle. You have something, first plead it. Don't throw things across.
Everything has been pleaded.
Well,
If they
this
make some
pleaded.
statements, then I will have to
PCR,
respond. Then I
threaten, bribe.
think what they
As
need
a
to do
lordship
is
said, Madam,
contain themselves and stop.
I'll stop. Yes.
Please, wait.
Yes, sir. ಹಾ ಏನು ಹೇಳ್ಬೇಕಾ? Why did you come running? ಪೂರ್ತಿ ಅಡ್ಡ ಬಂದ್ರು ಅಂತೆಲ್ಲ ಹೋಯ್ತಾ?